My lord, I will pardon.
Yes, sir. Yes, madam. Kindly wait, we'll go page wise.
Supplemental list, page 1,
Have no question.
2 and 3.
आप तो कोर्ट केबे को आनिबे सर केबे आनिबे सर कोई मैटर आफ्टर नोटिस फ्रेश कौन सर
फ्रेश up to notice fresh stay मागिছে কালি ঠিক আছে
କରି परिबे कली कोई मत सर
এই মাসে
26
18 তারিখ ফাইল
Page 1, 2 and 3. Page 2, 4 to 9.
My lord, page 4, item 20. Yesterday I was directed to.
Sir, just 4 to 9 sir 4 to 9 sir just give me a second sir. Then 10 to 16 10 to 16 sir. 17 to 20 sir
20 ka.
yes I remember sir that is how it has been listed. Though we are at a different place, he was there, so it will be. I hope it will reach. Only one matter, Mr. Mohanty's matter, that is to be taken up after the mentioning. So your matter will be taken up. No difficulty.
After that, my lord, after that, I have to go to Bhadrak. For that I am telling.
Mr. Mohanty, he has orders matter. So we can. Yesterday there was this because handing over the document was not possible. Yes. 17 to 21, then 20 to 23. 24, just 1 second. 24 to 29.
29.
Yes, what do you want, sir?
It should be taken up today. I say
Hey, taken up
because that
How-
last
No,
time
after-
I have said that he is suffering from
last
cancer. He is suffering from cancer for that only.
suffering from cancer is there's no exception in High Court rules.
Because that is 2017.
And
he
you must understand choosing among cancer patients is still difficult. You never know how many persons are suffering from cancer who are before this court. And I will find out your case because the person is suffering from cancer. That cannot be, you have to be patient with that.
There are 5 times 2021 they are asking
5
the
times
time.
or 50 times your matter is in the list. Other matters have been adjourned 10 times. So if I apply this logic that 5 times adjournment, immediate taking
No,
up.
21. See, I filed is 2021 this matter is there.
Sir,
And they are asking for time only to file the
I am
matter.
taking of matters which are as old as me. One matter once. So 21 is not old for this court. Please appreciate that. Out of turn, taking up of the hearing of the matter, I cannot allow. You must understand. Out of turn hearing, how can it? Case specific, lawyer specific,
No, I am
and
not.
disease specific.
Means only
You
asking
know,
that they are asking the time
By,
without filing
there
any
are
counter.
much
For that
more
only I am saying
cases.
any order your lordship pass order. I am
Why
not
should
saying-
I? Why should I take up out of turn and pass any order? Why should I accept your submission at all? That I will take up your matter out of turn ahead of others? And in
I
competence,
am- For that I am saying that if possible.
sir, no, sir, definitely, sir. Definitely. That I can assure you. If it reaches, it will be taken up. I'm continuing with the bench. And I also see the response when I start hearing of the matter. Even after hearing for 1 hour, it is adjourned. So you have to be counter upon the आपनकर counter file है counter 29 ने दिया है
Prabhu is there. Prabhu
प्रभु को स्मरण करा प्रभु आसंतु
Malot, I'm there, Malot.
से counter देनांती बोली से कहउचंती
Yes, Malot, as last occasion, the last week, I have pursued it. They are
counter has become a cancer for the case now. The
Malot,
petitioner is suffering from cancer. The case is suffering from lack of counter.
Malot, I have pursued this matter. This week will anyway file the counter or the instruction. Malot. I have communicated the officers and they have also assured me that
Because
today they are
several
coming
times it has been urgent for filing of
Yes.
counter.
Yes, Malot. After 22, it has never been listed. But before once it has come before your lordship's board, I have.
That is a $1 million question.
Malot, I have taken the responsibility. I'll file it.
I know that it was never listed, but suddenly it becomes important.
Malot, I will file it this week anyway. I have.
And never state the disease of others. You must remember that shloka that your penury ମାନେ ଦାରିଦ୍ର୍ୟ ଆଉ ରୋଗ ବିଷୟରେ ବାହାରେ publicly discuss କରନ୍ତୁ ନାହିଁ. As you know, I mean, so many people are suffering from so many diseases.
That is part.
And
I should have some accountability that I have taken a case and I will nothing.
no, you are not
I am able to
accountable.
do anything.
That is the problem. You are identifying the case with you. Never do that. Never do that. Because indirectly what Mr. Prabhu has said, you understood. It was never listed after 2022.
Oh, man. In spite of
Sorry, after 22 it has never listed. Now it has come on board after 4 years. That is your responsibility. Anyway, he's pursuing and he'll file the count. I'll pass that order now or when it reaches.
If it will reach the time it will.
Okay.
If any instruction will come.
No, I will not hear without pleadings. Mr. Patra, I have sufficient matters where pleadings are complete. I have to hear them. So I will take up your matter out of turn without pleadings. Or even if it reaches, I will take up, because then what about the next matter where pleadings are available?
You Lordship pass the order if it will.
No difficult.
Now Lordship
No,
pass the order.
you leave that part to me. Orders you are not passing. So I will pass the orders. Don't worry. You have to change your approach also. You are identifying yourself with the case. Second, you are not taking steps for listing of the matter.
No.
When the matter reaches, I will find out how many mention memos are there.
Memo also I filed.
Yes, I will find out. That I will record. And by not listing the matter, definitely gets sold. Item 30 to 34, 35, 38, 39 to 44, 36, sir.
Reading the complete record, minute range my habit. Item 36 one.
Let us see if it you inform your other side, because you are for the opposite party. The petitioner, you inform the petitioner if you want adjournment, ask the petitioner. Okay.
My lord, item 40.
40.
I have already informed that petitioner. It will be taken up after vacation. Item
40 the date kar diyo. Your name, sir?
BP Varada Prasad Patnaik, BP Patnaik.
Power ଅଛି ଠିକ ଅଛି.
I
40 ଟା posting କରନ୍ତୁ after notice.
Pardon, my lord. Satish sir.
27. Yes, Satish.
My lord, item number 42. My lord, humbly seek for an adjournment, my lord.
Other side appear କରୁନାହାନ୍ତି. They are not sufficient. Okay, 42 urgent କରିଦିଅ.
IA to be continued.
ଆଜ୍ଞା
With counsel Satish sir.
Interim.
କଣ ଥିଲା adjournment order ଥିଲା?
Yes, my lord.
The matter being in the list for here for under the heading for admission is mentioned by the learned counsel. The liquid Dakshik Darshan Naik for the petitioner. D.D. Naik NAIK for the petition. Opposite party blank. The matter being in the list under the heading for admission. Are you going to AC chalu nahi ki? The temperature high. Mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. The seeking adjournment. The office note indicates neither AD nor undelivered notice is yet is received back. Indicating service on the sole opposite party. Awaiting appearance of the opposite party. The matter shall be listed in the week commencing for admission in the week commencing.
Satish sir.
Satish Satir. 45 ରୁ 51.
Item number 45 may be pardoned to
Just
my-
one second. Your colleague is 14. Inform the petitioner.
Your Lordship, I have already informed.
Mr. Prusti has been informed. 49 posting got you.
Prayer is to the opportunity for the father as DW2 to adduce the evidence. Your Lordship, that part will be allowed.
No, not hearing. You have Mr. Porky will be Akash. He was doing the same thing that take my matter and pass orders. No out of turn. 26 is in the queue. He is 21. Please appreciate that.
Yes, sir.
Then whenever both of you agree for any kind of order, then both of you should remain present and mention. No difficulty. I have been doing that. If he comes,
Yes, Your Lordship.
please mention that.
Yes.
After Pokala and fish fry, we will continue or not? Yes, Mr. Tripathi?
Continue.
You will be able to continue. The great thing. I have no difficulty. So, 2:30 na 3ଟା ବେଳେ ସରିବ କେତେବେଳେ? Actually, ସେ ଲମ୍ବା ଟିକେ ଭିଡ଼ ବି ହେଇଯାଏ। 3ଟା ହେଇଯିବ, ନାଇଁ କି? ଠିକ ଅଛି। ଆଜ୍ଞା? ତ मेरा These matters are listed for other purpose. This matter having been hard for 2 years, pending since 4 years. So these are listed for a purpose.
Senior.
Senior, junior, etre nahi. There is senior, junior, etre judge achante. I even remember the land acquisition case number, date. ଆପଣଙ୍କର ଏଇ ମ୍ୟାଟର ଗୁଡାକ ଏଠି ପେଣ୍ଡିଂ ଯୋଉ ରହୁଛି ତାପରେ ଆପଣ ମାନେ why it is pending that is being asked. ଭିତରେ ଆପଣଙ୍କ ଆଡଭର୍ସ ଅର୍ଡର କିଛି ହବନି ତା ବି ଆପଣ ଜାଣିବା ଦରକାର। ଆପଣ another 10 years 2016 ଯୋଉ 11 ମାନେ 15 ମସିହାରେ 11 ବର୍ଷ these are batch 2015 matter land acquisition appeal was recently disposed of. Around 2 years back another batch was disposed of. Must understand that.
Your Lordship, senior is not well.
Sir, wellness of the ଦେହ ଭଲ ହେଇଯିବ ପରେ this will work as a
Item 50 years.
50
50.
ତ ଆପଣ ଅଛନ୍ତି ବୋଲି ଆପଣ ପଳେଇଲେ
After the
ଆପଣ ପଖାଳ ପରେ ରହିବେ ତ
state government moved to the appeals court passed the order on 16/4/2020 rejecting their
SLP.
yes. Then the
57 ପଢିଲା ବେଳେ ସେ ତମ ପଚାରିବା sorry, I'm sorry, 50. I'm so sorry. 50 Mr. Lenka, Mr. Mahanti, SLP dismiss ହେଇଗଲା କହୁଛନ୍ତି ଦେଖନ୍ତୁ
I
45 Mr.
may be pardon, my lords. 45. My lord, notice has been sufficient, but as per the office note, it indicates that none has appeared in.
The notice not sufficient. ଆପଣ ତ ପଢିବେନି ଆଉ
My lords, AD return.
AD is not evidence. ତାହେଲେ କାହିଁ ଲେଖା ହେଲା? What is the significance? Neither AD nor undelivered notice as against Solupi yet returned.
My lords, so your lordship may
The
keep.
rule.
My lords, so your lordship.
And AD return of AD answers nothing, creates more questions.
My lord, so your lordship may just.
They say that because ଆପଣଙ୍କର why on AD because AD bears the signature, undelivered notice bears the signature.
My lords. So your lordship may keep
It
it.
has already been tested. There is a division bench judgment by Honorable Justice Sinha and me. Because we tried to actually work on this. We accepted your contention, then asked the postal authority that you give report. They say we cannot say. Because the delivery receipt is at the delivery point, not at the issuing point. And who received that they cannot say.
My lords.
There are a lot of technicalities here.
My lords. So your lordship may keep this matter.
45 re same order as
42 probably, my lords.
42 ବୋଧେ ଆପଣ କେତେ mention କଲେ? ଗୋଟେ mention କରିଥିଲେ 42. 42 ରେ same as 45 same as 40. But ଆପଣ 42 ପଢୁନାହାନ୍ତି ଜାଣିଥିଲେ ପଢୁନାହାନ୍ତି ଆଜ ନେଇଛି ତ ମୁଁ କୋଉ ପାଇଁ ପଢୁଛି same exact same order 45 Devi Datta Mahapatra's petition
Interim order to continue, my lords.
42 ରେ interim order ଥିଲା କି
42 ରେ ବି ସେମାନେ mention.
I'm sorry, I have not dictated the order.
My lords.
42 ରେ ଲେଖନ୍ତୁ update କରନ୍ତୁ. The learned counsel for the petitioner seeks continuance of the interim order dated 9/2/2026. Stop. Accordingly, it is directed the MAT case number 42. MAT case number 18/2024 pending before the learned civil judge senior division Kodola shall be adjourned and a prayer being made for the said purpose to a date as would be convenient to the learned court in session of the matter. Beyond कितनी तारीख अपन date adjournment 27 हेले beyond 31 नहीं 31 सॉरी 31 पर हो ना 3 8 बियॉन्ड 3 8 20 24 मतलब बियॉन्ड 27 7 कर दे बियॉन्ड 27 7 45 पे डेट कर 27 7 27 से आइडेंटिकल कितने दे तो जो दी तक डीडी ना कितने डी महापात्र
Great for it.
It came, another matter is pending between the parties. WPC number.
इसी चालू नहीं पढ़ा था So item 4, Amitabh Tripathi for the petitioner. The matter being listed for fresh admission is mentioned by the Learned Counsel for the petitioner. Seeking adjournment. He submitted that WPC number
21338
21338
of 2025.
2025 is also filed by who?
By the wife.
Filed by the party wife is pending. Now, the present application revision was heard at some length on 23/4/26. The facts as well as the propositions of law were noted. But to grant further opportunity to the petitioner, the matter shall be listed along with so and so for fresh admission in the week commencing 29
Not item 5.
5.
My lord, I have applied the certificate copy but not yet received my lord. The entire amount I have paid in local Adalat.
Mr. Saubhagya Kumar Das for the petitioner. The matter having been listed for fresh admission is mentioned by the Learned Counsel for the petitioner at the beginning of the day's proceeding, seeking adjournment. He refers to the order dated 12/3/2026. As well as 6/4/2026 and submits that the petitioner has already deposited the amount of arrear towards monthly maintenance as directed by the Learned Judge Family Court in order dated 18/10/2025 by order dated 18/10/2025 in CR.P. number Sandesh of 2024. Start. He submitted that said deposit has been recorded by the order of the court, Learned Judge Family Court. Rautala. And he's looked at intellectual property. It is submitted, so further time may be granted to obtain copy of the order indicating deposit of the amount. Stop. Accordingly, the matter shall be listed for fresh admission in the week commencing on 3/6/2024. Yes, text.
Item 1.
One put you, sir,
20 ta.
wait, 20 direction. 20 electron.
Item 20.
I have already replied and he had taken the amount of 5,20,000. What
The matter being in the Mr. Narayan Prasad Parija for the petitioner. The matter being listed for orders is mentioned by the Learned Counsel for the petitioner at the beginning of the day's proceeding. He produces copy of the order dated 31/3/2026 as well as 8/5/2026. Passed by the Learned Senior Civil Judge Kamakhya Nagar.
My lord.
The said orders are enclosed to a memo, which also encloses banker's check dated dash amount dash favoring so and so. है ना? तेरे एग्जीक्यूशन लॉन्च हो जाइए
ଆଜ୍ଞା
नंबर
ନମ୍ବର ହଉଛି 101/25 ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ 101/25 ଫ୍ୟାମିଲି ଜଜ୍ ଢେଙ୍କାନାଳ
the memo along with the enclosure shall be taken on record. The order dated 31/3 and 8/5 are reproduced here. Passed by the so and so in so and so. Let us C.S. into bracket mat 27/2018. Paraf. The Lauded Council refers to the order dated 28/2026, wherein sixth extension of the interim order passed in IA number 4402025. By the said order, this court had directed thus: para 8 reproduce kar de, para 7 and 8, and observe thus. Accordingly, it is directed the amount of rupees 25,000, which is stated to is being deducted from the salary of the petitioner, shall not be deducted for the months of
ଏଇଟା ହଉଛି ଜୁନ୍
June. March पर जो stay ହେଇଥିଲା February March ରେ deduction ହେଇନି
ହେଇଛି ନା
ହେଇଗଲା
ହଁ ଟଙ୍କାଟା କଟି ଯାଇଛି
ଆପଣ produce କଲେନି କି
ଏଇଟା ପୁରା 31/3 ରେ ଦେଲି
ଆଜ୍ଞା
31 ତାପରେ ଦେଇପାରିନଥିଲି
ଓହ ଆଚ୍ଛା ସରି ଆପଣ ଦେଲେ 31/3 ରେ ସେଥିପାଇଁ ସେଟା
ଆଜ୍ଞା
shall not be deducted for the ମାନେ ଏପ୍ରିଲ ରେ ବି କଟିଗଲା May masar for the shall not be deducted for the month of May when the salary will be received in June, and for the month of June when the salary will be received in July. The matter shall be listed in the week commencing on orders in the week commencing on 30/6/2026.
ଏକ୍ଜିକ୍ୟୁସନ କେସଟା
ଏବେ stay ହବନି ଆପଣଙ୍କର ସେମ୍ ଏଫେକ୍ଟ ଆପଣଙ୍କ ଡିଡକ୍ସନ ବନ୍ଦ କରି ଦିଆଗଲା ସେ appear କରିବେ
କରିବନି ନୋଟିସ ପାଇ
ଆପଣ କଣ ଡରେଇ ଦେଲେ କି
ନାଇଁ ନୋଟିସ ପାଇ ଆଇଲାନି ସେ କଣ ପଇସା ତ ପାଇଗଲି ଯିବି କାହିଁକି
ଓକିଲ କେମିତି କଣ କରିବେ ରିପୋର୍ଟ ଉଭୟ ପକ୍ଷେ appear କରିବା କଥା ନା ଆଉ some of your juniors should appear also on 30/6 এটা ଆସିବ 29/6 so ଜୁନ ମାସ ଜୁଲାଇ ଇନଫ୍ୟାକ୍ଟ ଜୁଲାଇ ମାସ ପର୍ଯ୍ୟନ୍ତ এটা ଆପଣଙ୍କର ଡିଡକ୍ସନ ହବ ଗୋଟେ ଲାଇନ୍ ଆଡ୍ କରିବେ it is submitted by Mr. Farida that since the amount was deposited ଆପଣ 31 deposit 31/3 ରେ so it was deposited in 31/3/2026
and she has taken
which was conditional which was made conditional for grant of the interim order by order dated 28/2026. The amount of 25,000 has been deducted from the salary of the petitioner for the month of February, March, April. Line ta khali add upare yes. এটা হিয়ারিং কলে কোন জলদি সরজিও বলে আশা করি করা হইছে নহলে হিয়ারিং ম্যাটার তো প্রথম রখিয়া কথা নো नहीं सार करो सो महांती आपके महांती टीपी महांती
आइटम 2 रे
आपण 2 रे नहीं वन टा रहिछि एक्चुअली आगो आपण 2 रे कोन चाहौ सर नोटिस जीवो
नोटिस तो हबो इनफैक्ट तदरे आईए ता लिस्ट रे आसीनी देयर इज एन आईए इट्स अ चैलेंजिंग मेंटेनेंस ऑर्डर
एंटर अमाउंट न देले मु इंटरफियर करूनी एरियर अमाउंट आपण डिपोजिट करले Or it's a special case like Mr. Parija when there is a permanent alimony.
Permanent alimony 22 ଲକ୍ଷ ନେଇ ସାରିଲା ପରେ ପୁଣି maintenance
125 ତ
125
125 ତ ସୁପ୍ରିମ କୋର୍ଟ ସେଟା କହିଲେ ଆଉ
କହିଲି ଯେ କିନ୍ତୁ there must be some maintenance of equity 22 ଲକ୍ଷ ଟଙ୍କା ସେ ନେଇଛନ୍ତି
ଇକ୍ୱିଟି ସାର୍ ସେଟା ତ ଆର୍ଗୁମେଣ୍ଟ ଆପଣ ସୁପ୍ରିମ କୋର୍ଟ ରିଭ୍ୟୁ ଫାଇଲ କରିବାକୁ ପଡିବ କ୍ୟୁରେଟିଭ ପିଟିସନ ଇଟ୍ ହାଜ ବିନ୍ ଇଲାବୋରେଟଲି ଡେଲ୍ଟ ୱିଥ୍ ବାଇ ଦ ସୁପ୍ରିମ କୋର୍ଟ
ତ ନୋଟିସ ହଉ
ହଁ ଠିକ ଅଛି ନୋଟିସ ହଉ
ଆଇଏ ରେ ବି ନୋଟିସ ହଉ immediately ଛୁଟି ପରକୁ ଆସୁ
ଆଇ ତ ଆସିନି
ଆସିନି କିନ୍ତୁ ଏଟା that is on board ଅଛି ଏଥିରେ ଅଛି ବୋର୍ଡ ରେ ଅଛି ଆଇଏ ନମ୍ବର
ନାଇଁ ଦେଖୁନି
290 of 2023
ଆଇଟମ 2 ତ
item 2
ଇଟ୍ ଇଜ ନଟ୍ ଶୋଇଂ ଏନି ଆଇ
ବୋର୍ଡ ରେ ଅଛି ଲିଷ୍ଟ ରେ କେମିତି ମିସ୍ କରିଛି
ଆପଣ କେବେ ଫାଇଲ କଲେ
ଆଇ along with the paper ଆଇଏ ନମ୍ବର
ତାହେଲେ ଫିଜିକାଲ କପିଟା କାଣ ଫିଜିକାଲ କପି ବାହାର କରନ୍ତୁ So Dwarika Prasad Mahanti for the petitioner. What कोटी deposit evidence कोटी देखे चल permanent alimony 22 लाख टंकार evidence. How do you substantiate that?
I can file that receipt
कोड़ा
এটা এইଥିରେ
page
ନା ଏଇଟା exhibit ହେଇନି ତାଦେହରେ କାରଣ ମୁଁ ସେ it has been received subsequently in a divorce proceeding
ଆପଣଙ୍କର permanent alimony କେବେ ଦେଲେ date of payment of permanent alimony
that is on 25 to 2026
25 to 26
yes
so ଆପଣଙ୍କର application କେବେ file ହେଲା 125 application
that was much before that
date
that was filed 16/5/2017
16/5/2017 so did you tell the while the taking of the court took up the section 25 application have you filed your statement that you are paying this amount kete amount
ନା ସେଟା ବହୁତ ପଛରେ ହେଲା କାରଣ divorce allow ହେଲା ପରେ permanent alimony grant ହେଲା and he has taken the money on 25 to
ନାଇଁ ଉଲ୍ଟା ବୁଝିଲେ just reverse ଟା ବୁଝିଲେ 25 ରେ ଯଦି ଆପଣ ଦଉଥିଲେ 125 interim maintenance ଦଉଥିଲେ ବା 24 କିଛି maintenance ହେଇଥିଲା
ସେଟା ମୁଁ ଏବେ information I cannot
ଠିକ ଅଛି 125 ରେ ଆପଣଙ୍କୁ ଯାହା direction ହେଲା ସେତେବେଳେ ଆପଣଙ୍କର ଅର୍ଡର କେବେ ହେଲା ଦେବା ପାଇଁ 16/5/17 ହଉଛି application date direction କେବେ ହେଲା
direction 19/6/2023
so 19/6/23 so that you have to continue to pay till 25/2/2026 even to that extent I can adjust though Supreme Court says that that cannot be a consideration and what is your stand in your written statement that you are paying that amount or not because what is happening I find that no stand is taken in the written statement here it is told not that because that it can't be substantiated it is not pleaded I have paid 10 lakhs 5 lakhs 16 lakhs 70 lakhs this is so how does the court take that into account because revisional cannot
unless there
revisional
is an
court
additional
cannot.
unless there is an additional evidence you cannot
Evident now because the Supreme Court has mandated you have to keep the disclose that
yes definitely that is not
so now in the revisional court doesn't have power to look into that again so you obtain instruction tomorrow I will get it again because I will not pass order so that it can be listed again if I pass order then it has to return to file has to be returned so 25/2/16/5/17 ରୁ ଆପଣ 16 ଆଟଲିଷ୍ଟ 16/1/2026 25/2 ସେ ମାସଟା ଛାଡି ଦିଅନ୍ତୁ ଆକ୍ଚୁଆଲି 16/2 ହଉଛି 16/2 ଠିକ ଅଛି 16/2 16/2/26 ଯାଏଁ ହଉଛି ଆପଣଙ୍କର 9 ବର୍ଷ 9 ବର୍ଷରେ ଟୋଟାଲ ଆମାଉଣ୍ଟ ଡ୍ୟୁ କେତେ ହେଲା ପର ମନ୍ଥ କେତେ ହେଇଛି କି
ଏଥିରେ per month ହେଇଛି 10,000 ହଉଛି ମାଙ୍କ ପାଇଁ ଆଉ ପିଲାଙ୍କ ପାଇଁ 3,000 13,000 total
13,000 so if 13,000 has not been factored by you before the trial court in section 25 how the revisional court will consider that
no that has been paid I what I was instructed so amount was
you should have told the court
yes
because you are mentioning because there is a specific column in Rajnish Neha affidavit whether any amount is being received by the wife child by any order say that that entry is there. They have simplified it actually. So 13,000 ରୁ ଆପଣଙ୍କର 13,000 into 108 is a substantial amount. So now now perhaps the strategy is that not to pay the 125 and take the plea that I am paying alimony, but that has been completely rejected by Supreme Court.
That I am conscious, but some.
So only to the extent the day you are paying permanent alimony, prior to that there can be, but whether after even alimony whether you can grant or not, that's a different thing. They have dealt with this. So perhaps the strategy was जे आपण 125 जेतु बिल्कुल देबानी एकाथरे alimony adjust कर देबा सेटा perhaps that was the reason for Supreme Court also to say that that can't be a consideration.
No, when this proceeding was pending, he was paying the maintenance amount, but what of the interim maintenance? I don't have the
Interim, no, 125.
Yes, 125.
125 is not interim. They say that 125 proceeding has nothing to do with a section 24 or section 25 because the 125 itself says divorced wife will get maintenance.
Divorce, that the language is there.
It is a statutory provision.
Statutory,
yes. So please look into it. And yes, simply Kali Rocky.
Along with the IA, so the
but unless he deposits that amount, sorry. Say, but you ask him to deposit that amount. How much he will pay? Because 108 into 13, it's a staggering amount.
Huge amount.
Say set by 13 lakh tanga.
Already, it account immediately say late in the recent.
Upon ଯଦି ସେଠି ଲିଟା ନେଇଥାନ୍ତେ ମୁଁ 13 ଲକ୍ଷ ଟଙ୍କା ଦେଇଛି ଆପଣଙ୍କର ମେଣ୍ଟେନାନ୍ସ ସହିତ 22 ଲକ୍ଷ କମି ଯାଇଥାନ୍ତା. That is you now you have created such a situation. Now suppose you have taken what I was telling you. I'm not taking up the MATA challenging the quantum. I am only concerned with 125. Possibly 125 can be adjusted if the amount is paid if the court takes note of that. But should happen say standing in. Yes. 5 lakh ki 6 lakh taka kuhନ୍ତୁ se deposit karibe.
I will take it.
ଆପଣଙ୍କର adjournment ନା କଣ?
I have taken instruction for settlement. He is ready. You want any day, he can come over and make a settlement with her. If they are ready, I have no objection also. I can.
Mr. Samantara is busy.
Let it be after vacation.
You talk to Mr. PB Balakrishna for the item 3 adjournment. So PB Balakrishna 2 ta simply posting kar diyo. Hala. So Balakrishna for the petition. Yes. No order pass kale au thare mane list wa cost hoijibo. The file has to be returned after signing. PB Balakrishna for the petitioner, Mr. L. Samantara, senior advocate, along with Mr. S.G. Das.
No, I'm A. Sahoo.
Mr. A. Sahoo. For the opposite party, Lord and Counsel for the petitioner submits that he has tried and hopefully an amicable settlement will be achieved between the parties acceptable to both. He seeks further time.
After vacation.
Date कहले हम ना
July 1st week.
July रे ठीक है जी. According to the matter shall be listed for fresh admission in the week commencing 6-7 20
Public.
Item 1 करो.
Item 6.
1.
Item 1.
Appeal against a land acquisition. Just because yesterday I was appraising your lordship, there's a note set here, the first page, right? And what a histography.
Yes, and let me open the page. Appearance Mr. Ramananta Mahanti, senior advocate, along with Mr. A. Mahanti for all the appellants. Mr.
I'm there, madam. I'm there, madam.
Yes, please. sole appellate. 1 to 2 होचंदी आपण
Respondent 8.
okay 1 to 7 होचंदी आपण
1 and 2A to 2E man.
okay 1 and
On the number
A
one.
to 2E Mr. A.K. Nando along with Mr. G. N. Sahoo आपण 8A to 8E 8F okay. Mr. Mr. Chakraborty
Chatterjee.
Ms. Chatterjee
On behalf of AP Bose.
Miss A. Chatterjee
RP Chatterjee.
Miss R.P. Chatterjee on behalf of AP Bose for the R8 and 8A to 8F. State कौन नांती
8 state 3
State 3 अच्छा Mr. Prem Kumar Mahanti for 3 AC additional standard. Yes. Written note of submission filed on behalf of the appellant. Yes. Genealogy corona kara
sir kindly देखिए दीटा फर्स्ट रे दीटा प्रॉपर्टी डिस्क्राइब करछि
आगे
से दीटा प्रॉपर्टी एक्वायर्ड
आगे
award was passed in favor of this genealogy kindly देखिए
yes
उषावती विक्रम विकास प्रकाश प्रसन्न ए पांच जन ना
so मीनाकेतन ब्रांच रे अवार्ड ता हेछि
नहीं करुणाकर ब्रांच
करुणाकर बट व्हाट अबाउट प्रसन्न मीनाकेतन चंपावती
सब पूरा समस्त ना से उषाव ए पांच जन ना रे अवार्ड हिछि उषावती प्रसन्न विक्रम विकास प्रकाश so the branch of करुणाकर ना रे हला
branch of करुणाकर has received
हाँ से पूरा अवार्ड ता हला then this
apportionment challenge kale Champavati or
Champavati and Saraswati they claim that they are also the daughters of Karuna so they have half share in it now the matter came to the High Court so it's second page re ठीक है kindly देखिए High Court order ता देखिए second page re 23/4/2014 Lordship got it
23/4/25 in this particular
23/4/2014
14 appeal re
WPC number 1 second page
WPC सेटा को पेज रे अछि
second page of the note
so note रे अछि
yeah second page
सिप तक पढ़ने
नहीं सर
note ता कोडा गला note second page actually it ends at page 4 para 3 paragraphs
the second page
Written note of submission, the dates are mentioned.
yes
Even although he also
the
pays.
High Court order which he says that it is
the annexed no quote is
अच्छा quote अच्छा
second page second
yes that is a quotation yes
पहले सर
23/4/14
23/4/14 WPC ete these petitions मैंने these two sisters were the petitioners these two sisters were the petitioner direction to refer the matter under section and counsel for the petition submits that the first self relief the petitioners approve the opposite party by application so and so in view of the above we direct the opposite party to dispose of the said petition according to law as done no reference need be made to the extent claim of parties is undisputed the undisputed amount may be paid as per award that means undisputed माने एमानकर branch half is undisputed खाली से दीप भौणी करो disputed amount था because they claim that means if I would have succeeded I would have got 100% if they would succeed now or they have succeeded they will get 50% यति होचे dispute now
माने 100% in this sense out of the 50%
no entire award टा जो हेची तादिरो सेमाने 50% claim
correct out of that 50% if you succeed you will get that 50% 100% of that 50%
50% already amount undisputed
or else that 50% will be divided amongst them 25 each
25 वाले 50 हला हो से
वर्तमान 25 into 4 होची 100
हां
आपण जदी दि जण को एलिमिनेट कर देले दीटा 25 रहला से ताको
therefore these two sisters will not get any share if they fail
correct
so my contention was this whole dispute was that these two are not the daughters of Karuna so they don't have any share ethical stuff now for that ସେଠି ମୁଁ ଦେଖୁଥିଲି ସେଥିରେ ଗୋଟେ ଜାଗାରେ ସେ ଏଭିଡେନ୍ସ ଟା ଦେଖିଦେବ ତ ଟିକେ ଦେବେ।
LCR LCR ଅଛି ମୋ ପାଖରେ
ଅଛି
ଆଜ୍ଞା
sir, can we see
Disposition କାହାର
DW1
DW1 ର deposition
deposition ସିଏ ପ୍ରସନ୍ନ ନାୟକ।
there is a problem. Whoever is preparing this paper book in digital format, they don't write actually. So I find in the bookmark PW1 is there, no DW1. So I have to search for it. Just give me some time.
ପ୍ରସନ୍ନ ନାୟକ
Prasanna Naik, okay.
belonging to our branch.
Deposition of OPs ଅଛି ତ 28 ରୁ 45 ନା ଆପଣଙ୍କର ବୁକ୍ ମାର୍କରେ କିଛି ଲେଖିଲେନି list of exhibits exhibit A deposition of witness number 1 for the OP number 7
OP number 2
number 2
Prasanna Naik,
Prasanna Naik
ପ୍ରସନ୍ନ ନାୟକ
para 11 your lordship says.
ଆପଣ ଏଇଟା କଣ ଲେଖିବେ ବାରିକ କଣ DW କୁ PW ଲେଖିବେ yesterday in fact both the additional standing counsel met me and said that why we are not getting this, we are facing a lot of problem. Actually the paper book was the best part and we have not been able to convert digital paper books to the quality physical paper book.
ଗୋଟେ କପି ଦେଇଦଉ
ଏଇ ତ ଅଛି ବିକ୍ରମ ନାୟକ ଆସିଗଲେ ତା ପୂର୍ବରୁ ଅଛନ୍ତି
ପ୍ରସନ୍ନ ନାୟକ
physical copy paper book
LCR of 56, 55 ସେଇ ପେଜରେ ଅଛି ସାର୍।
ପ୍ରସନ୍ନ ନାୟକ କାଢୁଛନ୍ତି କୋଉ ପେଜ ହଁ ବାହାରିଲା 34 ଡାହାଣ ପଟେ 34 ଲେଖା ହେଇଛି ପ୍ରସନ୍ନ ନାୟକ witness number 1 for the OP number 2
ହଁ
Yes.
ପାଇଲେ sir
ସେଟାକୁ ସେମାନେ ଯାହା କରୁଛନ୍ତି
ତାର paragraph 11 ଟା
କରୁଣାକର ନାୟକ
son of Karnataka
7-8 cross examination declined by OP1 then cross examination for OP 3 and 6
ସେଟା paragraph 11 କୁ paragraph 11
ପିଟିସନର ହଉଛନ୍ତି ଏଠି ଯିଏ ଅଛନ୍ତି ଉଷାବତୀ
ହଁ
ଉଷାବତୀ and ଚମ୍ପା
ସେ ଆମରି ବ୍ରାଞ୍ଚ
ଆଚ୍ଛା ଚମ୍ପାବତୀ ସରସ୍ୱତୀଙ୍କ ବ୍ରାଞ୍ଚରେ ଉଷାବତୀ ଆସିଛନ୍ତି
ଉଷାବତୀ
ହଁ
No. See the
ଉଷାବତୀ ଆମରି ବ୍ରାଞ୍ଚ
see the
ଆମରି
wife of
ବ୍ରାଞ୍ଚ ସେ ଗୋଟେ ତ କରୁଣାକର ବ୍ରାଞ୍ଚ ର ଗୋଟେ କରୁଣାକର ବ୍ରାଞ୍ଚ paragraph 11 ଟା କାଇଣ୍ଡଲି
we are 2 brothers and 3 sisters
ହଁ
Vishnu my sister is dead Saraswati and Champa are alive
we are dead.
that you are saying
my father received order
Mr. Sahoo and Mr. Nanda has been harping on that actually
Yes.
ସେତିକି ଅଛି and that is an admission and I found that that admission has not been explained out ଏତିକି ତ ଗୋଟିଏ କଥା
no actually that is cross examination he has stated this in cross examination may not be admission because he might not have stated but
anyway but that is
he has told the truth that has helped so now
now
that clinches the issue
so therefore
flag mark କରନ୍ତୁ ଆଜ୍ଞା
ଆଜ୍ଞା
flag mark ଆପଣ ଯୋଉଟା ବାହାର କଲେ ସେ ଯୋଉ ନାୟକ he is Mr. ପ୍ରସନ୍ନ ନାୟକ ସେ ଜାଗାରେ flag mark କରୁଛନ୍ତି ଆପଣ ଏଟା କହୁଛନ୍ତି DW1 ଲେଖିଦିଅ flag ରେ DW1 ଲେଖିଦିଅ
ଏତିକି ହଉଛି କଥା we disputed that daughtership
so now what is the status of that amount 50%
amount is in deposit total I filed a petition for to release the undisputed amount can I disputed half ଟା ରହିବ ସେଇଟା that will be considered at the time of hearing ବୋଲି ହେଇଯାଇଛି
so ବର୍ତ୍ତମାନ please work out that apportionment
ସେ ଆପଣ କରିଦେଲେ ଯଦି if you
ସିଏ କରିବେ ନାଇଁ ଆପଣ କରିଦେଇଥାନ୍ତୁ ଆପଣ ଗୋଟେ ପେପରରେ ସିମ୍ପଲି ଯୋଉ ଆମାଉଣ୍ଟ ଟା Mr. Nanda and Mr. Sethi.
Client presence ଦରକାର ତାହେଲେ
No, ଗୋଟେ ପଇସା ଆଣିକି ବାଣ୍ଟିବାର କହୁନ. I will be issuing that guideline for them to distribute disbursement apportionment.
ସେ ତ ମାନେ କରୁଣାକର ବ୍ରାଞ୍ଚ କୁ ଗୋଟେ କରୁଣା
Yes, Mr. Nanda, କରୁଣାକର branch ଗୋଟେ ପାଇବେ ତ?
My lord,
Again, that genealogy.
my lord, as per the genealogy, my lord senior has admitted that we are the sisters of the.
No, admission may not be taken.
As per the submission, my lord. It is not only that.
He has
my
simply
lord,
placed the material on record.
Yes, and one more witness also, he has also admitted that
ତାଙ୍କ ନାଁ ଆର witness ଙ୍କ ନାଁଟା?
advocate now, which is
Mr. Sahoo.
his name is
What is
Vikram,
batch number? 3 to
Vikram Nath, my lord, Vikram Nath. Witness number
Vikram Naik.
Nath, Naik, my lord. Vikram Naik,
Flag marantu.
ସେଥିରେ my lord, paragraph 14, my lord. Paragraph 14. He is the son of my lord, he is the son of my lord Minoketan. Minoketan is the brother of Prasanna. Minoketan and Prasanna are two brothers.
There is Amari branch.
Yes, their branch. And Minoketan's son says in paragraph 14 that it is a fact that the petitioners are my paternal aunts. That means his father's two sisters. So he has also admitted.
ପ୍ରସନ୍ନ ପ୍ରଥମେ କହିଲେ.
ଆଜ୍ଞା
ପ୍ରସନ୍ନ ହଉଛନ୍ତି R4 ସେ admit କଲେ.
ତାପରେ ଏଠି
ଆପଣଙ୍କର ବିନୋକେତନ ବ୍ରାଞ୍ଚ ରେ ବିକ୍ରମ ବି କହିଲେ admit କଲେ ପ୍ରୋସିଡର ଷ୍ଟେଟମେଣ୍ଟ ଦେଲେ ଆଉ they have stated R5 ବି state କରିଛନ୍ତି ସେ ଆସି କହୁଛନ୍ତି.
Yes, my lord, here these are all matters admitted fact. Now the one more thing, my lord, that I beg your lordship to my lord submit. My lord, may kindly to look to paragraph 15 of the judgment. That needs a little clarification in view of the fact that during the pendency of the appeal before this honorable court, the law laid down in the year 2020, and in that Vinita Sharma's case, that says that
Vinita Sharma case.
Vinita Sharma's case. I have requested my lord, friend my lord, to pass on a copy of that judgment to my lord, because during the pendency of the appeal of this present one, which is pending since 2016, that law was laid down in 2020 because of the confusing views of different high courts, man. I only request my lord to kindly look into the last paragraph.
How Vinita Sharma will impact this judgment?
Because
Yes, my lord, here
paragraph.
You say that instead of handing over the copy.
My
So
lord.
they should also know. Mahanti should know.
Earlier,
ଗୋଟେ eighth judgment ତ
hey, judge.
Vinita Sharma, my lord, I am just reading out that portion because here what has happened, that's why I was requesting my lord to look into paragraph 15 of this judgment, present judgment, if you judge. Paragraph 15, your lordship sees fine. Here what has happened, my lord, the learned low court, my lord, has held that on the death of the father, that's Karunakar, there is a notional partition, he says. And the partition he has done in this case is, my lord, on the holding that this is on the basis of survivorship.
No, my question is a little bit different.
Yes, my lord.
Because I'm only appellate court. I can't go beyond whatever was there. So was this what you are arguing now was what it was considered by the learned trial court and what was the finding?
These things are academic. But ultimately the parties have to get their share as per the law. If these two persons are held to be daughters, then they will get a share. That's a calculation part they will do.
Perhaps Mr. Nanda is saying that even if the children of these two sisters that you are suggesting by Vinita Sharma.
Yes,
No,
sir.
no.
What?
These
No,
two
what I am
Subuni
submitting, my lord.
actually audio ଟା ବଢେଇଲେ କମ୍ପ୍ୟୁଟର କହିଲେ ଆମର ଅଡିଓ ଆଉଟପୁଟ ଟା ଟିକେ ବଢେଇବେ ଅଡିଓ 100% ଅଛି.
Is it audible, my lord, now? Is it audible, my lord?
1 of 2016, my lord, the entire compensation amount has been divided into 4, my lord. 1/4 share, 1/4 share. Two daughters, 1/4 share each, my lord. My senior clients will get 1/4, 2 persons. Our clients will get 1/4, 2 persons, my lord. That is in 1/2006. My lord.
ଭୁଲ ମ୍ୟାଥମେଟିକ୍ସ କହୁଛନ୍ତି.
ନାଇଁ, 1/4
1/4 ଥିଲେ ଆପଣ 1/4 into 2 ହେଲେ କେତେ 1/2.
ନାଇଁ, 4
ଦି ଜଣ ଭାଇ ହେଲେ 1/4 କୁ 2 ରେ ଗୁଣିଲେ 1/2 ହବ.
ସେ
ଦେଖୁନାହାନ୍ତି
ଜିନୋଲୋଜି ପ୍ରସନ୍ନ ମିନୋକେତନ ଚମ୍ପାବତୀ ସ୍ୱରୂପ ଏଇ ଚାରିଟା.
My humble submission is, my lord, may kindly look into paragraph 15 of that judgment, my lord, the lower court judgment.
Hey,
That
what you
was-
want? I'm asking about the impact. That
In
you are
fact,
saying that you are saying that instead of 1/4, you are getting more.
I'm getting less in as per this judgment.
That
As
your
per
lordship
this
will
judgment.
verify that they will get.
That is what my prayer is, man. My
Yes.
prayer is because the learned trial court has held that there is, well, it is a notional partition and he has held, and on the basis of the notional partition, it says that two sons, father. On the death of the father, there is a notional partition. Three of them will get 1/3, 1/3, 1/3 share. Out of the share of father, that is 1/3, it will be again redivided among the two sons and two daughters, and we will get married out of that 1/3 share. Will get married one share.
But since that was not argued by Mr. Mohanty, so I could not have because Mr. Mohanty's argument is 1/4.
If my
So
lord
you are
said-
saying now you are saying that the trial court has held that the daughters will get the 1/3 share of the father,
Yeah, only 1/3 share.
not
of the
as a
father.
not as a co-parsoner.
Not as a
Or
co-parson.
I mean, like a joint family property devolving upon the legal heirs.
Yes, ma'am, that's what my submission.
First of all,
And
that is
the-
not, first of all, that is not the issue here. Second
No,
of
no,
all,
that
there is
is-
no counterclaim or.
No, what I'm submitting,
sir.
if the judge. If
No, I
the
think
judgment
Mr.
is-
Mohanty has proceeded that everybody gets 1/4. That is how I was unable to follow what Mr. Sahoo was saying.
If your lordship holds that Champavati and Saraswati are the daughters of Coronagar, it's the end of the matter. Calculation will be done.
And I think what Mr. This is a judgment of 2015.
20. The Supreme Court judgment is in the year 2020.
No, I'm not
20.
there. I'm saying about this judgment of the learned referral
Yes,
court.
yes, ma'am.
2015.
15 ବେଳକୁ ଏଇ lawଟା ଏଇଟା
Now
ଆସିନଥିଲା।
Vinita Sharma will prevail.
Yes, ma'am.
That's why it's
Not an issue.
It's not an issue.
Not an issue here, right?
Issue is whether they are the daughters. If your lordship holds that they are the daughters, end of the matter, calculation will be done by them.
No,
That's
no.
I'll record your submission that for
Oh, yes.
calculation you are relying on Vinita Sharma.
Yes, and it should be equal. That's my humble prayer, man. And the
I think
second case,
because of the prevailing law, in fact, Mr. Mohanty has argued 1/4.
1/4.
He never said 1/3 by 2.
Man, my only apprehension was my lord.
1/6.
Had that judgment been my lord upheld in toto, probably there would have been another confusion regarding the allotment of share. That's why my humble submission is to clarify that as per the law laid down by the Supreme Court.
So 1/3 by 2 ହେଲେ 1/6 ହବ, ଏଥିରେ ହେଲେ 1/4 ଦଉଛି।
1/4 each ହବ।
1/4 ହବ, ସେମାନେ 1/3 ଜାଗାରେ 1/4 ପାଇବେ।
ସମସ୍ତେ 1/4
1/4 ପାଇବେ।
ସମସ୍ତେ। ଆଉ ସାର୍ ସେକେଣ୍ଡ କେସଟା ଯୋଉଟା ଅଛି, ଆଉ ଗୋଟେ ସେକେଣ୍ଡ କେସ୍ ଯୋଉଟା ଅଛି, ସେଥିରେ ଠିକ କରାଯାଇଛି। ସେଥିରେ ପୁରା ଠିକ ଅଛି।
ଆଚ୍ଛା, LA2 ରେ ଆପଣ କହୁଛନ୍ତି ସେ ଇସ୍ୟୁଟା ନାହିଁ। ସମସ୍ତେ ପାଇଛନ୍ତି equal share।
ନାଇଁ ସାର୍, LA2 ଟା ପ୍ରଥମ କେସ୍ ଆପଣଙ୍କ ପାଖରେ।
Honestly, it will becoming academic.
No, it's not academic. It's more for clarification so that there is no further problem. So ଯୋଉଟା ପ୍ରଥମ କେସ୍ ସାର୍ LA2 ରେ ସେଥିରେ ହିଁ ପ୍ରୋବ୍ଲେମଟା ହେଇଛି। ଯୋଉଟା ସେକେଣ୍ଡ କେସ୍ ସେଟା LA1 ହେଇକି ଅଛି, ସେଥିରେ ପ୍ରୋବ୍ଲେମ ନାହିଁ। ସେଥିରେ ପୁରା ଠିକ ବେସିସ୍ ରେ ହେଇଛି। ଇକ୍ୱାଲ ଦେଇଛି।
LA1 ରେ ଠିକ ଅଛି ସାର୍, LA2 ରେ ସେ national partition କରିଦେଇଛନ୍ତି। LA1 by 6
ଏଇଟା national ଆପଣ କହୁଛନ୍ତି 1/6 ହେଇଗଲା, 2 ରେ ହେଇଛି, 1 ରେ ସେ ପ୍ରୋବ୍ଲେମ ନାହିଁ। But Mr. Mohanty argued is LA1. I think yes, I have opened LA1.
But the LA2 is
So, since there is, I could have pronounced it, but since there is a lot of time, I'm
Only I pray your lordship may direct because ଜଣେ deathbed judge. Disbursement within immediate disbursement.
Suggest କରନ୍ତୁ କେତେ ଦିନ ଦବା।
ମାସ ଭିତରେ ହଉ। କେନ deposit ହିଁ ଅଛି।
ଆପଣ ମାନେ ସମସ୍ତେ appear କରିବେ ନା particular date suggest କରନ୍ତୁ।
କରିଦେବେ, they will disburse the amount as per the law.
କାହିଁକିନା ବୋଧେ actually ଛୁଟି ଭିତରେ pronouncement ହେଇପାରିବନି। ମୁଁ ବୁଝୁଥିଲି ଯାହା ମାନେ last
ଆପଣ ତ ସୁବିଧା ଅନୁସାରେ ଦେବେ।
reopening ବେଳକୁ କରିବାକୁ ପଡିବ। It will be ready during the but since during vacation regular judgments cannot be pronounced.
ଖାଲି ଟିକେ time bound ଟିକେ କରିଦେବେ।
ଠିକ ଅଛି। ଆଉ ଯଦି ଆପଣ କହିବେ I will pronounce it by Friday, but it will take some time for finalizing and uploading the draft.
ଆପଣଙ୍କ ସୁବିଧା ଅନୁସାରେ will
So
not.
then because
ଖାଲି ଏତିକି ଖାଲି ଗୋଟେ ଦିଟା ଜିନିଷ time bound ଆଉ ଯୋଉଟା deposit ହେଇଛି along with accrued interest.
accrued interest.
yes.
Deposit plus accrued interest
And time bound.
ଆପଣ ମାନେ reopening ପରେ appear କରିବେ। ଆପଣଙ୍କର lower court ଖୋଲୁଛି 22 ତାରିଖରେ, ନାଇଁ 17 ତାରିଖରେ। 17/6 is reopening of the courts. ଆପଣ କେବେ ଆଫେକ୍ଟ କରିବେ?
ଯେବେ ଆପଣ
ଠିକ ଅଛି ତାହେଲେ shall appear on 22/6. If I am able to pronounce it on Friday, I'll give a date of appearance on 22/6.
ଖାଲି ମୋର କନସେସନ ଟା ନୋଟ
Not at all, not.
but that is the law I am telling you.
Yes.
ସେ ଆଡମିସନ ଟା କଣ ଆମର ଆର୍ଗୁମେଣ୍ଟ ଥିଲା କି ଯେ ଆମେ କହିଛୁ ସେମାନେ ଆମ ସିଷ୍ଟର ବଟ୍ ନଟ୍ ସିଷ୍ଟର ମାନେ ଡଟର ଅଫ ଇଏ ସେଇ ଡିଷ୍ଟ୍ରିକ୍ଟ ଗୋଟେ ଥିଲା ସେଇଟା ଗୋଟେ ଉଚିତ ଥିଲା ଯେ ଆଡମିସନ ଟାକୁ ଏକ୍ସପ୍ଲେନ ହୁଏ କରିବ କରିନାହାନ୍ତି
ସେମାନେ ତ ପ୍ରଥମରୁ ମନା କଲେ
ସେମାନେ ବି ସେଟା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହିଛନ୍ତି
ଆଜ୍ଞା ହଁ
କ୍ରସ୍ ଏକ୍ସାମିନେସନ I think it can't be
ସେ
expected.
ଜାଣିକିରି ପଚାରିଛନ୍ତି କ୍ରସ୍
ତା ଆଗରୁ ମୁଖ୍ୟ
Cross examination cannot be expected. ଆପଣଙ୍କର ଯେତେବେଳେ ଆଡମିସନ ଥିଲେ ଆପଣ କ୍ରସ୍ ଏକ୍ସପ୍ଲେନ କରିଦେଇଥାନ୍ତି
ହେଇପାରିଥାନ୍ତା ତାକୁ ରିକଲ କରିଥାନ୍ତି କି ଆଉ ଥରେ କରିଥାନ୍ତି କିଛି କଲେନି ତ ଆଉ ଛାଡ ଆଉ କଣ କରିବୁ
difficult to get over a cross examination statement. ଏଇଟା ସାଇଟେସନ ଟା ରଖି ଦିଅନ୍ତୁ AI 2020 Supreme Court.
only last paragraph my lord may see. That the ultimate directions.
B717. पारा कितने कहले मिस्टर नंदा?
129.
129. 129. Last paragraph.
129.
Yes, madam. That those are the summary and the directions.
ठीक है. Yes. Hearing concluded. Judgment written. The Lord Senior Counsel for the appellant, along with Mr. Animesh Mohanty, first item in lecture. Mr. But the appearance of here had at length. Yes, Mr. Prem Kumar Mohanty, yes, anything to say?
No.
Yes. Both the appeals say had at length. Yes. Call କରନ୍ତୁ
Second day.
ଆଜ୍ଞା
Second day. Metro second.
ଦିଟା ଯାକ କ୍ଲୋଜ ଦିଟା ଯାକ ସିଏ ବି କଣ 4 ବି ଗଲା 5 ରୁ ବୋଧେ ଡାକିବ 5 6
Item 6.
6, your lordship remembers the wife is to appear. Your lordship yesterday urgent saying that my engineer is there. ସେଟା ଡେଟଟା ଗୋଟେ
କେବେ appear କରିବେ ଆପଣ କୁହନ୍ତୁ ଛୁଟି ପରେ
30 କହୁଛନ୍ତି ସେ appear କରିବେ ବୋଲି ସେଠି
नो डिफिकल्टी लिखି ଦେଇ ଦିଅନ୍ତୁ it will be closed.
ନାଇଁ ଆଉ ଗୋଟେ ଏଇଟା ଯଦି ଡିସ୍ପୋଜାଲ କରିବେ ତାହେଲେ ଆଉ ଗୋଟେ ପଏଣ୍ଟ ଅଛି
ଆପଣ କହୁଛନ୍ତି ଏଟା ପେଣ୍ଡିଂ ରହିବ ବୋଲି
ତାର କାରଣ ହଉଛି ନହେଲେ ଆପଣ ଯଦି ଡାଇରେକ୍ସନ ଦେଇଦେଇଛୁ ଦି କୋର୍ଟ ଡାଇରେକ୍ଟେଡ the Honorable Judge Family Court. I filed 5-6 petitions. He has quoted it. He directed that he only allowed one petition, namely to summon the wife for appearance for further cross-examination, and he said other petitions will be considered post facto her cross-examination, depending on that. So now what happened? She did not appear despite repeated summons. Now the Land Judge Family Court closed it and even did not consider my petitions and posted for argument. What I am praying for, now that my land senior, his client has agreed through my land senior to appear on June 30th, my petitions may be considered post facto.
because you are saying that closing order, closing everything
could not have been done because he himself said that it is to be heard.
Because it is prejudicial to both the parties.
Not only that, the Land Judge Family Court himself said.
ସେ ବୋଧେ ରାଗି ଗଲେ ଟିକେ ପାଖ ଉପରେ
My lord, I suggested that let
June 30
matter sent to the
conciliation ଆଜ୍ଞା ହବନି mediation ମୁଁ ଜାଣିଛି ଆଉ ମୁଁ ଯୋଉଟା mediation ହଉଥିବ I will agree.
ବର୍ତ୍ତମାନ ଗୋଟେ ଚାଲିଛି ଯେ ଯୋଉଥିରେ ମେଣ୍ଟେନାନ୍ସ ଡାଇରେକ୍ସନ ତ ମେଡିଏସନ କରିବେ ପଇସା କି ଆପଣ ଯଦି ଦେବେ ତାହେଲେ ଦିଅନ୍ତୁ ତାପରେ ମେଡିଏସନ କୁ ଦେବା ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦଉଛି ଏଥିରେ ମେଡିଏସନ କଣ କରିବେ ଏଭିଡେନ୍ସ ରେ ଏଭିଡେନ୍ସ ରେ ହାଇକୋର୍ଟ ରେ କଣ ମେଡିଏସନ
ଆଉ ଏଭିଡେନ୍ସ ଦବୁ ନା
must understand that
he want
ସେ jurisdiction ଟା ନାହିଁ କୋର୍ଟ ର ସେଟା ଟ୍ରାୟାଲ କୋର୍ଟ ଫ୍ୟାମିଲି କୋର୍ଟ ର ଅଛି
In fact, I have talked to my land senior.
one paragraph is dedicated.
Don't worry, I will ensure.
ଆପଣଙ୍କୁ ବି allow ହବ
ମୁଁ ସେଠି family judge ଙ୍କ ପାଖରେ କଣ ହବ ନ ହବ I have domain. If I am not appearing also, I will ensure it. But domain ମାନେ with regard to the party, my party. So ମୁଁ ଦେଖିବି ଯାହା ଭଲ ହବ ନିଶ୍ଚୟ କରେଇବି ଏଠି ପଠେଇ conciliation କୁ be a wastage of time ଅଛି
complete wastage of time and the system is getting overburdened.
ନହେଲେ ମୋର କିଛି ମନା ନାହିଁ
statutory conciliation prescribed in the Family Courts Act. It is mandatory. Now, High Court doesn't have that jurisdiction. We do not have counselors also. You can check the judgment. The Supreme Court has already considered that aspect. In Rajneesh versus Neha, they have also said that it has to be sent for conciliation by the court.
সেটি ହେଇଛି
Counseling, counseling, rounds of counseling.
Sir, ହେଇଛି
Conciliation ଟା
ଏଇଟା।
ଏଠି ହଉଛି।
Sir, ସେଇଟା ସେଠି ହେଇଛି
Till then ଯାହା ବି କରିହବ ତ ସେ କହୁଛନ୍ତି କରାଯିବ।
ସେଇଠି କରାଯିବ କିଛି ଅସୁବିଧା ଖାଲି ମୁଁ ଆସିଷ୍ଟ କରିବା ପାଇଁ ଡିସ୍ପୋଜାଲ ପାଇଁ ଯୋଡ଼ିଏ ପେଜ ଦେଖେଇଦେବି ଲର୍ଡସିପ
Yes.
ପେଜ 33 ଏଇଠି ମୁଁ ଫାଇଲ କଲି ପିଟିସନ ଗୁଡାକ ଏବିସିଡି ସେ
So
କୋର୍ଟ
that closing that order ଖାଲି ସେଠି ଦେଖ। ଯୋଉ order
ଆଜ୍ଞା।
ସେ କହିଲେ ସବୁ close ହେଇଗଲା।
ସେ କ୍ଲୋଜ ରେ ଖାଲି ପେଜ 35 ରେ ସେ କହିଲେ ପିଟିସନ ଗୁଡା କନସିଡର ହବ ଆଫ୍ଟର ଏକ୍ସାମିନେସନ ପେଜ 35 ପେଜ ପାରାଗ୍ରାଫ 3
35 paragraph 3.
ଆଜ୍ଞା
That you have challenged.
ନାଇଁ ସେଟା ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରୁନି ସେ କହିଲେ କନସିଡର ହବ ତେଣୁ ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରିବା ଦରକାର ନାହିଁ ତାପରେ ଚାଲିଲା ୱାଇଫ ଆସିବା ପାଇଁ କାହିଁକିନା କୋର୍ଟ ସେଡ୍ ଦ୍ୟାଟ ୱାଇଫ
ଏଇ ଯୋଉ କ୍ଲୋଜ କରିଦେଲେ ସେଟା କୋଉ ଦିନ?
ସେଟା ଏଠି ଆସିଲା ସେଟା ୟୋର ଲର୍ଡସିପ ସି
page.
ସେଟା ମୁଁ ସେଟା ଆସିଛି ପେଜ 44
44 in 6203.
ମାଇ ଲର୍ଡ ମାଇ କେସ୍
Six two zero three page 44. 44. ଆପଣ ଏଇଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି।
ହଁ ସେ କ୍ଲୋଜ କରିଦେଲେ
ଠିକ ଅଛି। WPC 6203 of 2025, Mr. Samir Mishra, senior advocate, along with Mr. Raut, Rakesh Raut for the petitioner, Mr. PK Ratha, along with ଆପଣଙ୍କ ନାଁଟା actually ମୋର ମାନେ ଜୁନିୟର ଭାଇ ମନେ ପଡୁଛି। So that's the problem. DR Devaranjan Mahapatra for the हाँ ठीक है देवरंजन महापात्र फॉर द अपोजिट पार्टी सेकंड मैटर लिखिबे एटा 6203 गला सेकंड होची 18941 मिस्टर इक्के रथ along with Mr. Devaranjan Mahapatra for the petitioner, Mr. Samir Mishra, senior advocate, along with Mr. S. Raut for the opposite party. In the WPC 6203, the husband in the marriage is the petitioner, and in the tagged WPC 18941 of 2019, the wife in the marriage is the petitioner. The husband challenges the order dated 4/11/2024 passed by the learned Judge Family Court in CP number dash. The said order is reproduced herein. The wife, by filing the writ application 18941, challenges. ଆପଣ ବି ସେ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି?
ନାଇଁ ନାଇଁ ସିଏ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଯୋଉ ମେଣ୍ଟେନାନ୍ସ ଆୱାର୍ଡ ହେଲା ମୁଁ ବି ଚ୍ୟାଲେଞ୍ଜ କରୁଛି ସିଏ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ମୋ କେସଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲା ତାଙ୍କ କେସଟା ପେଣ୍ଡିଂ ଅଛି ବର୍ତ୍ତମାନ
ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ କହୁଛନ୍ତି ବର୍ତ୍ତମାନ ସେଟା ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ ହେଇଗଲାଣି ଷ୍ଟେଜ
challenges the order.
ସେ ଇନଫ୍ରକ୍ସସ୍
not press man like that fits in the marketplace.
16/8/2019 passed in IA number 15 of 2017 arising out of CP number 288 of 2017 directing payment of pendent light maintenance at the rate of rupees 5,000 per month from the date of filing of application, that is 12/7/2017. The CP has been filed by the CP ki file karchandi?
CP has been filed by me.
By the husband?
ଦିଟା ଅଛି ଗୋଟେ ରେଷ୍ଟ୍ରିକ୍ସନ ଅଛି ଗୋଟେ ଅଛି ଡାଇଭର୍ସ ମୋର ଡାଇଭର୍ସ ୱାଇଫ ର ରେଷ୍ଟ୍ରିକ୍ସନ
ଆପଣଙ୍କର the CP number ଆପଣଙ୍କର ଅଛି 288
ଆଜ୍ଞା
of 2017 has been filed by the husband in the marriage under section 13 of the Hindu Marriage Act, seeking a dissolution of marriage and grant of decree of divorce. Stop. Sapara. CP number wife CP number 2 counterclaim na kon setire.
ନାଇଁ ସେ ଗୋଟେ ସେପାରେଟ ଫାଇଲ କରିଥିଲେ ରେଷ୍ଟ୍ରିକ୍ସନ କଟକରେ
Number ekka ହେଇଗଲା.
288
Marriage has made in heaven.
ଆଜ୍ଞା
Still it is not working.
and it's
The CP number 288 of 2016 has been filed by the wife in the marriage under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Accordingly, both the matters were taken up together by the learned Judge Family Court, Cuttack. Para. regarding the application seeking an enhancement of pendant light maintenance or not pressed.
Not.
The infructuous why sir? 55 হয়ে গেল infructuous কেমতি বলছে
not press কই
the learned counsel for the appearing for the wife submits that the wife doesn't want to press the said application as of now or as on date as on date. Accordingly, the said petition is disposed of. তারমানে সেটা হবে কত কইলে accordingly WPC 18941 of 2019 is disposed of. Regarding the connected writ application where the challenge is to the order passed by the Learned Judge Family Court in author se page ta ko jan to 48 58
your lordship order dated your lordship
page
that is page
44 order dated 4/11/2024
page 44
is seen that the said order has been passed as the opposite party as the wife in the marriage refused to appear before the Learned Judge Family Court for adducing evidence. In the form of her depositions. Stop. Now, se taka refusal ta kodino record korthile as indicated in order.
এটা your lordship will see page 38 refusal କିଛି ନାହିଁ ସେ appear ତ କଲେନି ଖାଲି ପୁଟ ହେଇକି ରହିଲା
ଆଚ୍ଛା
ମୁଁ ପିଟିସନ ଟା ଦେଲି ଯେ ଯେହେତୁ ସେ appear କରୁନାହାନ୍ତି ମୋ ଦରଖାସ୍ତଟା କନସିଡର ହଉ ବର୍ତ୍ତମାନ ସେ କ୍ଲୋଜ କରିଦେଲେ
fail to appear ସେଟା କୋଉ ଦିନ ଯାଏ appear ସେ କଲେନି
28/2024 ପେଜ 38
2024
ତାପରେ 6/9 ରେ ନିଶ୍ଚୟ କରିନଥିବେ କାହିଁକି ନା ପିଟିସନ ଦେଲି
24/8/2024 kale though he was directed to appear kebe arambha hela down direction hela
direction was started your lordship from page 35 page 35 paragraph 3
8/11/23
ते लिखिले all other petitions shall be considered after re-cross examination of respondent wife सेउटु आरंभ होला
कौन लिखले though he was directed to appear apparently from the with effect
8/11
with effect from the by order dated 8/11/2023 stop now the Learned Counsel for the appearing for the wife in the marriage files memo ta dio kudra appear kariyo Mahapatra memo likhi dio files memo of date indicating that the wife undertakes to appear before the Learned Judge Family Court Cuttack in the pending proceeding on 30/6/2026. The Learned Court shall proceed to record her evidence.
Re-cross examination
to bracket re-cross examination on the said date or shall fix a date, definite date when she will appear and tender her evidence. The issue still left is pointed out by the Learned Senior Counsel for the appellant husband. That is order dated 4/11/24
24 ଟା ଯିବ
4/11/24 ନା
16/10/23 ଟା କ୍ୟାରି ଆଉଟ୍ ହବ ତାପରେ 16/10/23 ରେ ସେ କହିଲେ
4/11/24 ରେ କ୍ଲୋଜ କୋଉଠି ସେ ଲେଖିଲେ
your lordship ସେ କିଛି କ୍ଲୋଜ ଲେଖିଲେନି ସେ କହିଲେ put up for argument that means it is closed I am not inclined to entertain the petition
that records quote tinta dot both parties come to ready for arguments तो बढ़िया इंग्लिश लिखा है come to ready stop quotants काली मु देखली राती रे in order to enable the learned counsel to file. So lekha is unable. E au you upon hota jani paribeni.
Notice.
So simple here, it has a devastating consequence.
Well,
So, contents, hala. It is submitted that once the matter is posted for arguments, the purpose of recross examination and consideration of the matter, consideration of the evidence,
petitions as ordered in
and also the
order dated-
petitions, and also the petitions
as ordered in order
reflected,
dated 16/10/2023,
reflected in order dated 1610 taku page.
page 33. ସେଇଠି ମୋ ପିଟିସନର ଟାକୁ ସେ କନସିଡର କରି ପେଜ 35 ରେ କହିଲେ ପିଟିସନର ଟା କନସିଡର ହବ ଆଫ୍ଟର ରିକ୍ରସ୍ ଏକ୍ସାମିନେସନ ପାରାଗ୍ରାଫ 3 ରେ ପେଜ 35 ରେ
Petition ଟା କୋଉ ଜାଗାରେ ପଢିଲା?
ପିଟିସନର ଟା ସବୁ କୋଟ କଲେ ପେଜ 33 ରେ ଏ ବି ସି ଡି କରି ମୋ ପିଟିସନର ପ୍ରେୟାର ଏଟା
ଷୋହଳ 10/2023 would be rendered OTOs. Accordingly, it is directed. The order dated 4/11/2024 stands modified to the extent that after the recross examination of the wife in the marriage, the learned judge family court shall proceed to consider the petitions. ଆପଣଙ୍କର ଖାଲି ନା
ମୋର ଖାଲି
wife ଙ୍କର କଣ petition ଅଛି?
ନାଇଁ ୱାଇଫ ର କିଛି ନଥିଲା as observed in order
The
dated
petitions
2020.
as the learned court has observed and reflected in order dated 16/10/2023.
Therefore,
तो आगे ऊपर लिखी ଦେଇଥିବେ the वकालतनामा on behalf of the duly executed वकालतनामा executed by the wife in the marriage shall be taken on record, scanned copy be updated. This court, before parting with the case, this court records the efforts of records appreciation of the efforts made by the learned senior counsel for the husband, appearing for the husband, as well as learned counsel Mr. Ratho and Mr. Mahapatra, appearing for the wife in the marriage, for arriving at for disposal of the matter, as the pendency of the applications has interdicted the pending suits before the pending civil proceedings before the learned family court. Okay. Yes. Urgent certified copy as per rules. Yes, next.
Item 7.
Mr. Surendra Kumar Bishwal for the petitioner. The matter was heard at length on 29/4/2026. At some length. Stop. 11/2 should have 11/2/2026. The matter was heard at length on 11/2/2026 and was adjourned. By the learned counsel for the petitioner to make further submissions in view of the facts as well as the propositions of law recorded in the said order. Thereafter, the matter was adjourned by the petitioner on 30/3/2026. On 30/4/2026. Stop. Today, the matter being listed for fresh admission, adjournment is sought for by the learned counsel for the petitioner. Stop. Accordingly, to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 20/7/2026. Yes.
Item 8.
Item 8, Your Lordship, it is matter regarding payment of arrears to fourth peon post. Similar matter was there before Your Lordship yesterday at serial number 14 of the list.
Identical to that.
କିନ୍ତୁ order pass ହେଇନି କହୁଛନ୍ତି
order pass ହେଇଛି
ହେଇଯାଇଛି ମାନେ comply ହେଇଯାଇଛି
ନା comply ହେଇନି. The request has been made to government to place funds.
ଆଚ୍ଛା
So identical matter, your lordship posted to week commencing 20th July.
କାଲିର 14 ଦେଖନ୍ତୁ,
14
କାଲି 14 ଥିଲା କହୁଛନ୍ତି
ହଁ।
discharge।
Yes,
The same.
I've written the number and I've given.
ସେଠି ଚେକ୍ କର। Ms. Charvi on behalf of Subhadatta Rautray for the petitioner, Mr. D.N. Lekka, AGA for the state. Again?
Yes.
It is stated by the learned counsel for the petitioner as well as the learned AGA that similar matter was listed, was in the yesterday's list and has been posted to 13/7/2026. Accordingly, the matter shall be listed on in the week commencing 13/7/2026 for fresh admission. Stop. It is submitted by the learned counsel for the learned AGA for the appearing for the opposite party that the request has been made for placement of funds.
Yes.
For dispersal of the co-due.
It doesn't say.
Salary.
Area.
For arrears of salary as due and admissible to be paid to the petitioner. Stop. The learned AGA shall obtain up-to-date instructions.
Yes.
And file affidavit by the state. Yes, next.
Much obliged, Your Lordship.
Item 9.
9, may I please your
Mr.
lordship?
Ibu Prasad Mahanti for the petitioner. Mr. Polai.
Yes, my lord, I am on behalf of Vishwajit Prasad.
Yes.
My lord, in occasion last
Mr. R.
order.
Polai. S. Polai.
SR Polai.
Mr. So I spoke both the letters. Mr. S.R. Polai on behalf of Mr. Parijay. Mr. B. Prasad.
B Prasad.
Yes.
My lord, in occasion last order, annex କହନ୍ତି ଆଉ ଗୋଟେ RPFM ଫାଇଲ ହେଇଥିଲା ଲାବଣ୍ୟ ମିଶ୍ର ତରଫରୁ ଚନ୍ଦନପତି ସେଇଟା my lord ସେଟା ଭୁଲ ଟାଇପ ହେଇଥିଲା।
ଲାବଣ୍ୟଙ୍କର କଣ ଅସୁବିଧା ହେଲା? अरे this is a very interesting ମାନେ prayer. ଆପଣଙ୍କର I direct that the similar another RPFM between the parties. ଆପଣ ଆମର third party ନା କହିଲେ?
ନାଇଁ
land acquisition ନା କଣ?
ନାଇଁ no my lord.
Inadvertently, last occasion, the number which has been given and is attached is too different because they have filed a RPFM 96.
Sorry,
96 of
ଚନ୍ଦନପତି ଲବଲୀନା ମିଶ୍ର
ଲବଲୀନା ମିଶ୍ର
ନା ଦାସ versus ଶିବାନୀ ଦାସ
that is a wrong file has been
wrong file by attached.
And this affidavit your lordship has directed
ସେଇଟା my lord 94 ଜାଗାରେ 64 ହେଇଯାଇଛି।
Shankar and Shivani are fighting it out.
94 ଜାଗାରେ
The
60
most famous god and goddess.
sunk. Which one?
Second matter. ସେଇଟା ଭୁଲରେ ଆସିଗଲା।
ଭୁଲରେ ଆସିଯାଇଛି my lord 94 ହବା ଜାଗାରେ RPFM 94/2000
It is submitted by the learned counsel Mr. Polai that inadvertently RPFM 64 was mentioned to be tagged whereas the number is RPFM
94
64 of 2026 ହେଲା 94 of 2026
yes ma'am
94 of 2026 is to be is pending between both the parties both of herein
Filed by the wife.
filed by the opposite party wife if the opposite party lekhantuni filed by the wife in the marriage stop accordingly RPFM 64 of 2026 shall be T-tagged hala and shall be listed separately stop RPFM 94 of 2026 shall be tagged to the present matter and shall be listed together in the for orders like fresh admission in the week commencing
Here,
6-7 yes go.
I have asked for lordship's direction in RPFM 67 of 2026. Dated 6/3/2026. I filed this affidavit, your lordship. Giving a
ଆପଣଙ୍କର ଗୋଟେ ସେଇ ଗୋଟେ ବେସିକ ଫଣ୍ଡାମେଣ୍ଟାଲ ମିଷ୍ଟେକ୍ ରହୁଛି
tabular form.
ପ୍ରୋବ୍ଲେମ ରହୁଛି ନା 5ରେ ଆପଣ କିଛି ଲେଖିଲେନି ଆପଣ 6,60,000 କୋଉ ଦିନ ଦେଲେ ହେଲେ ଲେଖିଥାନ୍ତେ
ସବୁତକ ଦେଇଛି ଗୋଟେ tabular form ରେ
କରିବେ
ଦେଇଛି
କୁଆଡେ ଗଲା
third page ରେ
ସେଟା ମିଷ୍ଟର ପଲାଇକୁ ଦିଅନ୍ତୁ
ଦେଇସାରିଛି let him verify.
ଆପଣଙ୍କର କେବେ ଆପ୍ଲିକେସନ କେବେ ଫାଇଲ ହେଲା
Application ଟା your lordships The interim order was allowed.
application date ର ଆରମ୍ଭ କର
application date ଟା ତ court order କରିଦେଲେ ଯେ 3/9/2022 ରୁ
ନାଇଁ 3/9 କୋର୍ଟ କରିପାରିବେନି after Rajneesh versus Nya it has been that is now article 141 it has to be from date of application
13/9/2022 ରୁ order ହେଲା
39 ରେ ହଉଛି ଆପଣଙ୍କର application file ହେଲା 30
30/9/2022 ରୁ जो जजमेंट देले फाइनल जजमेंट टा ସେଥିରେ କହିଲେ 30/9/22 ରୁ ଆପଣ ପଇସା ଦେବେ ବୋଲି
30/9/22 ହେଇ परिबनी
हां इंटरिम ऑर्डर टा
application date ରୁ ହବ
इंटरिम ऑर्डर
केबे
यस इंटरिम ऑर्डर योर लॉर्डशिप विल सी
application ଟା केबे से फाइल करले वाइफ एटा को 125 ना 24 application
125
हां केबे फाइल होला
फाइल हला 10/2/2023 ରୁ
10/2/2023 डिस्पोज ऑफ केबे होला
नहीं सेही ऑर्डर रे देइथिले 20000 टंका लेखे हमको दवा पई ऑर्डर करथिले 10/2/2023 रे ऑर्डर रे एनेक्सचर 4
नहीं कंफ्यूज होंतुनी
मालो
आपण कीप इट सिंपल आपण 125 फाइल हैला 120 सीआरपीसी 10/2/23 रे
नो
ऑर्डर केबे कले
मिलॉर्ड द एप्लीकेशन आज इंडिकेट
आपण को प्रॉब्लम कोन होछ कि आपण डेट जगह अन्य कथा कहउछ
ना मिलॉर्ड
that leads to confusion
मालो
10/2/2023 रे एप्लीकेशन फाइल हैला
ना
केबे फाइल हैला
एप्लीकेशन फाइल हला 30/9/2022
30/9/22
आज्ञा
जजमेंट केबे हैला
आगो
10/2/2023
ना ना फाइनल जजमेंट आगो इंटरिम ऑर्डर हे
छाड़ दियंतु
आज्ञा
ମୁଁ ଯଦି ପଚାରୁଛି ଜଜମେଣ୍ଟ ଇଣ୍ଟରିମ୍ କହି କନଫ୍ୟୁଜନ ହଉଛି
नहीं जजमेंट
ଲେଖି ପକଉଛି ତାପରେ
जजमेंट होची 20/12/2025
20/12/2025
आज्ञा
अमाउंट केते हैला
कहले डेट ऑफ एप्लीकेशन रू 20,000 टंका लेखे दबो बोली
30/22 ରୁ 20,000 देबे
आज्ञा आज डेट रे आमे लास्ट डेट रे करथलु 43
30/22 ରୁ जो ऑर्डर हेची
आज्ञा
आपण केते लेखा दउतले 30/22 ପରେ
आमे आगो 15,000 दउथलु तापर 20,000 एबे देइछु
15,000 जो आगो दउतले आगोडा तारीखटा केते
आगो तारीख होची योर लॉर्डशिप फ्रॉम दी we have started paying as per the list 2nd March 2023 ru
15,000
in the page number 3 of the present affidavit today we have filed
ono 2nd March 2023 रे देले
3 रू आरंभ कली
125 रे ऑर्डर हेतिला
125 रे ऑर्डर हेतला इंटरिम रे ऑर्डर हला डेट ऑफ एप्लीकेशन रू एथिरे हला डेट ऑफ ऑर्डर रू इंटरिम
छाड़ दियो अमाउंट तो पैसा देइछले कहउछन
हां एबे जाय 6,60,000 टंका हम देइछु बोली गोटे देइछु एफिडेविट
एबे जाय फेरे कहले आपण जिते कहले एबे जाय सेबेठू आगो दिन
नहीं
तापरे
टोटल
किछि नहीं आया इट मेक्स नो सेंस
total
be specific about the dates
total we have paid
we saying that you have not paid but to make a sense आपण आगो दिन तापर दिन पछरु दिन
starting from March
2023 रे 15,000 दबा आरंभ कले that is your statement
आज्ञा we paid up to 3rd August 2024 15,000 thereafter we paid 20,000
आपण ऑर्डर केबे हला फर्स्ट ऑर्डर टा इंटरिम ऑर्डर हला
इंटरिम ऑर्डर मिलॉर्ड
ऑर्डर होइछ माइलॉर्ड 10/2/2023
10/2/2023
सिपे आपण 2-3 रे देले 15,000 दबा आरंभ कले
आज्ञा
तापर जजमेंट हैला आपणकर 20/12/2025 रे
आज्ञा
टिपिटु आपण 20,000 दउछत
हां
यस मिस्टर पलाई ही हैज बीन पेइंग
कंसल्ट पते इंस्ट्रक्शन ना मांगलो नै जो
तो भलो कथा आपण पैसा नेला पर इंस्ट्रक्शन नेबे से बहुत परिश्रम करी खोला तोड़ा करी बाहर कले केते पैसा देले आपण नै गला पर बहुत देते आपण जो गोटोटे मासे 50,000 काई दिछि ना आपण एमपी तले व्हाई यू आर फाइटिंग इट आउट
ମିଲଟ
15,000 କହିଲେ ଆପଣ 50,000
ନାଇଁ
ଦଉଛନ୍ତି
50 ଦେଇନୁ କୋଉଠି 30,000 ଗୋଟେ ଜାଗାରେ ଦେଇଛୁ ଆଉ ତାପରେ 20,000 ଲେଖେ ଦେଇଛୁ
ତାହେଲେ ଆପଣ
ନାଇଁ,
କରୁଛନ୍ତି
30,000
ସେପ୍ଟେମ୍ବର 24 ଦେଖନ୍ତୁ
ସେପ୍ଟେମ୍ବର
4 ସେପ୍ଟେମ୍ବର 24
ହଁ 20,000 ଦେଲୁ ଆଉ ଗୋଟେ 30,000 ଦେଲୁ ସେତେବେଳକୁ ଏ ଯୋଉ 15,000 ଟଙ୍କା ଆମାଉଣ୍ଟଟା ଆମେ ଦଉଥିଲୁ କୋର୍ଟ ଆକ୍ଚୁଆଲି କରିଥିଲେ 20,000 ଟଙ୍କା ଲେଖେ ଇଣ୍ଟରିମ୍
ତେଣୁ ଆପଣ 50 କାହିଁକି ଦେଲେ
ଆମେ 15,000 ଟଙ୍କା ଦେଉଥିଲୁ ସେ ଯୋଉ ଡିଫରେନ୍ସିଆଲ ଆମାଉଣ୍ଟଟା ଥିଲା କୋର୍ଟ ଯେହେତୁ 20,000 କହିଥିଲେ ଆମେ ଗୋଟେ ଏଠି ଫାଇଲ କରିଥିଲୁ ଇଣ୍ଟରିମ୍ ଏଗେନଷ୍ଟରେ which was rejected ultimately court has passed the order
Hard Learned Counsel for the petitioner, the Learned Counsel files affidavit dated 22/4/2026. Copy of the affidavit has been served on Mr. S.R. Polai, appearing on behalf of Mr. Parija for the petitioner. कितने नंबर आइटम?
No.
RPFM
এটা
67
তাহলে ଆପଣ ডিলিট ହେଇଗଲା ପରେ ଅର୍ଡରଟା କରିବେ 64 ରେ ନୁହଁ 67 ରେ କରିବେ it is submitted by the learned counsel for the petitioner also relying on the table annexed to the affidavit table supported by the affidavit that the application seeking maintenance under section 125 of CRPC was filed by the wife in the marriage on 30/9/2022. It was disposed of by judgment dated 20/12/2025. Prior to disposal on 20/12/2025, there was interim direction for payment of maintenance. Stop. Referring to the table annexed to the affidavit, as well as supported by affidavit, he submits that from starting with 2 March 2023 up to 15 December 2025, total ଜାଣି ପାରିଲେନି
total 6,60,000 paragraph 5
6,60,000 has been paid. ଆପଣ କେତେ ଚାହୁଁଛନ୍ତି ଦବା ପାଇଁ
15,000
15 ଦେବା ପାଇଁ ଚାହୁଁଛନ୍ତି the petitioner shall the bond କେବେଠୁ କଲେ
ଡିସେମ୍ବର ରୁ ହିଁ ବନ୍ଦ ଅଛି
the petitioner shall deposit the arrear from for the months of January to May 5 মাস at the rate of 15,000 without prejudice to his rights and contentions. In the present petition, rupees 75,000 shall be deposited by এটা কাজী ক্ষেত্রে 20 তারিখ by June 25
yes your lordship
June 25 ଆପଣଙ୍କ 10 ତାରିଖ ସୁଦ୍ଧା ଦେବା କଥା
ନାଇଁ 30 ତାରିଖ ସୁଦ୍ଧା କହିଥିଲେ
ମାନେ କୋଉ ମାସର 30 ଟା କେବେ ଦେବେ ଧରନ୍ତୁ ମେ ମାସରେ ଦେବେ ମାନେ ମେ 30 ସୁଦ୍ଧା କୋଉ ଏପ୍ରିଲ ମାସର ନା ମେ ମାସର
30/5 ମାନେ ହଉଛି 30
ସେଟା maybe you are not I am also I cannot understand.
yes
ତ ଛାଡି ଦିଅନ୍ତୁ ସେ 75 ଦିଅନ୍ତୁ and he shall continue to pay the amount of rupees 15,000 per month during pendency of this petition without prejudice to his rights and contentions. The wife in the marriage shall continue to receive the amount without prejudice to her rights and contentions in the present petition as well as number ta author kuhuntu
RPFM 94
as well as RPFM 94 of 2026
for filing of the enhancement for enhancement of the
2026 both the matters shall be listed together in the week commencing 6/7/2026
my lord reduce the
reduce କରିନି
ହେଲେ 20,000
20,000 ଟା ଯେହେତୁ ସେ 15,000 ଆପଣ ନବା କଥା 6,60,000 ଦେଇଛନ୍ତି so he is a bona fide litigant
my lord 20,000 my lord 20,000 direction was
ଆପଣ
given
15,000 ନେବେ ନା ନାହିଁ କୁହନ୍ତୁ ମୁଁ ମନା କରିଦେବି ଦବା ପାଇଁ
my lord
ଆପଣ ବର୍ତ୍ତମାନ 15,000 ଟଙ୍କା ନେବେ without prejudice to your rights and contention ଆପଣ 5,000 ବାକି ରହିଲା ତାଙ୍କର 5,000 ବାକି ରହିଲା without prejudice to 5,000 ଦେବେ without prejudice କାରଣ ସେ deny ବି କରୁନାହାନ୍ତି I am strict when somebody is denying and not paying. Because also consider ଆପଣ ଯେତେଟା ଜାଗାରେ appear କରିଛନ୍ତି husband ପାଇଁ and ଦେଇନାହାନ୍ତି ପଇସା have I entered it?
no my lord
ଆପଣ ତ appear କରୁଛନ୍ତି Mr. Polai Palay is today smiling, but he never smiles like this.
Another court that my lord.
Sir Palay never smiles. He will say that I'm so poor and I'm completely.
My lord, I pray reopening of the debt, my lord. Our admission ଟା ହେଇନି ତ RPFM ଟା ସେଠି. Just
ଆପଣ ତା ବି ଶୁଣୁନାହାନ୍ତି ଆପଣ ଯେତେବେଳେ ଡେରିରେ ଆସିବେ ଆଟଲିଷ୍ଟ ନହେଲେ ପଚାରି ଦେବେ. Both have been tied together and I have already said that without prejudice to your rights and contexts you are receiving that. ଏଇଟା ଆପଣଙ୍କର କଣ ଷ୍ଟକ୍ ମାର୍କେଟ ଇନଭେଷ୍ଟ କରିବେ ନା କଣ?
No, my lord.
Then this is not a matter ଯେ ଆପଣ ପଇସା ନେଇକି ହଜବେଣ୍ଡ କୋଠୁ ଷ୍ଟକ୍ ମାର୍କେଟ ଇନଭେଷ୍ଟ କରିବେ ତାପରେ ପଇସା ଆପଣଙ୍କର ବଢିଯିବ ସେମିତି ହବନି.
No, my lord. The
ଆପଣ
husband also
କ୍ରାଇଟେରିଆ ଅଛି
suppress
ଯୋଉ
the
କ୍ରାଇଟେରିଆ
material facts,
ଗୁଡାକ
my lord.
ଅଛି 10ଟା ଖଣ୍ଡେ ଲେଖା ହେଇଛି
My lord.
Delhi High Court judgment କହିବେ ସେଇଟା ସୁପ୍ରିମ reiterated in Rajneesh versus Neha ସେଇ କ୍ରାଇଟେରିଆ କିଏ କହୁଛନ୍ତି ଆମର ଇଣ୍ଟରନ୍ୟାସନାଲ ସ୍କୁଲରେ ପିଲା ପଢିବ ମୋର ଧରନ୍ତୁ ଆପଣ କହିବେ ଯେ ଆପଣଙ୍କର ଯୋଉ there are so many expenses possible expenses that cannot be a criteria.
My lord, Netherlands service କରୁଛନ୍ତି
Everything is on record.
Netherlands ତ ଆମର ବଢିଆ relationship ଏବେ ହେଇଛି.
Everything is on the
was he
record.
present? Find out whether he was present in that meeting and wave to yes. से कंटिन्यू करिवे 15000 देबे जहा एरियर अछि सब क्लियर कर
टोटल सर देइना दे जजमेंट पर टू देइना सर जजमेंट पर टू सर टोटल अमाउंट
डिसेंबर को देना 75 केमति होबो ताल 1575 सेमति हैला सेउडा आपण कहना आपण पे मिस्टर पोलाई भी किछि कहना कि चुपचाप चढ़ाई हसुछ
सर मु जस्ट विल पास ओवर करे जस्ट
नो एडवर्ट शट अप
माय लॉर्ड अजलर्स
ए कॉपी टा पाइछंती हो कॉपी ऑफ द एफिडेविट शॉर्ट कर दे
आई थिंक yes it's RPFM my lord RPFM copy may be sharp
लेबे
my lord
ठीक अछि the learned counsel for the opposite party request for another copy of the RPFM it shall be served it shall be आपण कोन return on serve ना कोन
my lord
notice टा कोन हैला what happened to the notice if notice is served on you how can a court direct again
notice not
served
so this served forfeit notice by one. Subsequently, a matter is listed. That's why the last occasion, Mr. Padavara appear. Notice ta sir painu. Learned Badal may
and
soft copy.
अपन एट रिसीव करिए
आगे
sir.
The office note indicated सुबह ऊपर लिखी दियो office note dated 5 नहीं 5 नो तब अपन सेटा चेंज करो तो ये फिक्स कंफ्यूजन 2026 5/8 तार कोन लिखा हो 8/5/2026 indicates that the notice issued to the opposite party has been returned unserved with postal report addressee left. The learned counsel for the petition opposite party shall receive the copy available in the registry that has been returned unserved.
RPFM may be corrected, Lordship, the already passed 94.
Already, yes.
Item 10.
Pass over करो
11.
May I please, your lords?
yes please Mr. Manoranjan Padi for the petitioner.
Well, yesterday, my lords, I filed the affidavit, my lords. Yes, I will pay total amount.
कोडे गला से affidavit affidavit टा आपण फाइल करछनी काली
Yes, sir.
कोडे गला से आछि देखिबे पासवर्ड करन देखन जदि आछि काली फाइल करछनी काउंटर
Yes, sir.
नंबर
Xerox टा ऑफिस को बिटा.
नहीं सेटा ठीक अछि कल तो इठिसी आसु आसु हेला 5टा ता परे आ
Sir.
रजिस्ट्री बंद हुए 5टा
Item 12.
बस पठे दो जस्ट वेट मिस्टर पाडी
Yes, sir.
अब पळेबे सेकंड हाफ रहिबे ना पळेबे
अच्छी अच्छी.
रहिबे
हाँ अच्छी फंक्शन अच्छी.
सकाळ has no impact on you
तेरे दबा नवा हो सर.
दबा न कल तो जे आपण जाई परिबेन बाबा
नहीं.
Well, Mr. Jaminikanta Das for the petition.
Yes, my lord.
Yes, please.
This case, your lordship wanted an affidavit to be filed by me, wherein I am to indicate as to when and how much I have paid to the opposite parties,
Yes, please.
as well as the copy of the order dated
The petitioner has liberty to file affidavit indicating details of amount paid pursuant to the direction of the learned family court, dates, manner of payment, and the amount that has been deposited. This is application under section 125.
yes, my lord.
So when the application was filed, sir? 11/7/18.
Yeah. And 26th day of
Judgment ହେଲା ଆପଣଙ୍କର 26/4/21.
ଆଜ୍ଞା
ଆପଣ ତ କିଛି ସେଥିରେ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ କି କିଛି ଏଭିଡେନ୍ସ ଦେଲେନି.
କିଛି ନଥିଲା ଆମର admittedly.
What can be done, sir? Revision ରେ କିଛି କରିହବନି.
I can pay two alternatives and it is up to your lordship.
No, it is not up to me. It's up to the law.
True that
Sit
is.
here
True that is.
by having fancied idea that
No. Your lordship is not going to ignore the law.
Because even if I have sympathy, I cannot reopen in revision.
No, I am not
It is
asking for
better
any
if it is
sympathy
stated
also.
before the Supreme Court where the party does chooses for some reason not to file evidence and not to file written statement and comes in revision. The Supreme Court is very clear that I cannot reopen the matter.
Correct, Nicholas. I'm not asking for reopening.
Yes, what do you want, sir?
But I'll suggest only two alternatives. The first being either your lordship to decide how much I am to pay, or in alternative, your lordship to direct the court below, wherein I am to appear and apprise the honorable court as to what amount exactly I am.
Both are not tenable in view of the law laid down by the apex court. I have to reject both.
But at the same time,
because the first question is impossible, second is also restrained by the court.
But the honorable court,
even because the language, have you checked the law?
yes, my lords.
What you have?
I have
Which case
judgment.
law?
That judgment that Rajnish versus Neha that I have brought.
Rajnish has not dealt. Revision has not been dealt by Rajnish.
No.
Rajnish has followed
ratio,
another case.
Yes, my lords. That ratio they have decided is I am liable to pay 1/4 of the
It's not-
salary.
you have, that's not the case. That is not on. That is by Honorable Justice Deepak Mishra.
Yes, my lords.
Rajnish has followed that. Samima Faruqi versus Sahid Khan on 125 CRPC, but there's the scope of ଏଠି ସବୁ ଥିଲା। ଏପଟେ ଗଲା ଲିଷ୍ଟ ଅନୁସାରେ ତ କିଛି ନାହିଁ ଏତେ। ନେଇକି ଆସନ୍ତୁ ସମୀମା ଫାରୁକ। ଆପଣ ଏଟା ଆସିକି ଦେଖୁନାହାନ୍ତି ବୋଧେ। ଏଟା এটা কোটা আরপিএফএম 116টা কি এটা এই ଆପଣ ଯୋଉଟା ଫାଇଲ କଲେ ସେଟା ଅର୍ଡରଟା କାଇଁ ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର
Is there, my lords.
ତାର କପିଟା ଦିଅନ୍ତୁ କପି କରିନାହାନ୍ତି ସିଆରଏଲଏମସି କଣ ଏଟା ହ୍ୱାଟ ଇଜ ଦିସ୍ ସିଆରଏଲଏମସି
CRMC is when they approach this honorable, they approach the honorable court for execution of the warrant against me,
Which warrant? Which case?
in the trial court, I mean,
Like who case? 125 or the ICC?
125.
125 warrant.
Yes. As against that, I immediately appeared, apprised the honorable court.
ଆପଣଙ୍କର due କେତେ ହେଲାଣି?
Due maybe
20 ଲକ୍ଷ?
16 point something habo.
16 ଲକ୍ଷ 2 ଲକ୍ଷ ଆପଣ ଦେଲେ କଣ? ଆପଣ ତ ଜୟ ବି କରୁନାହାନ୍ତି।
ନାଇଁ, more kindly see my salary slip, my lords.
Sir, ସେଟା ମୁଁ ଦେଖି ପାରିବିନି। ଆପଣ ପଢିଲେ ବୁଝା। The problem is that when you do not read and insist the court to believe you, so that is the problem.
No,
ଆପଣ ଏଟା 20ଟା ପଢନ୍ତୁ। ଆପଣ ବିଲକୁଲ ଦେଖିଲେନି। I made my best effort that so that we can read that judgment. The scope of preference. ସେ ଆଜ୍ଞା warrant issue ନଥିଲେ ସେ ଆପଣଙ୍କୁ ବି ପଚାରିବେନି। He doesn't care for the court. He doesn't appear. He does not file written statement. He doesn't file adduce evidence.
The reason I
have one copy. Upon read it aloud.
In the instant case, as is seen, the Honorable High Court has reduced the amount of maintenance to 4,000 to 2,000. As manifest, the High Court has become oblivious of the fact that she has to stay on her own. Needless to say, the order of the Law and Family Court is not mainly manifestly perverse.
Say that is slowly photo. Those are the 5 criteria they have laid down.
There is nothing
manifest perverse. First, second.
That is nothing perceptible which would show that order of the statutory of errors. In fact, when the order is passed on proper appreciation of evidence on record, or the revisional court should have interfered.
One second. I'm so sorry. Arbitrariness. Second, something perceptible should be there to say that it is a sanctuary of errors. Please kindly read.
Or different or another conclusion. When the substantial justice has been done, there is no reason to interfere.
So now the second problem is that I have to say, first, I have to say that it is manifest.
Correct.
Sanctuary of errors. That is
substantial justice.
Substantial justice has been done. Interesting.
Yes, sir. There may be a shelter over her head on the parental house, but other real expenses cannot be ignored solely because the husband had retired. There is no justification to reduce the maintenance by 50%. It is not a huge fortune that the shower on wife and
ଏଠି କେତେ ଟଙ୍କା ଆଜ୍ଞା ଏଠି କେତେ ଟଙ୍କା ସେ ଦେଇଛନ୍ତି
30,000
30,000
ମୋ ଦରମା ହଉଛି 12,000
ସୋ ଆପଣ ଦରମା 12,000 ଆପଣ କୋର୍ଟ ଆପଣ ଘରକୁ ଯିବେ କି ଯେ ସାର୍ ଆପଣଙ୍କୁ ମୁଁ ଅର୍ଡର ପାସ୍ କରିଥାନ୍ତି ଆପଣ ଦେଇଥାନ୍ତେ ମେଣ୍ଟେନାନ୍ସ କେତେ ଆଜ୍ଞା ପାଉଛନ୍ତି if I can pass those kind of orders then it is possible ଆପଣ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କରିବେନି ତାପରେ ଓକିଲଙ୍କୁ ବ୍ଲେମ କରିବେ ପ୍ରାୟତଃ ସମସ୍ତେ ଏଇଟା ଗୋଟେ ହେଇଯାଇଛି ଯେ ମତେ ଲାଗେ ଓକିଲ ବି ମେଣ୍ଟେନାନ୍ସ ଫାଇଲ କରିବେ କାଲି ଗୋଟେ କହିଲେ ଯାଜପୁରରେ କହିଲେ ଆଜ୍ଞା ସେ ଓକିଲ ମୋ କଥା ଶୁଣୁନାହାନ୍ତି I was narrating a story when I was visiting the district court.
Yes.
ସେ ଭଳିଆ ସେ ଆପଣଙ୍କର ବେଲ୍ ଜମ୍ପ ଗୋଟେ ନାହିଁ କି ଏଠି ତ ବେଲ୍ ଜମ୍ପ ହେଇପାରିବନି ଓକିଲ କରିବେ କ'ଣ ଯେତେବେଳେ that is a pan India phenomena. Not responding to the lawyer, brief ଧରି ଦେଇ ତାପରେ ପଳେଇବେ କୁଆଡେ ଗଲେ ସେ ଆଉ ଆସିବେନି. There are some videos also in some other places western India ରେ ଗୋଟେ ଦିଟା state ରେ ସେଟା ମଝିରେ ଆସିଥିଲା. ବର୍ତ୍ତମାନ ହେଲା ଯେ ଓକିଲ କିଛି କଲେନି. ଓକିଲଙ୍କ can a lawyer prevent you from filing this state?
No. Of course not.
Cannot. ତାପରଟା ପଢନ୍ତୁ sir. ଆପଣଙ୍କର ଯୋଉ ପ୍ରେୟାରଟା ସେଟା ସେକେଣ୍ଡ ଅଫିସର ସେ ଡିଲ୍ କରୁଛନ୍ତି ଅନରେବଲ ଜଷ୍ଟିସ ମିଶ୍ର the way he writes he has dealt it.
Next paragraph. Having stated the principle, we would have proceeded to record our consequential.
The High Court cannot interfere because the High Court will arrive at a different conclusion.
Yes.
That they have said. Kindly read that. So that you are suggesting to me to do.
But a significant one, we cannot be oblivious of the assertions made by the appellant.
Yes.
In this, and this has been asserted by the respondent had taken voluntary retirement after judgment dated 17/2/12 with the purpose of escaping the liability or to pay the maintenance amount as directed by the directed to the petitioner. That the last drawn salary of the respondent taken into account by the Law and Family Judge was 17,564 as per salary slip of May 2009, and after deduction of AFPP fund and AGI, the salary of the respondent was 12,564, and hence, even on the basis of the last basic pay.
Sir, about 20 days, sir. In fact, when the order is based on proper appreciation of evidence, for 20% appreciation of evidence on record, no revisional court should have interfered with the reason on the basis that it would have arrived at a different or another conclusion.
Yes.
That is a great, that's a huge limitation put by the, and this principle is revisional jurisdiction, old principle. It's nothing new. But the way the Lordship Justice Mishra writes, he has written it in his own way. He has presented it very beautifully rather. So that I cannot do. And already they have said the non-application of mind by the High Court has reduced, High Court has reduced by, so same thing will happen to me if it is challenged in the Supreme Court.
No, may I
you have to think that whether Order 9 Rule 13, because my discussion with you, all of you, the bar, Order 9 Rule 13 is not applicable in case of a 125.
Correct.
But for modification in 125, you can find there is a provision. Which provision? 125.3. 4. Okay? 127. Yes, thank you. Already there is a provision. That you can avail. Because you are saying, you have a genuine case that your income is 12,000 and it is 30,000. So 127 coil alteration in allowance. One, on proof of change in the circumstances. Yes.
I mean,
Yeah. What is it? Same product. So how correct stuff.
you follow the county. Let's look at it.
But problem is the party, the person should cooperate with the lawyer. To file a 127 now, filing a 127 can be ground to say something. But they are going to say total के तो 16 लाख कुछ.
हाँ.
2 लाख 2 लाख
Already paid.
High Court कहले NBW against. So that cannot be counted as also.
Correct.
So यदि से आओ 5-7 लाख टका देबे then कुहंतु so that you can file 127. And after you deposit that, maybe I will direct that you file 127, that at least the court will wait for that, consider the same.
Let me take instruction in that case.
But you are na?
Yes, you want.
ଆପଣଙ୍କ client have ଆସିବେନି.
ନାଇଁ
ଆପଣ ଯୋଉଦିନ ପଚାରିବେ ଆଜ୍ଞା କି ଆପଣ କିଛି ଲିଟିଲ୍ ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କଲେନି ପଇସା ଦେଲେନି
ମୁଁ ସେଟା କହିଛି ନା already. Right from the beginning, I have already disclosed that.
So he should respect the lawyer at least.
Obviously.
He should have cooperated in the proceeding. I don't believe Mr. Knowing the person, the way it has been conducted, most likely the 12,000 is after, sir. Perhaps he thought that if I go to the court, usually it is a guesswork. Of course, I can't be sure, or even remotely I can't be sure also. But say ଭାବିଲେ ମୁଁ କୋର୍ଟ ଗଲେ ମତେ ତ ପଚାରିବେ କେତେ ତମ ସାଲାରୀ କେତେ ତେଣୁ ମୁଁ ଆଉ ଯିବିନି।
ଆମେ ତ କହିପାରୁନୁ କୋର୍ଟ ଗଲେ କଣ ହବ ଆଉ ସିଏ କଣ ହାଉ କ୍ୟାନ୍ ହି
ପରସେପସନ ନାହିଁ।
perception is blind.
ଗୋଟେ ସର୍ଭିସ ମ୍ୟାଟରରେ ଜଣେ କହିଲେ ମତେ ମୁଁ ଯିବିନି କୋର୍ଟ। He made way back in 25. I said that is not possible. You ମାନ ଅଭିମାନ କଲେ ହବନି ଆପଣ ଯାହା କହିବା କଥା ଯାଇକି କୁହନ୍ତୁ। ସେମିତି ତ କେତେ ଜଣ ଲୋକ
It has to be ventilated.
Something should be told to
Yes,
the
yes.
side. And why the lawyer will prevent the party from filing written statement and adducing evidence?
Or even cross-examining.
Of course.
Or even cross-examining.
Exactly. And how the lawyer will function? It is his profession.
Correct.
The counsel for the petitioner submits that affidavit, they files affidavit sworn to by the petitioner herein, dated 18/5/2026, wherein the following has been stated. Paragraph 1. He refers to the say order ta feridele. Okay? Order ta kode hala? To highlight ଆପଣ ପାଖରେ ଅଛି?
ନାଇଁ ଦିଲ୍ଲୀ ପ୍ରାଣ।
ଭିତରେ ପଶିଗଲା। କପି ନାହିଁ
ଅଛି।
He refers to the order passed by the Lord at so and so, wherein it has been recorded that as a condition for
last page
non-execution of the NBW, the amount of 2 lakh has been deposited. এটা ଖୋଜିବେ ସେଠି ପଶି ଯାଇଥିବ ଗୋଟେ ଉଠିଲା ପରେ ଖୋଜିଦେବେ କାଳେ ମିଶି ଯାଇଥିବ ସେ ଆପଣଙ୍କୁ ଏଟା ଫେରେଇ ଦେବେ ଟାଇପ କରିଦିଅନ୍ତୁ ହେଲା ଅର୍ଡର ଡେଟେଡ 23/3/2026 passed in CR.P. number 178/2021 by the Lord Judge Family Court.
Yes, Barampur
is the produced hearing. The relevant portion content. It is the extract actually. It's not a order, it's the extract. A tick mark or pencil. The affidavit filed by the petitioner is taken on record, scanned copy be updated. The counsel for the petitioner has adjournment to obtain instruction, further instruction that how much the petitioner can deposit before the learned executing court without prejudice to his rights and contentions.
Maybe 15-20 days. 20 days, you'll also say 3 weeks.
And if you advise the petitioner shall deposit the amount within
After reopening, that will be proper. The courts will not
deposit
function.
amount by 19/6/2026. So, the proof of deposit and orders, if any, that would be passed by the Learned Judge Family Court shall be produced before this court. The matter shall be listed for fresh admission in the week commencing. For orders in the week commencing 6/7/2026. IE 173 of 2026. Notice issue in.
Yes,
notice issue ହେଇଛି
ନାଇଁ ହେଇନି।
ଆଚ୍ଛା ଆଗ ତାହେଲେ ଏଥିରେ ଲିଖିବେ issue notice to the opposite party along with the copy of the order dated 1/5/2026 and copy of today's order by speed post with registration and proof of delivery. Requisites for issuance of notice will be filed within 3 working days. Returnable date be fixed to date college? Returnable date be fixed to 29/6/2026. The matter shall be listed. 30/6 the matter shall be listed in the week commencing 6/7/2026. সেটা adjust হয়ে গেল তাহলে IA 173 of 2026. The IA has been filed 173. A hard noted counsel for the petitioner, the reiterates his submissions as noted above. But issue notice as above, accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. Para. In view of the statement made on behalf of the petitioner that he will deposit further amount by amount fix kariba, but upon problem hela upon par instruction nahi. Again he will be a defaulter.
No chance of default.
Kete tanga se debe kochon?
Sei kotha mu pacharibi tike better hobo.
Phone kari pachari paribe? Time to mu fix kar deli.
I'll call him.
Okay.
From Puri, I'll call him.
ତାଙ୍କୁ କୁହନ୍ତୁ ସେ ଆହୁରି 2 ଲକ୍ଷ ଟଙ୍କା ଦେଇଛନ୍ତି ନା ଆହୁରି 5 ଲକ୍ଷ ଦିଅନ୍ତୁ ତାଙ୍କୁ ଟକ୍ ଟୁ କୋର୍ଟ ଇନସିଷ୍ଟ କରୁଛନ୍ତି 5 ଲକ୍ଷ
କହିବି
ଡେଟ୍ ଟା ଆମାଉଣ୍ଟ ଟା ଫିକ୍ସ କରିଦେବା he has undertaken ଉପରେ ବି ଲେଖିଦେବେ ସେଟା in view of the statement made on behalf of the petitioner upon instruction by the learned counsel that he shall deposit amount of rupees dash by date କେବେ କହିଲି
वो कौन सी 6
date ଟା ଆଉ ଗୋଟେ କହିଛି 25 ନା କେବେ ଗୋଟେ କହିଛି 30 returnable date ଟା deposit କେବେ କରିବ
30 returnable date 30 କହିଛନ୍ତି
deposit date ଗୋଟେ କହିଛି by
6-7 ଆପଣ ଡେଟ୍ ଫିକ୍ସ କରିଛନ୍ତି
by 25/6 the further proceeding before the learned judge family court in the execution ଟା କେତେ जानना नंबर जानना थी
अच्छे
बोलते से ऑर्डर लिखा है ऑर्डर का देखो
178/21
in the execution case arising out of CR.P. number 178 of 2021 shall be adjourned to a date beyond 13/7/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. कोनोडा पिटिशन देबे से आर्जन करिवे
आज्ञा
यस
होता है तो इस वजह से
harassment. Yes, next.
Item 13.
May it please your lordship. My lords, I am appearing on behalf of Mr. Sanapati, my lords.
Yes. He's there. He's there.
Yes. My lords, mediation is still pending. Posted to 19/6. There are two cases, my lords. One I am praying for transfer, that is CP 84. Another is divorce petition filed by the wife, where, my lords, mediation failed in the meantime. And, my lords, these peculiar, the better circumstances is, my lords, the mother and the child is staying with me in the Bhubaneswar house. So there is possibilities of settlement only with regard to quantum of maintenance. The residential expenses and the expenses of the school of schooling expense education has been paid by the husband, who is petitioner before your lordship. So, my lords, on 19/6, we are expecting that there will be a positive result. Otherwise, my lords, on the reopening, this case can be disposed of.
The mediation is pending and it is expected. ठीक है.
Yes.
So, Prabhu Prasanna Behra, along with Mr. Lambit Senapati for the petition, opposite party black. Pursuant to the order dated 1/5/2026, the learned Judge Family Court Hon'Ble has furnished this report has for Hon'Ble by letter dated 15/5/2026 addressed to the registry of this court has intimated the status of the mediation, which discloses the following. Hence, it is respectfully submitted to Neki information of the Honorable Court. Stop. Mr. Behra, learned counsel for the petitioner submits that there is every possibility of the parties agreeing for the settlement, agreeing for a mediated settlement acceptable to both the parties. The matter may be adjourned. Stop. Accordingly, the matter shall be listed for fresh admission or for orders. For orders in the week commencing 6-7.
I'm grateful, madam.
Yes.
14.
May I please?
Yes, please. So J.K. Ponda for the petitioner. Yes.
And the petitioner is the wife.
Yes.
The petitioner has filed this application praying inter alia for transfer of CP case from the court of learned judge family court judge Rayagada to the court of Korapur.
How many cases she has filed against the husband?
Only one case, the only dowry case. I have understand dowry case.
Okay, so is there any provision in statute or any case law that where the wife files the 498 case, all the cases has to follow her to her place? Any case law?
Any case law? Wife
examine that.
Wife.
Your submission is contrary to the case law as well as this wife's convenience. If you are citing, I don't know what case law you will cite, but I have to read and understand. I am yet to come across any such case law that wherever the wife files criminal case against the husband's case has to go there. Because you see that he's the criminal case, wife is a witness. She's not prosecuting the matter.
Here in this case, wife is the petitioner.
Wife is the petitioner in what case? Why she wants transfer?
She is staying at Damanjodi.
But she herself files the application, then she.
No. The wife has not filed. Husband has filed.
Why you are saying she is the petitioner?
No.
I understood you correctly. Apna FIR 498 करचंती case का husband. ଆପଣ କହୁଛନ୍ତି ଯୋଉଠି 498 ହବ
ମୁଁ ଡାଇଭର୍ସ କେସ୍ ଟା ଟ୍ରାନ୍ସଫର करे କହୁଛି
ଆରେ ଡାଇଭର୍ସ କେସ୍ କିଏ କରିଛନ୍ତି?
ହଜବେଣ୍ଡ କରିଛନ୍ତି ରାୟଗଡା।
ହଁ ସେଟା କୋଉ ପ୍ରୋଭିଜନ କୋଉ ଆପଣ ଏଟା କୋଉଥିରେ ଫାଇଲ କଲେ? which provision ଏଟା ଫାଇଲ କରୁଛନ୍ତି ଟ୍ରାନ୍ସଫରଟା section 24 CPC. Kindly look at section 9 of CPC. Hindu Marriage Act section 17, Family Courts Act section 7. By which provision this court can direct that जो 498 wife करिवे सेठी हबो?
The Supreme Court decision.
Who does Supreme Court decision? देबे ना?
That is not with me, but the wife's convenience is to be seen.
पढ़ले से decision टा पढ़िचंदी?
ଆଜି ପଢିନି।
केबे पढ़थिले?
2 years back.
को paragraph?
से
पूराटा पढ़िबे? Aishwarya versus Sarvada, that what is CVK or something, Aishwarya versus Sarvada. There the context, the Supreme Court has said something else. And also with that you read...
Madam, I may pardon, Aishwarya?
NCV Aishwarya versus A Sarvada, because it's difficult to remember the whole name. AR achi the citation. AR 2022 Supreme Court.
AR 2022 Supreme Court.
That is against you.
Already. I will examine.
ଆପଣ problem କଣ ହେଲା ଯେ ଆପଣ ସେଟାକୁ ଆଣିକି ଆ ଭିତରେ ଭର୍ତ୍ତି କରିଦେଲେ criminal. How there will be a simultaneous trial before the family court of a criminal trial and criminal trial you are not a party, you are a witness.
That is against me.
That decision you are citing, everyone is citing. But if you read the decision, that is not the proposition of law. That never said that joti husband nair family nair 498 case or city of trial.
And the wife is staying at Damanjodi. The husband,
Wherever stay, seta apanakara CPC re nahi. Then you have to find a citation where it says wherever the wife stays, there will be the husband's case has to go there. Aishwarya filed a case in Chennai for section 9 and 125. Sarvana filed section 13 at Vellore. The Supreme Court, and interestingly, the Madras High Court rejected the transfer application. Then Supreme Court says that since the wife has filed a section 9 application and 125 at Chennai, so this family court Chennai should try both the cases. I will direct family court Damanjodi to try 498.
498 STM.
ଆପଣ ଆଜି ସେଦିନ ଯୋଉ 2 ବର୍ଷ ତଳେ ପଢିଥିଲେ ଗୋଟେ ଦୃଷ୍ଟିରୁ ଭଲ ହେଇଛି. Otherwise you would have cited and along with that read Queen versus Latham.
My lord.
Queen Quinn versus Latham.
Versus
Latham LEATHEM. ସେଟା ଯାହା ବି ଆମର ତ ଆମର ଓଡ଼ିଆରେ ଇଂଲିଶ ଯାହା କହିପାରିବା ଯେତିକି Latham 1901 All England law reports or appeal cases.
All India?
All England law reports. Lord Halsbury. Appeal case रे विके बंदी सर कहले देख पढिया पे ताका पर appeal case रखछन्ती अछि appeal case भी अछि बोधे 1900 appeal cases जो Halsbury's laws of England नहीं की. So he has said that when you are citing a decision, how it is the authority on what it decides, not logically what follows from it. Because it's a difficult proposition. That's a husband's right to file a case is also extenuated by that because wife has filed 498 case against him. And both cases cannot be tried together. And she at best can be a witness. So wherever the witness stays, there will be the case will be filed there. That cannot be also. Next.
I pay notice.
No, notice ହେଇପାରିବନି. Dismiss ହେଇପାରିବ. Because I will rely on Aishwarya and Sarvana and dismiss it. And you are too senior not to read Aishwarya and because I have also worked and learned from you also.
छुट्टी पर आसुना
Mr. Ponda wanted that you did not he met me on the road. He said that you did not inform me, I would have traveled with you. So that remains still unfulfilled.
छुट्टी पर
We are preserving all our energy to be energized by him during the vacation. He is a fantastic host.
ସବୁଆଡେ ଆগে ଆଟାକ ହଉ ଶୀଘ୍ର ପଳେଇବା 3 ନମ୍ବର 24 ହିଁ ପଳେଇବା 6
J.K. Ponda for the petitioner. The petitioner, I'll continue after recess. 3টা ବେଳେ କହୁଛନ୍ତି 3ଟା ବେଳେ Mr. ପଢାପଢି କରିବାକୁ ସମୟ ଲାଗିବ କହୁଛନ୍ତି Mr. Ponnai କହିଲେ ଯେ
I have a small prayer subject to your lordship.
Yes.
Item 21.
Yes.
Where has it been listed under orders for vacation of the state? Also, may recall that whether the major gals are entitled or not.
Yes.
It was in fact supposed to be listed under fresh admission because point and everything.
ଯଦି IA ଥିବ notice ହେଇଥିବ
IA for vacation of the state.
It has to come in orders.
That's a fantastic
Listed
trick.
correctly.
That's a fantastic trick to avoid.
Nature of litigation is that even fresh and orders matters are being heard, like Mr. Ponda.
More of the orders.
I'll pass that order, Mr. Ponda, after I return. That is submission that wherever you have filed 498A, the CO or the husband CP should be taken up there.
ଡେଟ୍ ଟା ଖାଲି ଜାଣି
ଆପଣ କରିଦିଅନ୍ତୁ କେବେ କହୁନାହାନ୍ତି କେବେ କହିବେ we commencing 13/7 for fresh admission. Yes.
Oh blessed.
ଏ 21 ଟା ଟିକେ ଛୁଟି ପରେ ଆସୁ
କେବେ 21 ଟା କେବେ
reopening week ରେ ଆସୁ because the
29 ଆପଣ ଲିଷ୍ଟ ଦେଇନାହାନ୍ତି 29 ଟା 125 ଟା ହେଇଛି it has reached 130.
नहीं, because of the
ସେଇ week ରେ of course. ଠିକ ଅଛି।
girls
କେତେ କୁହନ୍ତୁ କେବେ 29
as fresh admission.
Yes.
Because my order is there that
49, sir. Procedure is.
under fresh admission.
49
I guess.
Because my lord, I have,
Mr. Pushpi ସେ କଣ disposal ହେଇଯିବ?
I am from the wife.
Yes.
I have examined as DW1.
Yes.
But I want to adduce further evidence to my father as DW2. That application has been rejected.
So
I have filed already evidence.
Ms. Kavi is saying that she is agreeing, the opposite party is agreeing for that prayer.
Yes, your lordship.
DW2 examine କରିବେ?
ମୁଁ DW2 କୁ ମୋ ବାପଙ୍କୁ ଏକ୍ସାମିନ କରିବି।
କରିବେ ଯଦି ସେ ରାଜି ଅଛନ୍ତି।
ସିଏ ଅପୋଜ କଲେ ଯାହା ଫଳରେ କି ଲର୍ଣ୍ଣ
ନାଇଁ ସେ ବର୍ତ୍ତମାନ କହୁଛନ୍ତି ଯେ that
Yes, your lordship, there is already a speedy disposal order by the different the transfer
Coordinate
case.
bench.
Yes, your lordship.
by the coordinate bench in transfer application.
Yes, your lordship. So for the speedy disposal, it is already there. This will only linger the case. So that is why we are praying that it may be allowed.
So,
Matter is
I'll
listed.
not record our concession, but I'll record that that it can be your father will be examined as DW2. Okay.
Your lordship, my only prayer is it matter is listed before the Honorable Family Court on the reopening day 17/6. So the evidence
Just
may
one second, 17/6.
17/6, the reopening day of the court below.
Yes.
So the matter may be taken up on that day. The evidence may be adduced on the same date and for the expeditious.
I will say that the parties will remain present. The court may
Yes,
proceed or they can fix a date.
Yes, your lords. And for the expeditious disposal.
affidavit only to cross-examine on that very particular.
Yes.
I will be remain
Because
present.
I do not know. If you read that judgment, that court has said that we do not know how the court is functioning, but we are passing so many orders.
Your
The
lordship.
Allahabad Bar Association, the Supreme Court has expressed concern regarding that. हमको दिनो हमको केस नेबे. How do we know that किसी दिन कौन केस अछि कौन नहीं? So
Your lordship, the matter is pending for
correct.
last
17/6
argument.
Yes, yes. But आपण वर्तमान examination ପରେ argument हवा.
Yes, sir. Argument from the side of the petition is already done, but now it will be taken up. Sir, argument. 17/6 only for the expeditious disposal. Sir, that which we
I'll
bring.
pass orders.
Is parties to cooperate for the expeditious disposal.
That I'll pass.
Oh, blessed.
Definitely.
Oh, blessed. Much blessed.
So rest of the matters after recess ଆପଣଙ୍କର ସେଠି ଯିବାକୁ ପଡିବ. ଦେଖିବା ଦେଖିବା. Yes.
The password. Password item 10.
Yes, Mr. Singh.
My lord.
You want adjournment after vacation, you said?
No, my lord. I want to take for this matter, my lord.
The Niranjan Singh for the petitioner.
As per your lordship's,
Yes.
as per your lordship's direction, I have already filed the affidavit, my lord. And I have paid up to 23rd August 2025. But from since 23rd September 25 till today, about 9 months, I have not paid
So you
the,
paid that 9 months?
my lord.
Why you have stated? The problem is that you write an essay on this. A simple one-line affidavit is converted to essay which does not make any sense.
I have given the
Or date of order केबे थिला? जो remuneration slip टाको आपण कोन ये करथिले?
मैं ଦେଇଛି ଆଜ୍ଞା।
सेटा exhibit mark ହେଇଥିଲା?
ଏକ୍ଜିଟ୍ ମାର୍କ ହେଇଥିଲା ଆଜ୍ଞା।
କେତେ number exhibit?
3600 ଟଙ୍କା ଯେତେବେଳେ ପାଉଥିଲେ ସେତେବେଳେ ଏକ୍ଜିଟ୍ ମାର୍କ ହେଇଥିଲା।
କେତେ number exhibit ସେଟା? जो adjustment किए कला IA 39-117 who has adjusted that?
Family court man.
I could not follow you actually. When you are yourself, your client is confused, you are confused, and you confuse the judge also. ଆପଣ କହୁଛନ୍ତି କଣ actually? I could not follow. ଆପଣ judgment କେବେ ହେଲା? Order କେବେ ହେଲା?
କହୁଛୁ।
9/1/2026 9/2026 ନା କେତେ? ମୁଁ ଭୁଲ ଫାଇଲ କରୁଛି। ଠିକ ଅଛି ତ ଠିକ ଫାଇଲ ଅଛି। 9/1/2026 ରେ ଆପଣଙ୍କ ଜଜମେଣ୍ଟ ହେଲା। ଡାଇରେକ୍ସନ କଣ ହେଲା?
ଏଇଥିରେ ଯୋଉ ଡାଇରେକ୍ସନ ହେଲା ଏଥିରେ କୁହାଗଲା ଯେ ତାକୁ ଏନହାନ୍ସ ରେଟରେ ଦେବା ପାଇଁ। पेज 33 रे
इन्वेस्टमेंट କାହିଁକି ହେଲା? କଣ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ କଣ ଦେଇଥିଲେ?
ଆମେ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଥିଲୁ ଯେ ମୋର ମନ୍ଥଲି 5265 ଟଙ୍କା ପାଉ।
ଏଠି ସ୍ପିଚ୍ ଦେବେ ନା ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଲେଖାଟା ସେଠି ଦେବେ?
Your lordship, turn to page 20, my lord.
28, 29, 28 page, paragraph 3.
ଆଚ୍ଛା 5200
ଆପଣ 19 ମସିହାରେ 5253 ପାଉଥିଲେ?
ନାଇଁ ସେ 3600 ଟଙ୍କା ସେଟା ରଙ୍ଗ ଲେଖା ହେଇଛି ଆଜ୍ଞା। 3600 ଟଙ୍କା ମୁଁ ପାଉଥିଲି 19 ମସିହାରେ 5000
ଏକ୍ସାମିନ କଲେ ଯେ ସାର୍ଟିଫିକେଟ ଦେଇଛନ୍ତି ତାକୁ ଏକ୍ସାମିନ କଲେ
ହଁ ସାର୍ ସାର୍ଟିଫିକେଟ
ଆପଣ ତ ମିନିମମ ୱେଜ ରୁ କମ ପାଉଛନ୍ତି
ଆଜ୍ଞା।
ଇଲିଗାଲ ଇଲିଗାଲ ସେଟା
ସାର୍ ମୁଁ ଦେଇଛି
ଆପଣଙ୍କୁ ଧରନ୍ତୁ ମୁଁ ଏନଗେଜ କଲି ଆପଣଙ୍କ ଆସି ମୋ ପାଖରେ କାମ କଲେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ମୁଁ ତାକୁ ଦିନକୁ 2 ଟଙ୍କା ଲେଖାଏଁ ଦେଲି ତ 60 ଟଙ୍କା ଲେଖାଏଁ ସାର୍ଟିଫିକେଟ ନେଇକି କୋର୍ଟରେ ପ୍ରଡ୍ୟୁସ କରିବେ whereas the minimum prescribed wage is now 500 rupees
that should be
ଆପଣଙ୍କର ମୂଲିଆ ମଜୁରୀ ବର୍ତ୍ତମାନ ଆପଣ କିଛି ପାଉନାହାନ୍ତି ବୋଲି ସାର୍ଟିଫିକେଟ ଦେବାରେ କଣ ଥିଲା ଆପଣ ଡେଲି ୱେଜ ହିସାବ ହବ ତାହେଲେ
sir page 36 your lordship can
ଆପଣଙ୍କର
count
daily wage ରେ ହିସାବ
page
କରୁଛି
30
କିଛି ପେଜ 36 କଣ କହୁଛନ୍ତି ଆପଣ ବୁଝିପାରୁଛନ୍ତି
ଆଜ୍ଞା
I will read the judgment ଯିଏ କିଛି କରିପାରୁନାହାନ୍ତି କହୁଛନ୍ତି ଯେ ମୁଁ ଦେଇପାରିବିନି ସେ ତାଙ୍କର ଡେଲି ୱେଜ ହିସାବରେ ହିସାବ କରିକି ଦେବେ ଯେତିକି ପଇସା ହବ ଆଉ ଡେଲି ୱେଜ ହିସାବ କଲେ ଆପଣଙ୍କର ବର୍ତ୍ତମାନ 500 ଟଙ୍କା ହେଲେ 15000 ଟଙ୍କା 15000 ଟଙ୍କାରେ ଆପଣ 5000 ଟଙ୍କା ଦଉଛନ୍ତି ଆଉ କଣ
ନାଇଁ ଆଜ୍ଞା ମୋର ଆଜ୍ଞା 4 ଆନେକ୍ସର 4 ପେଜ 36 ରେ ମୁଁ ଆଜ୍ଞା ଦେଇଛି
କିଛି
ଆଜ୍ଞା
ହବନି ସେଟା ହବନି
ସାର୍ ସେଇଥିରେ ମୁଁ ପାଉଛି ମୋର ତ ଅନ୍ୟ କିଛି ଇନକମ୍ ନାହିଁ
ଆପଣ
ସାର୍
କାମ କରିବେ ମୂଲିଆ କାମ କରିବେ
ସାର୍,
ଡେଲି
ମୂଲିଆ
ୱେଜ ରେ
କାମ-
ଆପଣ କରିବେ ଦ୍ୟାଟ ଇଜ ଦ ଲ
ନାଇଁ ସାର୍
ସାର୍ ଏଥିରେ କଣ କରିବେ ମୁଁ ତ ପଇସା ଦେବିନି ନା ଆପଣଙ୍କୁ
ନାଇଁ ସାର୍
ସେଥିପାଇଁ ମୁଁ ଏକ୍ସାମ୍ପଲ ଦେଲି
ଆଜ୍ଞା
ଏଥିରେ ମୁଁ କଣ କରିପାରିବି
ସାର୍,
ଆପଣ କାମ କରିବେନି ଯଦି
ସାର୍ ମୋର ଆଜ୍ଞା ମୁଁ ଆଜ୍ଞା କଣ୍ଟାକ୍ଚୁଆଲ ଆର୍ଟ ଟିଚର ଆଜ୍ଞା ଭିଜୁଆଲ ଆର୍ଟ ଟିଚର ଆଜ୍ଞା ଆନେକ୍ସର
ସେଇଟା ଆପଣ 10 ଥର କହିଲେ ମୁଁ ଟିକେ ଫାଷ୍ଟର ଆପଣଙ୍କୁ ପଢେ ଆପଣ ସେଟା କହିଛନ୍ତି ଆପଣ ମୋ ପାଖରେ କାମ କଲେ ଆପଣଙ୍କୁ ମୁଁ ଦିନକୁ 2 ଟଙ୍କା ଲେଖାଏଁ ମାସକୁ 60 ଟଙ୍କା ଦେଲି ଆପଣ ସେଟା ଏଭିଡେନ୍ସ ଦେଲେ ଟ୍ରାଏଲ କୋର୍ଟରେ ଜଣେ ଜଜ୍ କି ଫ୍ୟାମିଲି କୋର୍ଟରେ କହିଲେ ସେ ଏମଏସ୍ ସାଙ୍ଗ ପାଖରେ କାମ କରୁଛନ୍ତି 60 ଟଙ୍କା ପାଉଛନ୍ତି ତେଣୁ ତାଙ୍କୁ ସେ କିଛି ପଇସା ଦେଇପାରିବେ ତ ଇଜ ଇଟ୍ ଏ ଟେନେବଲ ଏଭିଡେନ୍ସ
ସାର୍ ଆମେ ସେଇଟାକୁ ସାର୍ ଦେଇଥିଲୁ ଯେତେବେଳେ 185 ଫାଇଲ ହେଲା ସେତେବେଳେ ଆମେ ଦେଇଥିଲୁ ସେତେବେଳେ ଆମେ 3600
ପ୍ରଡ୍ୟୁସ
ଟଙ୍କା
କଲେନି ଯିଏ ଆପଣ ପଇସା ଦଉଛନ୍ତି ତାକୁ ପ୍ରଡ୍ୟୁସ କଲେନି
ପ୍ରଡ୍ୟୁସ କରିଛୁ ସାର୍ ଆମେ
ଆପଣ ତ ଦେଖିବେନି ଜଜମେଣ୍ଟଟା ଆପଣ ତାକୁ ୱିଟନେସ୍ ଆଣିଥିଲେ ଯିଏ ଆପଣ ଦରମା ଦଉନାହାନ୍ତି ଆପଣଙ୍କୁ ଆପଣ ଯୋଉଠି କାମ କରିକି ଦରମା ପାଉନାହାନ୍ତି ତାକୁ ପ୍ରଡ୍ୟୁସ କଲେନି ଯେ ସେ କାମ କରନ୍ତି କିଛି ପଇସା ପାଆନ୍ତିନି
ନାଇଁ ସାର୍ ମୁଁ ସେ ପାଉଛି
କୋଉଠି ଆଜ୍ଞା ଆର୍ଟ ଟିଚରଙ୍କର ପଇସା ଆଜ୍ଞା ଦିନକୁ 20 ଟଙ୍କା
ସାର୍ ଏଇଟା ସମସ୍ତ
200 ଟଙ୍କା
ଅଲ୍ ଓଭର ଓଡ଼ିଶା ସାର୍ ଅଲ୍ ଓଭର ଓଡ଼ିଶାରେ
ଅଲ ଓଭର ଓଡିଶାରେ ସେ ତାହେଲେ ବାହାବାର ନଥିଲା
ତା ପୂର୍ବରୁ ବାହା ହେଇଯାଇଥିଲେ
ଆଉ କଣ କରାଯିବ
ତା ପୂର୍ବରୁ ବାହା ହେଇଯାଇଥିଲେ
କାହିଁ ବାହା ହଉଥିଲେ ବାହା ହେଇକି ସେ ଏଭିଡେନ୍ସ କାହିଁକି ଦଉଥିଲେ ନିଜ ଏଗେନ୍ଷ୍ଟରେ ଆପଣଙ୍କର ଏଇ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ଇଟ୍ ହାଜ ବିନ୍ କନସିଡର୍ଡ ବାଇ ଦ ସୁପ୍ରିମ କୋର୍ଟ ବୋଥ ମାନେ ସମୀମା ଫାରୁକି ରଜନୀଶ ନାୟକ and so many decisions that if a person says that I am incapable of earning ଆପଣ ସେଟା ପ୍ରୁଭ କରିବାକୁ ପଡିବ ଯେ ଆପଣଙ୍କ ଆର୍ଟ କଲେ ଆପଣଙ୍କର କିଛି ହବନି
ଯେତେବେଳେ ପ୍ରଥମ ଅର୍ଡର ପାସ୍ କଲେ 3600 ତାପରେ ଆନେକ୍ସର
ଆପଣଙ୍କର
ଫାଇଲ କଲି ତା ପର
ପ୍ରୋବ୍ଲେମ ହେଲା you are as confused as the art yourself you are making ଆପଣଙ୍କ ଜଜମେଣ୍ଟ ହେଲା ପରଠୁ ଆପଣ କୋଉ ଦିନ କଣ ଦଉଛନ୍ତି କିଛି ଲେଖି ନାହାନ୍ତି ଆପଣ ଦେଖିଛନ୍ତି ସେ ଆଫିଡେଭିଟ
ସାର୍ ମୁଁ ଦେଇ ସାର୍ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛି ଷ୍ଟେଟମେଣ୍ଟ 1 ରେ ଦେଇଛି
ସାର୍ ଟିକେ ଦେଖନ୍ତୁ ପାରାଗ୍ରାଫ ପେଜ 60 ଦେଖନ୍ତୁ ଆନେକ୍ସର 5 ସିରିଜ କଣ ଲେଖିଲେ କହିଲେ 28/15 20/10/15 ତାପରେ 21 ମସିହା ଆପଣଙ୍କର ଜଜମେଣ୍ଟ ହେଲାଣି କହୁଛନ୍ତି କେତେ
ସାର୍ ତାପରେ ସାର୍ ଗୋଟେ ଦେଇଛି ସାର୍
ତାପରେ ଫେର ଦେଇଛନ୍ତି
ହଁ ସାର୍ ତାପରେ ଦେଇଛି ଆଜ୍ଞା
ତାପରେ କଣ ଦେଲେ
ତାପରେ ଷ୍ଟେଟମେଣ୍ଟ 2 ରେ ଦେଇଛି
ଆପଣ ଏରିଆ ପୁରା ପଇସାଟା ଦିଅନ୍ତୁ ତାପରେ
ସାର୍ ଷ୍ଟେଟମେଣ୍ଟ
ଚାକିରି ରିଜାଇନ କରନ୍ତୁ
ସାର୍ ଷ୍ଟେଟମେଣ୍ଟ
କାମ କରନ୍ତୁ କାମ କରିକି ପଇସା ରୋଜଗାର କରନ୍ତୁ ନିଜ ପାଇଁ 18000 ଟଙ୍କା ମାସକୁ ମିଳିବ 5000 ଟଙ୍କା ତାଙ୍କୁ ଦିଅନ୍ତୁ 5 ନା 3000 ଟଙ୍କା ଏବେ ହେଇଛି
ନାଇଁ ଏବେ 7000 ଟଙ୍କା ହେଇଛି
7000 ଟଙ୍କା ଦିଅନ୍ତୁ ବାକି 9000 ଟଙ୍କା ଆପଣ ରଖନ୍ତୁ
କାମ ମିଳିବ ତ କରିବି ସାର୍ କାମ ତ ମିଳିବ ଆଜ୍ଞା ସାର୍
କାମ ମିଳିଯିବ ମନରେଗାରେ ମିଳିବ ଯୋଉଠି ଚାହିଁବେ ମିଳିବ
ସାର୍ ମୋର ସାର୍ ଷ୍ଟେଟମେଣ୍ଟ ପେଜ 30
କିନ୍ତୁ ଆପଣଙ୍କର ଆପଣ ଯଦି କୋର୍ଟରେ ପ୍ରେୟାର କରିଥାନ୍ତେ ମତେ କାମ ଦିଅନ୍ତୁ ଅଲଗା ହେଇଥାନ୍ତା ଆପଣ ଯେହେତୁ କହୁଛନ୍ତି ଦ୍ୟାଟ୍ସ ଆନ୍ସର ଟୁ ୟୁ
नो सर सॉरी सर
ନାଇଁ ନାଇଁ why you should be sorry for that thing
सर ମୁଁ ଦେଇ ସାର୍ ମୋର ଷ୍ଟେଟମେଣ୍ଟ 2 ରେ ଦେଇଛି ଷ୍ଟେଟମେଣ୍ଟ 2 ରେ ଅପ୍ ଟୁ ଅଗଷ୍ଟ 2025 ପର୍ଯ୍ୟନ୍ତ ଦେଇଛି ସାର୍
ଆରେ ସେଟା ପେଜ ଟା ଦେଖେଇବେ ନା ଷ୍ଟେଟମେଣ୍ଟ ଟୁ କହିବେ
पेज 32
ଆଫିଡେଭିଟ କୋଉ ପେଜ
32 ମାଇଲର पेज 33 ମାଇଲର
କୋଉ ଦିନର ଆଫିଡେଭିଟ ସେଇଟା
ଏଇ ଯୋଉ ଆଫିଡେଭିଟ ଦେଇଛି ଡେ ବିଫୋର ଷ୍ଟୋରେ ଦେଇଛି ସେଥିରେ ଦେଇଛି ଷ୍ଟେଟମେଣ୍ଟ 2 ରେ ଦେଇଛି ଆଜ୍ଞା पेज 33 ଆଜ୍ଞା
33
हाँ सर
कौन 33 ଆପଣ ଏଠି ଏଗୁଡ଼ା କଣ ଫାଇଲ କରିଛନ୍ତି ଏଠି
सर सब मनी रिसीट फाइल करते
अरे मनी रिसीट फाइल कले आपण मनी रिसीट मु पढिया पे आपण कहथिन ना आपण लिस्ट करबा पे कहथिन
टू प्रूव दी टू प्रूव
अरे आपण को दिन कोन पैसा देले सेटा आपण तो लिखिबे
सर मु लिखी सर
स्टेटमेंट देखा तो को पेज रे
स्टेटमेंट लिखी सर 32 लिखी सर
କୋଉ ଦିନ ଆପଣ କଣ CRP ଲେଖିଲେ 23/2022 12 ମାସ କଣ ତା ଅର୍ଥ କଣ? What do you mean by that? ଆପଣଙ୍କୁ କୁହାଲା କୋଉ ଦିନ କେତେ ପଇସା ଦେଲେ ଲେଖିବେ?
सर लिखी ता पर कलम छा लिखी सर कॉपी अटैच कर दी सर 36 12 मास
ଆରେ
सीआरपी
କୋଉ ଦିନ ଆପଣ ଦେଲେ କେମିତି ଜାଣିବି ମୁଁ?
सर कोर्ट रो ऑर्डर सर ता तो दे छी
ଆରେ
11
date of payment ଲେଖିବେ ନା
23
କୋର୍ଟ ଦେଖିବେ?
सर 11/2/23 रे कोर्ट ऑर्डर
ଆପଣଙ୍କର କେସ୍ କରିବାର ଇଚ୍ଛା ନାହିଁ।
सर 11/2/23 रे कोर्ट ऑर्डर टा देछि कोर्ट रे आगे ऑर्डर टा देछि
ଆଜ୍ଞା ଆପଣ ଡେଟ୍ ଟା କହିଲେ କୋର୍ଟ ଅର୍ଡର କହିବେ।
सर 11/2/23
ଆରେ ଆପଣ ଡେଟ୍ କହିବେ ନା କହିବେନି କହିଲେ?
हां सर
ହଁ ଆପଣ 20,000 ଟଙ୍କା କୋଉ ଦିନ 36,000 ଟଙ୍କା କୋଉ ଦିନ ଦେଲେ?
से 6/4/23 रे 10,000 टका
ଉଫ୍।
29/3/22 रे 5,000
ଆଜ୍ଞା ଆପଣ ଲେଖିଛନ୍ତି 2022 କିନ୍ତୁ ଆପଣ 12 months ଲେଖିଲେ ଡେଟ୍ ଲେଖି ନାହାନ୍ତି। The learned counsel for the petitioner refers to the page 32 of the statement 2 which does not disclose the date of payment, amount of payment and mode of payment.
कॉपी ऑफ द ऑर्डर से पेमेंट से फुल पेमेंट
ଆଜ୍ଞା ଆପଣ ଡେଟ୍ ଟା କହିବେ ନା। ନା ଆପଣ ପଖାଳ ଖାଇଛନ୍ତି ମୁଁ ପଖାଳ ଖାଇଛି ଆମେ କହିବାନି ଡେଟ୍ ଆଜି କଥାବାର୍ତ୍ତା ହବାନି।
नहीं सर
ଆପଣ 36,000 ଟଙ୍କା କୋଉ ଦିନ ଦେଲେ ଡେଟ୍ କିଏ କହିବ?
सर मु कहबी सर
କାହିଁ କହୁନାହାନ୍ତି?
सर मु कहली सर
ସାର୍ ମୁଁ ସାର୍ଙ୍କୁ କହିଛି ସାର୍ ଅର୍ଡର କରିଛି ସାର୍ କୋର୍ଟ କରିଛନ୍ତି ସାର୍ ସବୁ କଥା ଡେଟ୍ ଟା କହୁନାହାନ୍ତି।
पेज 35
I'm concerned whether you have filed receipt or not. I said that କୋଉ ଦିନ ଦେଲେ?
सर 7/9/22 से देछि गोटे
କଣ ଗୋଟେ ମୋ
तापरे
ଆପଣ ସେଟା କିଏ ଆପଣ ଏମିତି କହିବେ ଆପଣ ଲେଖିବେନି 7/9/22 ରେ ଦେଇଛି ଗୋଟେ। So who told you file affidavit of 35 pages? What was the necessity when you do not give the basic details?
सर देइ से तळु देइ
କହୁନାହାନ୍ତି ବର୍ତ୍ତମାନ ତିଆରି କରୁନାହାନ୍ତି। ଆରେ ତଳକୁ ମାନେ ଉପରକୁ ବର୍ତ୍ତମାନ କୁହନ୍ତୁ ଡେଟ୍ ଟା କୁହନ୍ତୁ।
सर प्रथम टारे जे देइ छे प्रथम
ଆପଣ ଗୋଟେ କାଗଜ ଲେଖି ଦେଲେ 36,000 କୋଉ ତାଙ୍କୁ ସାର୍ଙ୍କୁ ଦେଲେ ଗୋଟେ କାଗଜ 36,000 କୋଉ ଦିନ ଦେଲେ? ଆପଣ ପାଇବେନି ଛାଡ଼ନ୍ତୁ। After hearing the learned counsel for the some time for about 20 minutes regarding the amount paid, the date of order, the amount paid, mode of payment.
सर भाई कैश से
He refers to paragraph ଆପଣଙ୍କ କ୍ୟାश ଦେଲେ କଣ କଲେ that is not
मनी रिसीव जे तळे रखी
सर ସେଟା କୋର୍ଟରେ ପ୍ରଡ୍ୟୁସ କରିବେ ମୁଁ ଏଠି ଆପଣଙ୍କର ଗୁମାସ୍ତା ନୁହଁ।
नो सर
ସେ ଯୋଉ ମନି ରିସିପ୍ଟ ଟା କୋର୍ଟରେ ଫାଇଲ କରିଥାନ୍ତେ ମନି ରିସିପ୍ଟ ଟା କୋର୍ଟରେ ଆପଣ ଅର୍ଡର ହେଇଥାନ୍ତେ।
सर कोर्ट रे ही देछि कोर्ट रे ऑर्डर करछि कोर्ट ऑर्डर रे 11/2/23 रे
କୋର୍ଟ ଅର୍ଡର
11/2/23 ରେ ଟୋଟାल
ଆପଣ ଟିକେ ଗପିବା ବନ୍ଦ କରନ୍ତୁ କଥା କହିବା ବନ୍ଦ କରନ୍ତୁ। କୋର୍ଟରେ ଯୋଉ ଅର୍ଡର ରେ ଆପଣଙ୍କ ପେମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି ସେଟା ଦେଖାନ୍ତୁ ଷ୍ଟ୍ରେଟ୍ ଆଣ୍ଡ ଗो ଟୁ ଦ୍ୟାଟ ପେଜ ଆପଣଙ୍କୁ ପାରି ହବନି।
सर सर 33
ଆରେ ସାର୍ ଛାଡ଼ନ୍ତୁ କୋର୍ଟରେ ଯୋଉ ପେମେଣ୍ଟ କଲେ ଅର୍ଡର ଆପଣ ମନି ରିସିପ୍ଟ ଦେଲେ ଅର୍ଡର ହେଇଗଲା
आज्ञा
ହଁ ସେ ଅର୍ଡରଟା ଦେଖାନ୍ତୁ।
that order I will produce my lord because say
What is
page
this
order
thought
9
going on,
sir
sir?
एठे 11/2/23
Sir, whatever ଆପଣ କଣ you are in a different world. ଆପଣଙ୍କୁ ମୁଁ ଗୋଟେ ଜିନିଷ 20 ମିନିଟ୍ ମତେ ଲାଗିଲା କହିବା ପାଇଁ ଯେ ଆପଣ କୋଉ ଦିନ ଦେଲେ କୁହନ୍ତୁ ତାପରେ କହିଲେ ଅର୍ଡର ଆଜ୍ଞା କୋର୍ଟରେ ହେଇଛି ତାପରେ କହିଲେ ଯେ ଆଜ୍ଞା ମନି ରିସିପ୍ଟ ଦେଇଛି ମୁଁ କଣ ଆପଣ ଗୁମାସ୍ତା ଚିଠା ରଖିବି?
sorry sir
I am also very sorry that ଆପଣ ନିଜେ କଣ କରୁଛନ୍ତି ନିଜେ ବୁଝି ପାରୁନାହାନ୍ତି not that ଯେ ଆପଣ ଦେଇନାହାନ୍ତି ବୋଲି କଣ ଦେଇଛି
I will produce
more than 20 minutes
produce the certified copy of that order
you whatever you do please you do but don't spoil time ଆପଣ ସମୟର ଅଭାବ ଅଛି ଆପଣ ସେଥିରେ ଗୋଟେ ଜିନିଷ ଆପଣଙ୍କୁ ଡେଟ୍ ପଚାରିଲେ ଆପଣ ଦେଇଛି ସାର୍ ଦେଖନ୍ତୁ ସାର୍ ଆରେ ଡେଟ୍ ଟା କୁହନ୍ତୁ ଦେଇଛି ସାର୍ ଆପଣଙ୍କ ଆନ୍ସର ଆରେ ଆପଣ ଡେଟ୍ ଟା ତ କହିବେ ନା ନାଇଁ କହିବେନି
sir
he refers to the affidavit marked at flag C which runs into pages which according to in considered view of the court is unnecessary and was not to be filed. The petitioner shall file an affidavit in one paragraph and one table indicating date of payment, amount paid and the mode of payment pursuant to the order passed by the learned judge family court, Bhadrak, in CRP number 185 of 2016, as well as CRP number 272 of 2022. No document which is not part of the record produced before the learned judge family court shall be filed before this court. In view of the fact that the present application is a revision application and no material other than that was before the learned trial court can be considered for considering the revision. It is submitted by the learned counsel for the petitioner that the learned judge family court has recorded the payments in the orders. Copy of such orders, if any, shall be filed along with the statement in one paragraph and one page indicated in a table. You have to command Mr. Singh. You have to call it is not that the client will come and deceive you. You have to tell him what you want. It's very simple. It cannot run into 33 pages. Why did you ask him for receipts? Is he paying you? He's paying the as per the court direction. If he has filed it in the court, court will record that. Upon receipt the or can you entertain these receipts also? Yes. Next. The matter shall be listed for fresh admission in the week commencing 6/7/2024. Yes, next.
Item 11.
May I please, my lord?
Yes.
Yes, I filed the affidavit, my lords. Last direct to file affidavit and my lords, I filed yesterday.
Table the
My lords?
ଆପଣ କୋଉ ଦିନ କେତେ ଟଙ୍କା କେମିତି ଦେଇଥିଲେ ସେଟା
No, my lords, total I have not paid.
So don't file that. Why you are filing affidavit? That will go against you.
20,000, my lords. Kindly see order, my lords order.
ଦିଅନ୍ତୁ. The Manoranjan Padi for the petitioner. The Lorded Counsel refers to the order dated 15/5/2026 passed by this court when the matter was had at some length and the 6 lakhs is 6,000.
The 6 lakhs is. Now, my lords, I will pay
ଆପଣ ସବୁଡା ଦେଇ ଦିଅନ୍ତୁ ଦେଲା ପରେ ଆସନ୍ତୁ
20,000.
नो ବାର୍ଗେନ୍ କରନ୍ତୁ
My lords,
54,000 ଟଙ୍କା ଏଠି ଆସି ହାଇକୋର୍ଟରେ ବାର୍ଗେନ୍ କରୁଛନ୍ତି
my lords.
ଆପଣଙ୍କ ଟୋଟାଲ ଡ୍ୟୁ ହେଉଛି 54,000 ଟଙ୍କା
My lords.
according to you. So you pay it and come.
My lord, I will pay 50%, my lords.
No.
Can you consider, my lords?
OTS ନୁହଁ ଆଜ୍ଞା ଏଠି OTS ହଉନି ଯେ ମୁଁ ଏଠି OTS କରିବି ଆପଣ 6,000 ଟଙ୍କା କାହାର ଦରକାର କୋର୍ଟ ଡିସାଇଡ୍ କରିବେ ତା ଦେହରେ ମୁଁ କମେଇବି ତାକୁ ଗୋଟେ ବେକାର ସମୟ ନଷ୍ଟ କରୁଛନ୍ତି ମିଷ୍ଟର ସିଂ ତାଙ୍କର କଣ ପଇସା ଦେଲେ ସେ କହିବେନି ଗଲା ଗୋଟେ
I am ready to pay. I am ready to pay.
I am also ready to pass order.
Some consider, my
deposit 54,000 ଟଙ୍କା ଏଠି ବାର୍ଗେନ୍ କରନ୍ତୁ don't make it ridiculous.
lords, direct to how much money, my lords?
ଟୋଟାଲ ଆମାଉଣ୍ଟ ଟା ଡିପୋଜିଟ୍ କରିକି ଆସନ୍ତୁ ଆପଣଙ୍କ ଦରମା 60,000 ଟଙ୍କା ଆପଣଙ୍କର ସେ ହିସାବ କରୁଛନ୍ତି
No, my lords, I am a contractual, my lord, just I am working as a supervisor, my lords. Now my job is already, my lords.
ସେଟା କୋର୍ଟରେ ସେଟା କହିଥାନ୍ତେ must understand.
କହିଛି, my lord.
Did you read the judgment ସୋମିମା ଫାରୁକି?
Yes, my lord.
ଏଠି ପଖାଳ ବାଢିବା ଛଡା ସେ କାମ ବି କରନ୍ତୁ that will help you in your profession. ଆପଣ ଗୋଟେ ଟ୍ରାଏଲ କୋର୍ଟ ଜଣେ ଏକ୍ସାମିନ କରିକି 6,000 ଟଙ୍କା ଦେଲେ 6,000 ଟଙ୍କା ଜଣେ କେମିତି ଚଳିବ?
I am
still then
daily worker, my lord.
ଆପଣ ଟୋଟାଲ ଦିଅନ୍ତୁ ଆପଣ 6,000 ଟଙ୍କା ଦିଆଯିବ ଟୋଟାଲ ପଇସା ଡିପୋଜିଟ୍ କରନ୍ତୁ ବାକି ପଇସା ଫ୍ରି ଏଠି ରହିବ କୋର୍ଟରେ 6,000 ଟଙ୍କାରେ ଆପଣ ଚଳିବେ
My income is very low, my lord. So
ଆପଣଙ୍କୁ 6,000 ଟଙ୍କା ଦେଲେ ଇନକମ୍ ଲୋରେ ଆପଣ ଯାହା ଇନକମ୍ କରୁଛନ୍ତି ଡିପୋଜିଟ୍ କରିଦିଅନ୍ତୁ 6,000 ଟଙ୍କା ଆପଣଙ୍କୁ ଦିଆଯିବ ଚଳିପାରିବେ? These things are not to be bargained, Mr. Padi. The petitioner files affidavit indicating that he has paid only 20,000 out of the said the total amount. He shall make good the amount, rest of the amount of rupees 34,000. କେତେ ହେଲା total? 54 କୋଡ଼ିଏ ଦେଇଛନ୍ତି।
କୋଡ଼ିଏ ଦେବି my lord. ଦେବି yes my lord.
ଦେବେ ବୋଲି ଆପଣ କିଏ କହିବ ସେଥିପାଇଁ? ମତେ କାଇଁ ପଚାରୁଛନ୍ତି ଦବା ପାଇଁ? ମୁଁ ରଖିବି। The total amount shall be ଆପଣ ସେଇପାଇଁ ମନା କଲେ affidavit file କରନ୍ତୁ। I'll pass orders that you will deposit the entire amount there. ଆପଣ କରିପାରିବେନି ଯଦି you will be misunderstood.
Next sir, after vacation my lord, I will deposit the 20,000. Thereafter I will
20,000.
Thereafter
The entire amount 54,000 shall be deposited before the learned judge family court. Pursuant to judgment dated 23/2026 for sustaining challenge to the said order in the present revision application. ଆପଣ ଏବେ ଧାର ନେଇକି ଡିପୋଜିଟ୍ କରନ୍ତୁ ତାପରେ କେସ୍ ଜିତିଲା ପରେ ପାଇଯିବେ ସବୁ।
वो सर दे देगी आसिबी सब केस 20,000 डिपोजिट करी नेक्स्ट वैकेशन पर आसु
नहीं नहीं
आई विल फाइल ऑल द डॉक्यूमेंट
54,000 टका ଆପଣ ଏଠି 15 ଲକ୍ଷ ଟଙ୍କା ବାର୍ଗେନ୍ ଆପଣ 54,000 ବି ବାର୍ଗେନ୍ କରିବେ।
डेली वर्कर
पर ସେଥିପାଇଁ ହିସାବ କରାହେଇଛି ଡେଲି ୱାର୍କର ହେଲେ ଆପଣଙ୍କ ପାଖାପାଖି 8,000 ଟଙ୍କା ହବ।
माय पेरेंट्स इज रिजाइडिंग विथ
ପ୍ୟାରେଣ୍ଟସ୍ ଆପଣଙ୍କ ଉପରେ କଣ ଆପଣ ପ୍ୟାରେଣ୍ଟସ୍କୁ ପୋଷି ପାରିବେ? ଆପଣଙ୍କ ନିଜର କିଛି ନାହିଁ ଆପଣ ପ୍ରଧାନ ପ୍ୟାରେଣ୍ଟସ୍ଙ୍କ ଦ୍ୱାରା ପୋଷା ହେବେ। ପ୍ୟାରେଣ୍ଟସ୍ଙ୍କ କଥା ଛାଡନ୍ତୁ ପ୍ୟାରେଣ୍ଟସ୍କୁ ତାଙ୍କ ଫ୍ୟାକ୍ଟରି ଛାଡି ଦିଅନ୍ତୁ। ଏ ଯୋଉ କଥା ଗୁଡା କହୁଛନ୍ତି ଏଗୁଡା କୋଉଠି କହିଛନ୍ତି ଡେଲି ପ୍ୟାରେଣ୍ଟସ୍ ଦେଖାନ୍ତୁ
यस माय
statement ଦେଖାନ୍ତୁ
यस
how it has been dealt with.
My written objection my lords, I find my mother is a heart patient my lords.
अरे हार्ट पेशेंट नो आपणकर डेली वेजर आपणकर मदर को काम करी पैसा देबे कि आपनको?
नो
मदर को ट्रीटमेंट फ्री रे हबो। ओडिसा रे आपण कोन करि परिबे? ओडिसा रे एवरी ट्रीटमेंट इज फ्री सिंस लॉन्ग। नहीं किसी
अच्छा अच्छा
पेज 33 35 पढ़ो बेकार वेस्टेज ऑफ टाइम। कौन लिखिलो? For sustaining challenge the matter the deposit shall be made by
मेरे साहब 31 रे लिखी H that and the pertinent to mention
ଆପଣ
that
ना नदी राउत
minute
ଆପଣଙ୍କ ନାଁ କଣ? ବାବାଜୀ ରାଉତ
बापूजी राउत
କଣ ଏଭିଡେନ୍ସ କଣ ଦେଲେ ତାପରେ ସେଥିରେ କୋର୍ଟର ଫାଇଣ୍ଡ ଆପଣ ଷ୍ଟେଟମେଣ୍ଟ କଣ ଦେଲେ ଯୋଉ ଡବ୍ଲ୍ୟୁଏସ୍ କଣ ଡବ୍ଲ୍ୟୁଏସ୍ ଏଟା ଦେଲେ
WS ଦେଲେ
ଏକ୍ସାମିନେସନ ଇନ ଚିଫ
examination chief sir ସେଟା ଦେ
ବଟ୍ ଏନିୱେ ଆପଣଙ୍କ ଡେଲି ୱେଜ୍ ହିସାବରେ ତ କମ ଅଛି ସେଥିରେ କଣ ଅସୁବିଧା ଅଛି କି? ଆପଣ ଯଦି ଡେଲି ୱେଜ୍ କାମ କରିବେ ଯେତିକି ଟଙ୍କା ପାଇବେ ଇଫ୍ ୟୁ ଆର୍ ଏବଲ୍ ବଡିଡ୍ ପର୍ସନ 6,000 ଟଙ୍କା ଇଜ ଗୁଡ୍ ଏନଫ୍। ଲାଷ୍ଟ ଅଧିକା କରିପାରିବେନି।
ଲାଷ୍ଟ ଡାଇରେକ୍ଟ ଟୁ ପେ 4,000
ଦେଲେ ଆପଣ ଏଠି ବାର୍ଗେନ୍ ନ କରିକି 4,000 ଦେଲେନି ଯେତିକି ଏରିୟର ଥିଲା ଟୋଟାଲ ପେମେଣ୍ଟ କଲେନି। ଦ୍ୟାଟ୍ ୟୁ କ୍ୟାନଟ୍ ଟେଲ୍ ୟୁର କ୍ଲାଏଣ୍ଟ ବଟ୍ ହିୟର ୟୁ ୱିଲ୍ କମ୍ ଆଣ୍ଡ ବାର୍ଗେନ୍ ଫର୍ 2,000। 4,000 ଟଙ୍କା ହେଲେ ପୁରା ଏଣ୍ଟାୟାର ପିରିୟଡ କେବେ ପିଟିସନ ଫାଇଲ ହେଇଥିଲା?
ପିଟିସନ ମୋର ଫାଇଲ ହେଲା 4/8/25 4/8/25
4/8/25 ରୁ ଆପଣଙ୍କର 4/8
ଜଜମେଣ୍ଟ ହେଲା 23/3
4/8/25 ତାହେଲେ ଆପଣଙ୍କର ହଉଛି 8 ମାସ ଧରନ୍ତୁ 8 ମାସ 9 ମାସ ହଉଛି ଆପଣ ଟଙ୍କା ଡିପୋଜିଟ୍ କଲେନି? ହୁ ଟୋଲ୍ଡ ୟୁ ନଟ୍ ଟୁ ଡିପୋଜିଟ୍ 4,000 ଟଙ୍କା? The amount of 50,000 40,000 shall be deposited by କେବେ ଦେବେ?
1 month time
1 year ନେଇଯାଉନାହାନ୍ତି 1 month କାହିଁକି ନଉଛନ୍ତି?
20 days 20 days
shall be deposited within 2 weeks within 15 working days before the learned judge family court. The proof of such deposit shall be produced including order passed by the learned judge family court. Public voting season of the matter. The matter shall be listed for fresh admission in the week commencing 29/6/2026. Yes.
Item, miss case.
ଆପଣ ଦବାର ଥିଲେ 4,000 ଟଙ୍କା ଦେଇକି ଆସିଥାନ୍ତେ।
ଦେବି
ଦେଇକି ଆସନ୍ତୁ କାଲି କାଲି ମେନସନ କରନ୍ତୁ ଆଜି ଡିପୋଜିଟ୍ କରନ୍ତୁ ଫୋନରେ କହିକି 40,000 ଟଙ୍କା ଡିପୋଜିଟ୍ କରନ୍ତୁ କାଲି ମେନସନ କରିକି ଆଣନ୍ତୁ। Yes.
14.
Yeah?
14. Item 14.
None appears for the petitioner when the matter is called. ଡକା ହବ ଲିଷ୍ଟଟା କୋଉଠି ଗଲା? କଣ ଦରକାର? ଓ ଜେକେ ପଣ୍ଡା। Mr. J.K. Panda for the petitioner, opposite party black. The petitioner wife is before this court seeking transfer of the CP number 21 of 2026, passed by the Learned Judge Family Court, Rayagada. Seeking transfer of CP number is pending before the Learned Judge Family Court, Rayagada. The grounds for seeking transfer of the petition is that since the petitioner wife has lodged an FIR against the opposite party husband and his family members in Damonjodi PS case number 001 FIR number 0012 dated 10/2/2026 under section 85 115(2) 351(3) 3 into bracket 5 115 into bracket 2 351 into bracket 3 3 into bracket 5 read with section 4 of the Dowry Prohibition Act जोड़ा act जोड़ा लिखिले भारतीय नागरिक सुरक्षा संहिता 2023 and the case is pending trial before the court at Damonjodi at Koraput. Koraput. The CP filed by the husband under section 13 into bracket 1 into bracket Roman I-A then comma Roman I-small p should also be tried at Koraput. In response to the said proposition, Learned Counsel for the petitioner is apprised of the fact that for filing of a application under section 13 of the Hindu Marriage Act, the jurisdiction is conferred as provided in section 17 of the Hindu Marriage Act, section 9 of the CPC, and section 7 of the Family Courts Act. Further, the court at Koraput, that is Civil Judge Senior Division Koraput, cannot take up the CP as it would be without jurisdiction. No. The proposition that wherever the wife lodges FIR against the husband and his family, the CP, the proceeding has to be transferred to that particular jurisdiction, has to be supported by any provision or any case law. The Lorded Counsel for the petitioner has adjournment to address the matters shall be listed in the week commencing 6/7/2026.
Sorry, 13/7.
13/7, the week commencing 13/7/2026.
15.
My lord.
Yes,
my lord, on behalf of Mr. Ramesh Chandra Raut, my lord. My lord, the present petition files the writ petition challenging the impugned order Annexure 1 along with Annexure 2 and 5, my lord.
What is the Annexure 1 order?
Annexure 1 order is that the ESI, my lord, the opposite party number 3, the opposite party number 3, Deputy Director, Revenue, Rev 2, Employee State Insurance Corporation, my lord. Demanding, my lord, now demanding 3,13,814. The present petition for.
So why you are not moved in appeal to the
I have given, my lord.
Employee Insurance Code, you have moved.
Employees Insurance Code, I have given my lord, one second. I have given a representation to the director of the. I have given a representation under page 21, my lord, Annexure 4.
Representation, which provision of PSI you can make a representation?
There are, for which I am in hospital. For which
which provision, sir?
Under
which provision of PSI Act mandates that you will give a representation?
The section 45G of the PSI Act 1948. Order under appeal for withdrawal order under section 45G of the PSI Act 1948.
So unless the authority has power under the statute, is a statutory authority. So which provision you have invoked to make the representation?
Rather than
Okay.
in the meantime,
sir, what's your name?
Satyajit Raut.
Mr. Satyajit Raut on behalf of Ramesh Chandra Raut, or the petitioner. Yes, Mr. Ray.
No copy has not been sought. My lord also noted on 29th for that a copy has not.
I thought that your name is there, so but copy no dele kemti hobo?
Sir, I am not present.
Se bhi bujhu nahanti, apana bhi bujhibeni. Apana kahaku engage karibe
Next day,
bujhibeni.
Next date, my lord, I will represent. I will
think
produce the.
You must understand what you are arguing.
My lord, my lord.
45A, 45-0 remedy kona apana to
I will. Well,
Mr. Ray, but I mean it is time barred now.
My lord, I have not gone through.
Okay, see to dehi nahanti copy ho, theek achi. Sidhane kya appear kale? As directed by the order dated 29/4/2026, the copy of the application should have been served from the Lorded Standing Counsel. For the Lorded Counsel, for the petitioner submits that he shall serve copy today. Aji dei paribe?
By tomorrow.
By tomorrow.
Bus.
The matter shall be listed for fresh admission in the week commencing on 30/6/2026.
My lord.
Yes.
15.
16. Madam, your name is R. Singh.
Yes.
This is R. Singh for the petitioner. Yes.
7 affidavit file କରିବାକୁ କହିଥିଲେ ଆମେ already affidavit file ହେଇଛି।
Third learned counsel for the petitioner. Para 2 of order ticket 752026 I repeat करते हैं ହେଲା para in terms of the तापर लिखूं तो सब para the next para by the matter was earlier heard on 752026 and the following observations were made. Paragraph 4 टा quote कर देंगे तापर लिखिए the petitioner has filed affidavit dated 15/5/2026 which is on record. Paragraph 5, 6 and 7 are reproduced here. Para 5, 6, 7 तक पूरा reproduced है. अपन अच्छी flag B रे. Flag B page 1 and 2 इटा पुष्टा अच्छी 5, 6, 7. In view of the affidavit filed by the petitioner before this court that the petitioner shall appear, adduce her evidence, and shall cooperate in disposal of the in MAT case number 58 of 2023. The order dated 9/3/2026 passed by the learned civil judge into bracket senior division Sundargarh is modified to the extent that the court shall allow the petitioner to appear and render evidence, or evidence shall be entertained, and the matter shall proceed further after recording of evidence of the petitioner as undertaken. The petitioner shall appear before the learned judge. Next date की जानचंदी?
Yes, madam.
Date.
27/2026
पुढे रची?
नहीं मतलब से 1 तारिख रे टिके बाहर को जिबे तो से
या कोर्ट रे कोदिनो केस टा अछि बनाने. The petitioner shall appear before the learned judge, civil judge into bracket senior division Sundargarh on date न जानले मु कौन डायरेक्शन देबी? On the next date, the matter is posted. On the next date, inmate 58 of 2023 specified that it is posted. Or if the said is, or if the next date is later than 17 June 2026, the petitioner shall appear before the learned civil judge so and so, civil judge senior division Sundargarh on 18/6/2026, produce certified copy of this order along with the affidavit dated, along with copy of the affidavit dated 15/5/2026 for consideration of the learned court stuff. But the learned court shall proceed in accordance with law as directed by the order today. The petition is disposed of.
Yes.
ଆପଣ ଯେତେବେଳେ ଏ ପ୍ରକାର କେସ୍ କରୁଛନ୍ତି, you must know the date because I do not know what has happened. Yes.
Okay.
तो स्वाईଙ୍କୁ ପଚାରୁନାହାନ୍ତି ଫୋନରେ ସେ ଜାଣିଥିବେ କାଲି ମାନେ ଭିସିରେ appear କରୁଥିଲେ. If there is a specific date, it should be specific. Yes. ନା argument ହେଇ ସରିଗଲାଣି କେସ୍?
नहीं सर.
ସରିନି. ଠିକ ଅଛି.
17.
The Somnath Mishra for the petitioner. The petitioner is before this court Yes, Mr. Mr.
May please, Your Lord. My lord, the petitioner is having a manufacturing unit at
Is a proprietorship concern?
my lords.
Okay.
So proprietorship concern with manufacturing cable and conductors.
Mr. Raut thile pade polele. Actually, Mr. Raut jo case କରୁଛନ୍ତି ସେ କିଛି ବୁଝି ନାହାନ୍ତି ସେ ଆପଣ actually case present ରହିବାର ଥିଲା ପଳେଇଲେ ସେ କଣ କହୁଛନ୍ତି actually ସେ ବୁଝୁ ନାହାନ୍ତି so even if I try to give him hint what he wants ସେ କିଛି ବୁଝିଲେନି.
I was there.
Yes,
So here my lord, by Annexure 1, my lords, it was intimated to the Provident Fund Authority and as well as the ESI authority that the factory has been closed since March 2023. Annexure 1.
Yes.
Then Annexure 2 was issued by the ESI Corporation for omitted wages, my lord. Your lordship will find Annexure 2, page 13.
Yes.
This is ad hoc notice was issued to the petitioner. And my lord, so Annexure 3 was issued by the petitioner saying that it has been closed since March 2023. Now, I am challenging Annexure 4, the order passed under Section 45A, my lord. Your lordship may kindly see he has given 3 dates, but in all the dates, my lords, I have not been noticed. Though he has said that notice was issued, there is no, in the order, it is not there that I have received the copy of the notice. Your lordship may kindly see page 17, Annexure 4.
Yes.
In the said notice, principal, second paragraph, my lord.
Was afforded an opportunity.
Yes. Opportunity of personal hearing to represent his case on 18/11/25 and to submit his statement of contribution actually due as per their calculation. Whereas the employer did not reply to C18 notice dated so and so and also did not appear for the personal hearing to represent his case on 18/11. But for the sake of justice, another opportunity was given. The same fate, my lords. Notice was issued as per his writing. Issued but have not received, and in the meantime factory has been closed since 2023.
So here the statutory appeal will be a better opportunity or
that period has gone, 2 months has gone. So and again 25% is to be deposited. Here, my lord, my case, I'm a closed unit, my lord. I need not pay for some time. I'll have to pay some money if at all.
So total demand is now?
Now, my lord, it Annexure 4, it is 2,13,608. 2,13,608.
So 25% comes to 50,000.
50,000 pakapaki asibo. It is, had it been running unit, my lord, I have not said him to come here. It's a closed unit and we have intimated by the Annexure 1 and Annexure 3, your lordship will find, I have intimated that it has been closed.
And your case is that it is after that period of closure?
Yes. No, before closure is there. One period is before closure and another period is after closure. 25 days on demand closure.
But in one case, because the date of cause of action was not clear, that judgment I have pronounced.
But here only thing,
whether it will be challenged or
violation of natural.
I have said that that period of 3 years cannot be insisted because when the order was passed is not apparent. That earlier matter.
But in this case, 45A order was passed on
13/3/2026.
So here that question may
So
not
13/3, if it is passed, when it can be challenged?
within 3 years.
No, 3 years before the EI court, but 2 months before the appellate authority as your
authority.
So that 2 months I can extend?
No, I am not saying.
That cannot be my.
That cannot be because you are saying mandatory that Goy's India.
Yes. So as per that Provident Fund rules and all that, that's 60 days. And so here, my lords,
and if one does not move the appellate authority, can he not move the ESI code, EI code?
So yes, ESI code is always there, my lord.
3 years.
If one may not appear before the approach the authority,
yes,
he can approach the original court.
bypassing the appellate authority jurisdiction, I can come to the EI court. But here, my lords, it's a severe case.
Sir, ultimately, because you are disputing that, there are factual issues to be determined.
No, here
I think EI court will be a better court.
That if I go for disputing the amount and all those things. But here, my lords, I am disputing that I have not been noticed. The lordship says I have not.
You want a remand order?
Yes. I have not been noticed.
That way, they are also not prejudiced, you are saying.
Yes.
I have to take
instruction. No, in similar matters have been there, but after hearing that matter, regarding the 3 years and deposit. Of course, in that matter, the entire amount has been appropriated.
Appropriate he is. But here,
So in fact, after appropriation, he has come.
Acha.
So there is no question of depositing of 50% because 100% has been taken away.
Earlier,
73B, I think.
earlier in
73B, 50%.
2B.
73 2B.
75 2B.
75
2B.
to be earlier, my lords, 45 AA was not there in the statute. Appeal provision was not there. Anybody agreed by the order passed?
Was only remedy was 226.
Yes. No.
No, 75 of the Act.
EI code.
Okay.
And,
only High Court.
EI code. If there is
After amendment from
Only-
2010, 45 AA provision was.
your lordship entertaining writ application when it is violation of principle of nature.
Right.
That is
Correct,
the only
correct.
thing. Otherwise,
No. I have already, I have heard both of you on this.
Annexure 4 has to be stayed, no coercive action.
It's an appropriation which is नहीं.
नहीं.
Garnish order है.
Period ta dot expert recovery action है.
The petitioner is a proprietorship concern, Mr. Mishra.
Yes, sir.
Petitioner is a proprietorship concern. पूरा को what doubt हो पूरा लिखी दी. Engaged in. No, it's a private company. The petitioner is a
I'm sorry,
private
I'm so sorry, I'm
company registered under the
The
Companies
next
Act.
one is
Engaged in manufacturing of cables and conductor at Industrial Estate Jharsuguda
yes.
and was covered under the ESI Act. It is before this, by filing the writ application, the petitioner challenges the order, Annexure 4 लिखी में, order dated 30/3/2026, passed by the ESI authority under section 45-A of the ESI Act, 1948, raising a demand of rupees
2,13,608. Next page.
2,13,608.00 towards contribution on the wages of the employees at the rate of 4% for the period from 31/3/2021 to 6/2025. 6 माने जून मास बुझिपाली डेट नो 31/3/2021 to June 2025. It is submitted by the para. It is submitted by the learned counsel for the petitioner. Appearance likhi chati. But actually, Mr. Somnath Mishra for the petitioner, Mr. Amarendra Prasad. It upon copy sir. It a fast fresh sir.
Copy the.
Opposite में blank रखती हैं. Mr. ये it is submitted by the learned counsel for the petitioner that the period for which the demand has been raised largely comes within the period when the unit was the periods comes up the period when the unit was declared closed and the intimation was made to the authority by
Annexure 1 and 3.
with the Annexure 1 dated 1/4/2023 and Annexure 3 10/11/2025. It submitted that for the period the unit was operating, that may be paid by the petitioner, but otherwise the petitioner is not liable to pay. Referring to the order under section 45-A into bracket Annexure 4, it is submitted dated 30/3/2026. It is submitted that the order is conspicuously silent on the issue of sufficiency of notice when the hearing was undertaken by the deputy director. He is the jurisdictional authority, deputy director. So the deputy director, ESI.
That's right. That's
Para. Issue notice along with this order to the opposite parties. To the opposite party, singular, plural, opposite parties. Sri Amarendra Prasad Ray, learned counsel, learned counsel, standing counsel for the opposite party, corporation, when present in court shall accept notice. Stop. Let one extra copy of the writ petition be served on the learned standing counsel to enable him to obtain instruction. The learned counsel, standing counsel submits that he may be granted time to obtain instruction in response to the writ petition, and the opposite parties shall file counter affidavit if so advised.
Yes.
If so advised by the next date. How much time, sir? Wakalatnama?
So at least 2 weeks.
The duly executed wakalatnama on behalf of the opposite party shall be filed within 15 working days. Upon filing of the wakalatnama, the same shall be taken on record, scanned copy be updated. Name of Mr. Ray, standing counsel, shall be reflected in the cause list as well as the case brief. Stop. IA 9440 of 2026. Had learned counsel for the petitioner. He reiterates his submissions as noted above. Stop. Issue notice as above. Extra copy be served on the standing counsel. Stop. As an interim measure, it is directed that no coercive action shall be taken against the petitioner pursuant to order dated 33/2026, passed by the authority, OP authority, till the next date of hearing. The matter shall be listed for admission in the week commencing 27/7/2026.
18.
This is the proprietorship form, my lords.
Same at the stage of 45A.
Yes. Here, my lords,
My lord,
contractor. Petitioner is a contractor, my lords, transport contractors. And here, as per the work order annexure 1 series, my lord, he is to transport the limestone and the slag from the mines of the Dalmia cement to the Dalmia cement factory. And for that, my lords, he engages some other vehicle owners, my lords, and from his payment made by the Dalmia, he makes the payment to the vehicle owners. This aspect has not been, though the proceeding was initiated by the opposite party, all these things I have given the, only for sample I have given annexure 3 series, the bills. He has a charge for maintenance and repair. Maintenance repair, what is maintenance and repair? The tire and all these things, and engine, oil, all those things have raised the bills, and that he has taken into consideration the entire amount without bifurcating and without affording opportunity of hearing. Well, your lordship may kindly come to annexure 5, page 34.
Well, is it your case that he is not a transporter, or your case
No,
is that he is a
I
transporter?
am a transporter. I am paying the ESI contribution. There is no dispute. This is omitted. Your lordship will find this is omitted wages. They say that you have to pay ESI contribution on this head. That your lordship will find annexure 2, my lords.
They have rejected your.
No, they have not afforded opportunity of hearing. What I'll take your lordship to annexure 5, my lord, the impugnance order. This calculation is there, annexure 2, page 19. I'm just showing your lordship. This is
19,
not
19.
page 19.
Yes.
Annexure 2.
Transportation charges 185.
Again. 1 crore.
85 lakhs, 46,000.
And general expenses, repair maintenance. These
Yes.
repair maintenance content, I was not given an opportunity to explain that these repair maintenance contains, suppose some oil is put, or tire resoling or tiring change. So that money is there. So that for that there cannot be any labor component or ESI contribution. Your lordship then come to annexure 5, the impugn order.
Regarding 1 crore 85, what do you say?
That this has been paid. I have given annexure 3, my lords. That is why I have given annexure 3 series to show that I have paid this amount to my vehicle owners. That your lordship will find. And Gottemu Deichikal sample. All these records were filed before the authority, my lords. Your lordship may kindly come to page 30, limestone payment sheet. And he has passed the order that work orders were not given to by the petitioner. He has never asked for Gotiye sitting re କହିଲେ ଆମକୁ କହିନାହାନ୍ତି ଆମେ immediately also this that hearing was done on 21st. First date is 14/8.
From page 30, how do you show the ESI contribution?
नहीं ESI contribution ये तो payment है जी कहाँ सेवड़ा से नहीं नांदी sir your lordship may kindly see date then pass number then challan number all those things here my lords total amount है PAN card name of vehicles owners ये मन को payment है जी सब payment ये गुड़ा से नहीं थिले हमरे इतने टंका है ना था now come to your lordship may kindly come to annexure 5 the impugn order. He gave the date on 14/8.
No, I could not get one thing actually. My question is, can you just turn to again that sample document?
My lords.
Before the annexure 2 rather. Annexure 2 page 19.
Annexure 2.
On 1,85,46. Page 19 actually. Just now you placed that. On 1,85,46, the ESI contribution at 6.5 and 4% is 8,57,781.
Yes.
So that you will pay, or you are denying that also?
I am denying that. This is their calculation, my lord. This annexure 2 was issued by the authority.
No, general expenses, repair and maintenance.
So but
the amount is a small amount.
Yes.
But the major amount is
major
57,000.
Because this amount was paid by Dalmia to me, to the petitioner. So it's a huge money. But from 1 crore, I have already paid 90 lakhs to my vehicle owners. So I am getting only 10. So ESI contribution should have been
calculated on 10, you are saying.
My lords. So at least to explain I was not given an opportunity to explain all those things. Your lordship may kindly come to annexure 5. He says that just go to sitting. Your lordship may kindly see this paragraph 4 you annexure 2 he has given a date. 14/8.
Ended on 14/8/24.
Yes, this is given in C18 notice. This is not a 45-day proceeding. My lord may kindly see if I would have paid this or I would have. This is not a 45. Thereafter 45-day proceeding starts. Now my lord 14/8 also I appeared.
C18 is annexure 2.
C18 is that.
You are saying that after C18 state have a 45-day.
45-day hele amku seita
no notice is given in 45-day.
45 ସେମାନେ ଆରମ୍ଭ କରି ଦେଇଛନ୍ତି ଏଇଠି ଦେଇଛନ୍ତି ସେଠି ସେଟା C18 ରେ ଷ୍ଟାର୍ଟ କରି ଦେଇଛନ୍ତି C18 ରେ
C18 ହେଲା 31/7/24
C18 31/7/24 ଫିକ୍ସିଂ ଡେଟ୍ ଟୁ 14/8
1/11/24
ନାଇଁ sir
almost 3 months
31
8 9 10 but 3 months during those 3 months there was no 45-day notice.
ନାଇଁ 45 notice ହେଇନି I appeared pursuant to annexure 2 I appeared before the opposite party number 1 on 14/8 that your lordship will get at
is it that
annexure 5 page 34
ଆପଣ C18 ଟା ଦେଖିଲେ କିଛି date fix କରା ହେଇଛି C18
କରା ହେଇଛି ପରା ମୁଁ କହିଲି page next page 19 14/8 my lords got it
yes I didn't mark that actually 14/8
ରେ ମୁଁ appear କଲି though it was
and 14/8 is also reflected in 45 way.
Yes. Tapare kale 21/8 just 7 days after and I appeared produce all records. See tapare kouchandi your lordship may mark.
No I got it
yes.
I mean your point is well taken. Mr. Ray what about that payments made to the because suppose he receives 2 crores roughly 2 crores but that money is not at his hand. So liability you are fixing at his level or the level of the other persons?
My lord, in this case, the inspectors or social security officers inspected the records of the petitioner and found that some amount was booked, but no contribution was paid. They prepared a report and submitted to the court.
Their perception is maybe
factual,
right.
This is factual.
No, I am not differing with you. I am not there. Because that is not my question actually. The inspectors found that he has paid 1 crore 80. He has been paid by Dalmia 1 crore 80.
My lord.
Fine. And he has not made a contribution. So that point, your point is also very well taken. Just look at C18 again.
My lord, practically, I am submitting. Inspector found some amount was booked, but no contribution was paid. And there is no segregation about the cost of material or wages or
कॉस्ट ऑफ मटेरियल बहुत कम पैसा है आपण कॉस्ट ऑफ मटेरियल भी जदी भी
ना, ना,
कहिबे
ये
पैसा बहुत कम
ए केस कथा पड़ेनी
हाँ।
जनरली जोटी स्पेसिफाई करा जाय न थाए लेबर चार्ज मटेरियल चार्ज ट्रांसपोर्टेशन चार्ज करा जाय न थाए से जगह डायरेक्ट असेसमेंट करिहबनी कंट्रीब्यूशन तेणु ताको गोटे चांस दिया जाए जे ओमिटेड वेजेस रे या बाहरिची तमे एक्सप्लेन करो
सेटा C18
See, C18, there is no C18 under the ESI Act. As per section 45A, no order shall be passed without providing opportunity of hearing.
But as it seems, maybe what you are saying is the proper sequence as per the statute. But what the authority has done, just look at Annexure 2 page, upon the copy achi. Page 18 dekho. See, top ta देखो तो top margin, right hand side just below your letter head. C-18 ad hoc omitted wages.
My lord, there is a number of forms issued under different provisions and different situations. So, for official purpose, it is marked C-18 ad hoc, C-18 actual,
Whatever.
C-18 interest.
Let us assume that you see, I am not also raising a issue, or I am not asking also that whether C-18 is proper or not, because he is not arguing that. So if you mark the date of appearance at the next page, 14/8/24/11
My lord, for the purpose of 45A, and that date cannot be excluded from 45A.
No. Kindly read that paragraph.
My lord,
please so cause.
Please show cause within 15 days before hereof as to why assessment should not be made as proposed above. In case you have any objection, you are hereby given an opportunity to explain the same and or to file a statement giving full particulars of the contribution actually due as per your records for the above said period within the time specified above. In case you desire to represent your case personally, you may appear before the undersigned in person or through an authorized representative on 14/8/2024 at such and such AM with necessary document.
The next part actually I want to draw your attention.
Yes.
Please take notice.
My lord, please take notice that unless your explanation and or statement as mentioned in the paragraph 4 above giving the actual dues for the period in question is submitted to this office within the time specified as above, this office shall proceed to the case on merits and an order shall be passed under section 45A of the Act determining the amount of contribution due from you under the provisions of the ESI Act and further cause the same to be recovered under section 45C to 45I of the Act along with the interest at the rate of such percentage
50% per annum.
My lord.
Under 39(5) of ESI Act.
My lord.
Now the issue is, Mr. Ray, the issue is now you ask that you give explanation. If you does not, then he will pass order. But on the very day you have passed a 45A order.
No, not on 14/8
on 21/8 on 21
proceeding start hela opportunity diya hela tame
आपण फास्ट अपॉर्चुनिटी 14/8 रे देले आपण 14/8 रे फास्ट अपॉर्चुनिटी देले
my lord.
So my concern is that in the process you are unable to complete achieve something which is sustainable, because you must look at your interest or not.
Instruction to
ଆପଣଙ୍କର ଇଣ୍ଟରେଷ୍ଟ କୁ ଦେଖିବା କଥା ନା ନାହିଁ
ସେଥିପାଇଁ ତ ପୁଣି
ଆପଣ ଯେତେବେଳେ ଆପଣଙ୍କ ଇଣ୍ଟରେଷ୍ଟ କୁ ଦେଖିବେନି. Now the problem is suppose because he is not disputing that he has received 1 crore 80 lakhs. You are saying that 1 crore 80 lakhs is omitted wages.
My lord.
If 1 crore 80 lakhs is omitted wages, it is your choice to decide that, or he has to be given an opportunity.
Opportunity.
So
And
now,
for that,
so no discussion is there.
yes.
Just
Ma-
look at. Of course, you are very candid on that date. I remember what you said. I mean, in another matter, not in this matter. Just look at the order.
My lord. Where the
ନାଇଁ ସେଇଟା ବି ଦରକାର ନାହିଁ ସେଇଟା ରିସାଇଟାଲଟା ଅଛି ସେଇଥିରେ ହୁଏତ ବି କିଛି ବାହାରି ପାରେ but anyway let us not concentrate on that but how you have proceeded in the proceeding
my lord.
ଆପଣ ତାପରେ ଦେଖନ୍ତୁ in the said notice ସପରଟା ପଢନ୍ତୁ
My lord, in the said notice, the principal employer was afforded an opportunity of personal hearing to represent his case on 14/8/24 and to submit a statement of contribution actually due as per their calculation. Sri Amit Kumar Sharma, authorized the person, attended the hearing on 14/8/24, but he did not produce any records and requested for another date. As per his request, next date fixed on 21/8/24.
let us assume that he did not produce what is produced here
My
so now you pass an order on 21/8 without granting any because he has requested for a date.
My lord, next paragraph. Amit Kumar Sharma, authorized person, attended hearing on 21/8/24 and produced the copies of bills in respect of transportation charge along with payment sheet of slag transporting, copy of a bank statement for the period such and such. He further stated that transportation is executed by the principal employer and statutory compliance is made by the principal employer, but he did not produce any work order and statutory compliance by the principal employer.
Where from you will get it?
My lord?
Where from this particular employer contractor will get from the principal because principal employer is not the noticee.
Right, he has not produced. My lord, he is independently covered.
Correct.
Otherwise, principal employer to pay.
Definitely, suppose he says that the principal employer has produced this, has to produce. But the problem now is that principal employer is not a noticee.
No.
And you what you have done? You have done the entire 1 crore 80 lakhs as his wages.
My lord, here question of
ଆପଣ
principal.
କଣ କିଛି wage statement ହେରିକା ଦେଖୁନାହାନ୍ତି?
My lord, next page, my lord. ସେ segregate କରିଦେଇଛନ୍ତି।
ଆପଣ ଗୋଟେ ଡ୍ୟୁ ରହିଲା ଏଟା କେବେକାର ଡ୍ୟୁ?
ଡ୍ୟୁ 14/19 to 31/3/20।
ଆପଣ 8 ବର୍ଷ ପରେ ଗୋଟେ ପ୍ରୋସିଡିଂ ଇନିସିଏଟ କଲେ 6 ବର୍ଷ ପରେ
My lord,
ଫାଷ୍ଟ 4 ବର୍ଷ ପରେ ତ 4 ବର୍ଷ ପରେ ଯଦି ଆପଣ ୱେଟ୍ କରିଥାନ୍ତେ ତାକୁ ରେକର୍ଡ ଦବା ପାଇଁ ସେ ଯଦି ରେକର୍ଡ ଏତିକି ଦେଇଥାନ୍ତେ ବର୍ତ୍ତମାନ now this question how this court will answer suppose because you see don't presume because I understand what Mr. Tripathi is telling you will obtain instruction but I am on a different issue by keeping these matters pending now what now suppose he has now filed it in a writ petition you will file a counter so now he has filed certain Goel Enterprises jacket at the expenses truck tire tube flap lubricants then ଆପଣଙ୍କର ଯୋଉଟା 22 ରେ ଯୋଉଟା ସେ ଦେଖଉଥିଲେ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଗୁଡାକ
my lord,
to whom he has paid
my lord.
So what would be your answer now? So now in the ultimate this court will be end up being a fact finding court.
I am saying that this is a totally factual dispute.
So the problem is that and factual because you see in a very small factual disputes also at least we as appellate court we have to write pages you are writing 2 lines so and so appears did not produce record and the next date it is allowed now so in ultimately if ultimately this court will entertain this writ application then
my lord may see next page
he has not discussed anything
he is finding I have gone through the employer.
The esteemed Mr. Assistant Director, what he has done, he has went on his theory is that this fellow does not produce any documents. Correct.
Hello.
So that is how he has given, because either he has to refer to documents or he's not to refer to documents. His theory is that he appears on 18, 14, then he requests for time. I give him time to 7 days time. And 7 days he does not produce anything, so I pass a order.
Yes.
Now before this court, these documents are produced. So what is the position of law? Because these documents were not before you for consideration. And you proceeded on a basis as if no document is there.
No, what document produced he has written?
And my lord, so your lordship will find it.
Documents written to say 18 ad hoc notice after both thora भी देखेइले आपण आपन transportation charges आपण कहले 1,85,000, general expenses 40,000, 42, repair and maintenance 67,000. So out of transportation charges, how he has spent the money, he now files in the High Court. So you have to show me a provision in ESI Act. If such a case is made out, ESI officer cannot consider that. Authority, not officer, ESI authority. Unless that happens, these litigations, even after 10 years, like land acquisition appeals after 11 years, the project proponent is not made a party. In 1995, Supreme Court Constitution Bench said, if the project proponent who is paying the money, either apportionment or enhancement, he is to be made a party. The matter is kept pending for 15 years. This will be kept for another 15 years. And the last date, ultimately, this court is not equipped also. The reason being, there is no finding. There is no finding or nothing.
My lord, 45A proceedings.
ଆପଣଙ୍କ ପାଇଁ ଆଜି ପାଇଁ ଏଟା ମୁଁ କହୁନି. ମୁଁ in a broader proposition I wanted to discuss with you when there is lack of material in the order passed by the trial court. I mean the authority, administrative authority. Because this court is not a fact-finding court or cannot discuss the facts which have not been discussed by the authority.
Yes.
The authority on the 14 तारिख रे केस पड़िला से कहले 21 तारिख टाइम मागिले कहले तो 21 तारिख दिन से आसिले किछि कागज देखले ऑर्डर पास हे गला.
My lord.
So he doesn't refer to
In
anything.
this case, it seems the order passed.
He may be.
Matter was closed very hurriedly.
No, could be, but for to be in a hurry, at least he must refer to some provision. That in case of a transport case, so and so, so and so. If I will not go into the details, who has received money, who has been paid money. So that is the concern because this pendency being blamed on the court, that court is not taking up in many times. The pendency actually is leading to nowhere also. Because by count, now you will file a rejoinder. Counter. They will file a rejoinder. Again, it will boil down to those documents where they rely and what your authority will decide on those documents. How to appraise your authority, Mr. Ray?
Yes.
ଆପଣ ତ ଗୋଟେ ଦେଖିଲେ ମିଷ୍ଟର ରାଉତ ଯୋଉଟା ଆର୍ଗ୍ୟୁ କଲେ ସେ କିଛି ବି ଆର୍ଗ୍ୟୁ କଲେନି. Even at times also the matter is kept pending for that. Mr. Mishra ବର୍ତ୍ତମାନ adjournment ନେବେ. What I can do? It will be adjourned. ଆପଣଙ୍କ authority ଗୋଟେ ଦେଖରେ ଆମେ ତ order pass କରିଛୁ. ଆମେ ଆଉ ତା ଦେହରେ ପସିବୁନି. They must understand what kind of order they are passing. They are statutory
summary provision तो 45 है तो उसे ए टाइप रो ऑर्डर कर दउचंती जोथि पई कि 45 75 1 रहिला जे डिटेल फैक्चुअल एस्पेक्ट सेठी एनक्वायरी हो
बढिया कथा
45 ए रे थिले सेना सेठी जिवो किस तरह
any litigation emanating after a adjudication by the authority must deal with facts.
Yes.
Must deal with facts.
That is not.
Otherwise, let us assume it goes to the EI court. District judge. They are more bound by procedure. They only see the facts. They only see the statement. They only see the evidence.
Right.
So there also it will be a struggle again.
And there is also a provision against the order of EI court. There is no appeal.
No appeal. Only 226.
No. Appeal is live if it involves substantial question of law. Otherwise,
taxation bhaliya.
Madam.
The High Court will favor substantial question of law, then can only be entertained. This adds to the burden actually, Mr. Ray, that is the concern, and they must realize that by this way, ultimately nothing is going to be achieved also.
My lord, in this case, ଜଣା ପଡୁଛି ଯେ ସେମାନେ currently pass କରିଛନ୍ତି. Some cases, even after affording opportunity of 7-8 times, they are.
ମୁଁ ଯେତିକି ଆଜ୍ଞା ପଢିଛି opportunity of hearing, I have done little reading. Whenever a notice is issued to any person, the person must know what he is to answer.
My lord.
ଆପଣ ଏମିତି କୁହନି ଯେ ଆପଣ ଗାଈ ବିଷୟରେ ଯାହା ଜାଣିଛନ୍ତି କୁହନ୍ତୁ. ଆପଣ ଯଦି ତାଙ୍କୁ କହିବେ ଆପଣ ଇଏ ସେ ଆକ୍ଟ ବିଷୟରେ ଡିମାଣ୍ଡ ବିଷୟରେ ଯାହା ଜାଣିଛନ୍ତି ଲେଖନ୍ତୁ, ସେଟା ହବନି. ଆପଣ ଯଦି ସ୍ପେସିଫାଇ କରିଦିଅନ୍ତେ ଯେ ୟୁ ଆର୍ ଏ ଟ୍ରାନ୍ସପୋର୍ଟ କଣ୍ଟ୍ରାକ୍ଟର, ୟୁ ହାଭ୍ ରିସିଭ୍ ଦିସ୍ ଆମାଉଣ୍ଟ, ଆପଣଙ୍କର ଦେଖିବା ଦରକାର ଯେ ହାଉ ହି ହାଜ୍ ସ୍ପେଣ୍ଡ ଦ ଆମାଉଣ୍ଟ, ଆପଣ କହିବେ ତାଙ୍କୁ. Because Mr. Ray, the bills what he has produced or the statements he has made, those cannot be manufactured. On the fast reading, ଆପଣ ତାଙ୍କୁ ସିଧା 2 crore କରିଦେଲେ, ସେ କହିବା କଥା ଯେ 2 crore ମୋର ଲେବର କମ୍ପୋନେଣ୍ଟ ତା ଦେହରେ କିଛି କଣ ଅଛି ମତେ ପଚାରିଲେ ବି ନାହିଁ. Both of you are experts on this branch of law. Whatever little I understand, we have been discussing for last about half an hour. Can a businessman understand this? ଆପଣ ଯଦି ସ୍ପେସିଫିକ କ୍ୱେଶ୍ଚିନ୍ ପଚାରନ୍ତେ ଯେ ଆପଣ କାହାକୁ ଦେଲେ, ଲେବର କେତେଟା ଥିଲେ, ଆପଣ ଲେବର ପେମେଣ୍ଟ କେତେ କରିଛନ୍ତି, that would ensure better compliance and better results also. There is a possibility that they have not complied. Is there any presumption that they comply କରିଛନ୍ତି ବୋଲି? Even they say that Dalmia has complied. Now Dalmia is nowhere in the picture. Now if somebody says Dalmia has complied, whether he will issue notice to Dalmia or not, because he can't bring in Dalmia.
My lord, he has to insist the authorities to implement them. Has he
ଆପଣ ସେଠି ଝାରସୁଗୁଡାରେ both of you have to appear. ସେଠି ଆଜ୍ଞା ଆପଣ ଜାଣିଛନ୍ତି ଲୋଅର କୋର୍ଟରେ କେସ୍ ଟ୍ରାଏଲ କରୁନାହାନ୍ତି, have tried to understand କାହିଁକି ଟ୍ରାଏଲ ପଡିକି ରହୁଛି. The district judge says when we are pressing them, ଆଜ୍ଞା ଟେକ୍ ଅପ୍ କରନ୍ତୁ, କେତେଟା ମ୍ୟାଟରରେ ସେମାନେ ଡରିକି କରୁନାହାନ୍ତି, ଖାଲି ଆଡଜର୍ନମେଣ୍ଟ ନେବେ କାହିଁକି ନା ଜଣେ ଓକିଲ ଅଛନ୍ତି, ସେ ଆସନ୍ତି ଏଠୁ, ସେ କଟକ, ସେମିତି ବିଭିନ୍ନ ଜାଗାରେ ଗୋଟେ ପର୍ଟିକୁଲାର ମ୍ୟାଟରରେ ଥିବେ, ଆପଣ ଦେଖିବେ ସେ ଓକିଲ କରିବେ, ସେ ନ ଆସିଲେ ସେ କେସ୍ ହବନି. ଆପଣ ଯୋଉ କଥା କହିଲେଣି ସେ I don't think to that level the bar will grow that ସେ ତାକୁ ନୋଟିସ କରିବେ, ସେ ବୁଝି ତ ନିଜେ ବୁଝିବି ନାହାନ୍ତି. I don't think they will understand these things. Yes, the learned counsel for the petitioner. The petitioner is a proprietorship concern undertaking transport contracts, was a subcontractor under one Dalmia Cement Limited and Dalmia Bharat कौन बोलते?
Dalmia Cement Jharsuguda.
Dalmia Cement Jharsuguda. The petitioner challenges the order dated 1/11/2024 passed by the Assistant Director ESI Corporation Jharsuguda under Section 45-A of the ESI Act.
And consequently,
the consequential garnishee order 45A होची
Annexer 7 page 22/4/26
dated 22/4/26 and the consequential garnishee order to bracket annexer dated 22/4/26 under section 45G of the ESI Act demanding an amount of rupees 53,68,000 नहीं 53,06,000 53 comma
5,44,384
5
lakh 40,384
5,40,384
and pursuant to this annexer 8 they have already taken 9,990 ସେତିକି ଟଙ୍କା ମୋର ଆକାଉଣ୍ଟରେ ଥିଲା ନେଇଯାଇଛନ୍ତି.
The garnishee order was issued to the banker of the petitioner, that is Axis Bank. ପାଟି କରିଛନ୍ତି
OP number 3,
OP number 3,
who has already remitted
Rasgang, Axis Bank, Rasgangpur branch, Rasgangpur, and an amount of rupees 6878.
no sir,
It's not the DD number.
9990.
Amount of rupees 990 has been appropriated from the petitioner to the bank by instructing the bank to issue demand draft dated 5/5/2026.
Right.
Stuff is submitted by the learned counsel for the petitioner is heard at length. He refers to the notice dated 31/7/2024 at Annexure 2, which mentions the calculation of demand, that is contribution payable in respect of employees under section 45-A for an amount of rupees 8,62,880. And the notice was and the noticee, petitioner was directed to remain present on 14/8/2024. The learned counsel then refers to the order 45 order ta ko page re
Sir, page 34.
Order dated 1/11/2024 passed by the authority under section 45-A of the Act. The ordering portion indicates thus in the said notice to Neki, principal employer. For example, page 34. It starts in the said notice, the principal employer, up to then second out para, then third subpara. Compliance by the principal employer. For example, stuff. Referring to the said observations of the authority, it is submitted that adequate opportunity has not been given, as all the payments received from the employer Dalmia Cement Jharsuguda has been treated to be payment towards wages, whereas the sample document annexed to the present writ application at Annexure 3 shows that for the transport contract, several purchases were made, such as truck tires, tube, flap, and other similar items. It submitted that in no case the expenses made for purchase of tires, tubes, and retreading can be treated as wage payments, payment on wages. The tapare aute apon jota dekhuthile table le thila
Repair maintenance.
ha apon bibhinno head re jo bibhinno loko ko dele the learned sita kon part of gote annexure hi jaichi.
Annexure 3 series.
The learned counsel then refers to further page 30 part of Annexure 3, which shows the limestone payment sheet dated 5/10/2019. Eta kahar hoida? Eta aponko na Dalmiar?
Eta more. Mu euda isu payment karchi more.
Where
vehicle
money has been paid to
vehicle owners.
Sir, eta with 14/8/2019 up to 24/8/2019. Stuff. The effort, the contention raised by the learned counsel for the petitioner is that there is no scope for the authority to consider these aspects. Therefore, the entire amount of rupees 1,80, so the entire amount of rupees around 1,80 lakhs was taken to be wage payments. I can't say the language ta kon use korchonti.
Transportation charges.
Na se tako kohchonti omitted wages. OMI TTED then space remitted wages. Issue notice to the opposite party along with this order. The allotted opposite parties 1 and 2. 1 and 2 along with this order. Notice to the opposite party number 3 banker is not issued for the time being. Sri Amarendra Prasad Ray, learned standing counsel, being present in court, shall accept notice on behalf of the opposite parties 1 and 2.
One extra copy.
One extra copy of the application shall be served on the learned standing counsel by tomorrow. The learned counsel shall file the duly executed Okalatnama on behalf of 1 and 2 within 15 working days. Within 15 working days. Upon filing of the Okalatnama, the same shall be taken on record. Scanned copy be updated. The learned counsel for the learned standing counsel shall obtain instruction and file counter affidavit if so advised. Stop. Para. IA 9558 of 2026. Hard learned counsel for the petitioner. Issue notice as above. He reiterated his submissions as noted above. Stop. Then he issue notice as above. Accept what set of process fee as well as postal requisites. In the interim, it is directed that no coercive action shall be taken pursuant to the order dated Garnisi order under section 45G of the ESA Act dated 22/4/2026 and the
45A order.
45A order ta hochi
11/11/24
and the order passed under section 45A the ESA Act dated 1/11/24. That's the petitioner.
No further
amount shall be debited from the accounts of the accounts maintained by the petitioner and credited to the account of the ESA corporation.
Petitioner is
without leave of the court.
Operator
Petitioner shall be allowed to operate. Or minimum balance sheet kete assess re.
ଏବେ କିଛି as per my instruction ଏଲେ କିଛି 15,000 ଖଣ୍ଡେ ଥିଲା ସେ ନେଇ ଯାଇଛନ୍ତି.
The petitioner shall be allowed to operate the bank account maintained with the OP number 3 Axis Bank main branch and Axis Bank Rajgangpur branch at Rajgangpur district Sundarban without any hindrance. Upon एवढा कभी amnesty आनिया कथा. I think the problem would be once you embark upon a journey of discovering facts. ଆପଣ କାହାକୁ ଡାକିବେ ଦାଲମିଆକୁ ଡାକିବେ ତାଙ୍କ ଟ୍ରାନ୍ସପୋର୍ଟରକୁ ଡାକିବେ କିଏ ହୁଏ ଲେବର nothing is known and the concern is that your cause is a just cause. ଆପଣ ଯଦି employee contribution ସେମାନଙ୍କର ଦବା କଥା ସେ କଣ employee ମାନେ ପାଇବେ ସେ contribution ଟା ନେଲେ ଆପଣ ଯୋଉଟା ନେବେ
ନା ସୁପ୍ରିମ କୋର୍ଟ ମନା କଲେ କଣ୍ଟ୍ରିବ୍ୟୁସନ ଜଣେ ଦେଲା ଯେ ସେ କିଛି ବେନିଫିଟ ପାଇବ ସେମିତି କଥା ନାହିଁ unless he is eligible to get the benefit.
Yes.
Date
the matter shall be listed for admission in the week commencing the document. 27/7/2024.
सर आ गोटे अछि 22 नंबर ऑर्डर एटा सुनिथिले आपण से मो करथुली ऑनलाइन रे टिके असुविधा हला सेटा सर आज तो ही पर कैन इट बी टेकन अप टुमारो ऑर्डर नंबर 20
आपण जेति की फ्रेश ऑर्डर्स 22 टा काली रखि दियो
आगे
Item 19.
In this case,
Draw my lord certain.
kindly taken up after vacation.
अरे सुनंदु सर पिटिशनर कोन कहउछनी सुनंदु तापर ताको आपण अर्जन करिवे
नहीं
माने की सर आपण
Axis Bank.
एक्सिस बैंक पे काय आपण व्यस्त होचंदी
नहीं मु व्यस्त
तो बढ़िया आपण को जे जा पैसा मांगले ताको धरे देले
यस मैन माने अपोजिट पार्टी नंबर 2 रो एडवोकेट जन तांकर के
नहीं आपण मिस्टर रेंग को सागर अपियर करछंदी आरा मैटर टारे
नो
सेटा नो 22 रे 22 काली आसियो
madam sir मैं I have instructed from the opposite party advocate of the opposite 2
आज किछि ऑर्डर पास होनी सर एटा सिंपली से पोस्टिंग चेक कर चाहिए एटा काली आउथरे आसीबो किछि ऑर्डर पास हेनी already we have crossed the time.
Yes.
Apart from Pokhara, we have crossed, so we have crossed the time also.
Sir,
And do
sir,
make
I
a
have
mention.
request,
Pokhala is a great retarding factor.
another request, my lords, से जो ये copyright की operate मैंने
The party shall have the liberty to act upon the order of the copy of the order obtained from the official website of this.
Item 19, my lord.
Yes.
Because the interim order was
Sorry.
item 19, my lord, I am praying it may be listed up after vacation, my lord. It's a hearing matter.
Here I am appearing for the opposite party.
ଆପଣଙ୍କର ଯୋଉ କହୁଥିଲେ disposal ହେଇଛି ସେ
Yes, yes, yes.
Sir, ahead.
I will show, my lord. It is
ଆପଣ
wife's.
କଣ ଏମିତି disposal ଆପଣ ଜାଣିପାରିବେ
Yes,
ମୁଁ ଜାଣିପାରିବେନି
ମୁଁ ଖାଲି କହିଦଉଛି
Mr. ଭୂୟା ବି ଜାଣିପାରିବେନି
one line submission. Sir, one line
ଏଇଟା
submission.
ଡେଟ୍ କରନ୍ତୁ ଡେଟ୍ କର
So wife's divorce petition. In that, the maintenance proceeding was filed. In that, he filed a petition under order
It is filed in the
1114
CP.
for production of passport, my lord. Now that proceeding has been disposed of. That was my submission.
ଆଇଏ
My lord.
ନା ନା
Sir, CP ରେ file.
CP କଥା ମୁଁ ପଚାରିଥିଲି
CP is pending.
ମୋର ଟିକେ ନ ଭୁଲିବାର ପ୍ରୋବ୍ଲେମ
The CP is
ଆପଣଙ୍କର ଆଇଏ ପେଣ୍ଡିଂ ଅଛି କି 10ଟା ଆଇଏ
maintenance proceeding has been dropped.
CP is pending
CP is
So, I
pending.
understood that.
It is wife's CP.
whatever CP is pending
My lord, it is wife's CP for divorce. That was my
ସେଟା
submission.
କରିହବନି sir
Maintenance proceeding has been.
when I start hearing fresh and orders matter extensively ଆପଣ ଯାଇପାରିବେନି ପହଞ୍ଚି ପାରିବେନି I told you.
Reopening date then.
କେବେ ଆସିବ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ
Lordship kindly consider because wife's divorce proceeding.
Date ଟା at 19, my lord, interim
Just
order
to
is there.
linger the entire proceeding. That is the entire purpose, my lord.
Interim
It is
order
my
is
submission.
strategy
It is my submission.
that is a very legitimate strategy
Yes, ma'am.
illegitimate ହେଲେ କହିବେ
Therefore, I am before my lord. Therefore, I am before my
ଏମିତି
lord.
କଥା ଯଦି
ବେଳେବେଳେ
passport ଟା
hurried-
produce କରିଦଉନାହାନ୍ତି
Therefore, I
High
before
Court
my lord.
ସାମ୍ନାରେ ଆସିବ।
decision hurried is decision buried ଆପଣ ଦେଖିଲେ ଗୋଟେ
No, no,
letter
your
40
lordship-
ଲାଗିଲା କିଛି ବୁଝି ହେଲାନି
Your lordship keep it to reopening.
ଟିକେ ରହିବ ଆସିବ ଆଉ କଣ
It is my
Interim order may continue.
listed for admission in the week commencing
orders
ଏଇଟା admission ନା ସେଟା ସିଏ କହିଲେ ଯେ dispose of ହେଇଗଲା ବୋଲି order ଆସିଥିଲା dispose of ଆଜି ହେଇଯିବ ବୋଲି
There's a vacation of stay file each.
Whatever.
Can be posted for orders.
it should come
Subject
for
to my
admission.
lords.
ଆପଣ ଏଠି hearing ନହେଲେ ହେଇପାରିବନି ଆପଣ unwittingly you are favoring them
No, no.
because when you ମାନେ argue so much then how it can be disposed of it has to be heard
It will not take more than 5 minutes.
ନାଇଁ ମୋର ଆଜ୍ଞା ନାହିଁ
No, here lordship can. Lordship can.
ଆପଣ ମତେ ଯଦି ଭାବୁଛନ୍ତି
Issue is so
ମତେ
small.
25 ମିନିଟ୍ ଲାଗିବ।
The issue is so small.
Week commencing 27 26 yes
Yeah.
My lord,
Interim order.
Pardon to make a mention, my lord.
19/12/2025.
Mr. Vivekananda Bhuya, senior advocate, along with SS Bhuya, Unisha Lekuntu, along with SS Bhuya for the petitioner, Mr. Varman Kumar Das for the opposite party. The matter was mentioned by the Learned Counsel for the opposite party and was listed for orders. As it was stated that the CP was disposed of. CP out of which the present writ application arises has been disposed of. Today it is clarified by the Learned Counsel for the opposite party that the CP is pending. However, the IE has been disposed of.
Yes.
Accordingly, the matter shall be listed for admission in the week commencing 27
Can it be any day in June, my lord?
ଜୁନରେ ଆପଣ ଗୋଟିଏ ଦିନ ଅଛି
Any date, sub.
120 130ଟା ମ୍ୟାଟର ଅଛି ଆପଣ ଅର୍ଲିଏଷ୍ଟ ପସିବଲ ଡେଟ୍ କରାହଉଛି ଆକ୍ଚୁଆଲି
I'll take my chance.
ନାଉ वी had ଆପଣ ଚାନ୍ସ କେମିତି ହବ
Convenient to my.
ମୋତେ କନଭିନିଏଣ୍ଟ ନୁହଁ ଆକ୍ଚୁଆଲି ଇଟ୍ସ ନଟ୍ କନଭିନିଏଣ୍ଟ ଟୁ ମି
To my lord.
ଆଇ ଆମ୍ ଲୁକିଂ ଆଟ୍
Board.
ଟୋଟାଲ ନମ୍ବର ଅଫ କେସେସ୍ ଦ୍ୟାଟ୍ ଇଜ ହାଉ ଆଇ ଆମ୍ ଡିଷ୍ଟ୍ରିବ୍ୟୁଟିଂ
The first
ସୋ ଦ୍ୟାଟ୍ ୟୁ ଗେଟ୍ ଏ ଚାନ୍ସ ଲିଷ୍ଟ କରିବାଟା ବଡ କଥା ନୁହଁ ପଢିବାଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ
The fast week thing, if possible. If possible.
ୱିକ୍ କମେନ୍ସିଂ 6 7 20 26
Great.
the interim
Pardon
order
to make a mention, my lord.
just 1 second sir just 1 second give me a second interim order dated
19/12/2025.
19/12/2025 is reiterated.
My lord, item number 28.
Yes, 28 कौन कौन तू?
28, my lord, we are approaching on behalf of the petitioner. State had to file a counter. Agya, my lord.
Counter has been filed, my lords.
Counter has been, yes, my lord. Counter has been filed. So copy has also been served. I'll serve additional copy to my friend.
I have not received the copy, my
I'll
lord.
give another copy.
Or please, you are Mr. Mohanty.
My lord.
Huh?
My lord.
For the petitioner, 28 Lekontu. Mr. Prabhu Prasanna Bear, additional standing counsel for the opposite party. Paucity of time intervenes. The matter is mentioned by the learned counsel for the petitioner. It is submitted by the learned additional standing counsel that he has filed counter and copy shall be served on the learned counsel for the petitioner within 5 working days.
Yes, madam. Yes,
5
ma'am.
working days. The petitioner shall have the liberty to file rejoinder to the counter if so advised. The matter shall be listed for admission in the week commencing 27 27/7/2026. Item 29. The Sasanka Sekhar Patra for the petitioner. Mr. Prabhu Prasanna Behra for the opposite additional standing counsel. The paucity of time intervenes. The matter is mentioned by the learned counsel. The matter is listed for hearing under the heading for admission. Is mentioned by the learned counsel for the petitioner. He expresses grave concern for the fact that the matter is kept pending since 2021 and counter has not been filed. In response, the learned additional standing counsel submits that he has pursued the authority and shall file counter. Kete dino kouthile?
My lord, we have got the instruction that admittedly I may submit that he has worked that period. Within 2 weeks, we'll file it. That affidavit will file it.
The counter shall be filed within 15 working days. Upon serving copy thereof, at least you will be satisfied that.
I got the written instruction, my lord.
Yes. So, copy shall be served on the learned counsel for the petitioner, who shall obtain instruction and file rejoinder if so advised. The matter shall be listed for orders in the week commencing 6/7/2026. Yes, 30 to 34.
Item 27.
Date chahuchandi sir?
No.
Yeah,
Taken out tomorrow.
27 टा काली आनंद है जोटा जो हेडिंग रे अछि सेटा सेमती रिपीट कर देबे यस 30 to 34 की मेंशन करथि 35 तो काली पे रहला आप आपण 36 to 38 then 39 to 44
43.
43, yes.
43, my lord, I have filed my wakalatnama for the opposite party number 1, my lord. For the opposite party.
आपण गोटे केबे फाइल करे जानछन
My lord, today I have filed my wakalat.
Today?
My lord. My lord, I'll file counter, my lord. Let it be up.
And the petitioner, my lord.
No, 43 is not being taken up. No order is passed. He only says that his appearance has to be noted. 43 केबे चाहुछन आपण
My lord, any date after vacation.
डेट कर दियो
भूकांजन 13/7
13/7/2026.
My lord, 44, my lord.
44, yes, Mr. Sir.
After vacation, the interview continue.
44, Mr. Vijay Kumar Sahoo for the petitioner, paucity of time intervenes. And the matter is mentioned by the learned, the matter being listed for full stop, matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the petitioner. He seeks for extension of the interim order dated 10/4/2026. But accordingly, it is directed that CP number 337 of 2025 pending before the learned judge family court Puri shall be adjourned to a date beyond shall be adjourned to a date beyond 27/7/2026. As would be convenient to the learned court in season of the matter. The matter shall be listed for admission in the week commencing 27.
I pray, my lord, for further proceeding in disposal of the.
No. सेल तो आसीबनी अपन तापरे गोटे पत्थर आनी तापर थोइबे से उठी परिबनी ते उज्जीवित थाउ कोन त कुछ असुविधा नै
एटा जिबाउ पड़छ 200 किलोमीटर एकला जिबा पड़छ
200 किलोमीटर जिबेनी वकील एंगेज करिवे आपण जदी दिल्ली रो वकील आनिबे कहबे 1700 किलोमीटर जिबा पड़छ
सर्टिफिकेट कॉपीटा धरि जिबा पड़िबो तो
आगे
सर्टिफिकेट कॉपीटा नै जिबा
नहीं सर्टिफिकेट कॉपी आज से जुगो गलाने तो अपलोड हे गला द पार्टी शैल हैव लिबर्टी टू एक्ट अपॉन द Copy of the order obtained from the official website of this court. ଆପଣ ଆଜ୍ଞା ସେତେବେଳେ ଯୋଉ କୋଭିଡ ବେଳେ କହିଲେ ସମସ୍ତେ ଯାଇକି ସେତେବେଳେ ସିଆର ଦାସ ସାହେବ ଆଜ୍ଞା ସବୁ ଅର୍ଡର ନେଇ ଯାଉଛନ୍ତି ଆମକୁ ଆଉ ଦେଖା ହିଁ କରୁନାହାନ୍ତି ବର୍ତ୍ତମାନ ସେଇ ସିଚୁଏସନ ୟେସ୍ ଆଜ୍ଞା 49 ଡକା ହବ
Lordship, item 46 Lordship. 46 Lordship.
46 କଣ ଚାହୁଁଛନ୍ତି ସାର୍
May prefer tomorrow Lordship.
ଆଜ୍ଞା ଆଜ୍ଞା
Prefer tomorrow Lordship.
46 tomorrow ହଉ ଠିକ ଅଛି tomorrow କରିଦିଅନ୍ତୁ ଟା ମ୍ୟାଡାମ ଥିଲେ ଏଠି ପଳେଇଲେ ଅରିଜିତ ମିଶ୍ରଙ୍କ ଚାମ୍ବରରେ ଥିଲେ ଠିକ ଅଛି ଆଉ କଣ ରହିଲା ସେ ପେଜରେ
Lordship.
anyone mentioning in up to page a page ମାନେ item 35 to 44 45 to 48
Item number 47, my lord.
47
47.
what do you want sir
Sir, any date?
date ଚାହୁଁଛନ୍ତି 47 date କରନ୍ତୁ
ଭୋକାଂଶ 27/7
27 ରେ ଆସିବେ
Yes. Publish.
49 ଲେଖନ୍ତୁ Mr. Rabindra Kumar Prusti for the petitioner, MS Akanksha Kabi for the opposite party. The matter is listed for hearing under the heading for orders. Stop. For orders, ad is mentioned by the Lordship Counsel for the parties at the beginning of the day's proceeding. Is submitted by the Lordship Counsel for the opposite party, referring to the prayer made in the writ application that if the matter can be remanded to the Lordship Judge Family Court, not remanded, appropriate order can be passed, considering the prayer of the petitioner. The petitioner is before this court challenging the order dated 16/4/2026 passed by the Lordship Judge Family Court into bracket Roman 1 Bhubaneswar in CP number 561 of 2025. By the said order, the application filed by the opposite party, application dated 9/4/2026, filed on behalf of the respondent, wife in the marriage, and application dated 13/4/2026, praying to recall PW1, was rejected. was rejected. By filing the writ application, the petitioner wife in the marriage, who is the respondent before the Lordship Judge Family Court, submits that praise that the DW2, father of the petitioner, wife, should be examined in support of her defense. In considered opinion of this court, the prayer made before the Lordship Trial Court as well as this court can be allowed in the interest of justice, as keeping the matter pending here would interdict the CP, which would not be in the interest of both the parties. Accordingly, it is directed the parties shall appear before the Judge Trial Court on 17/6/2026 as fixed earlier. Lordship Judge पूरा लिखी दें. Lordship Judge Family Court Kotak on 17/6 ଗୋଟେ ଭୁବନେଶ୍ୱର ଡାକିଦେଲି କି ପ୍ରଥମ ଭୁବନେଶ୍ୱର କେମିତି ହେଇଗଲା? ସିଏ ଲେଖିଛନ୍ତି ଭୁବନେଶ୍ୱର, ଓକିଲ ଘର ଭୁବନେଶ୍ୱର ବୋଲି ସବୁଠି ଭୁବନେଶ୍ୱର ଲେଖିଦେଲେ। ସେ ଭୁବନେଶ୍ୱର ଲେଖି ଭୁଲ ହେଇଯାଇଛି, ଲେଖନ୍ତୁ କଟକ Hon'Ble Judge Family Court କଟକ ସବୁଠି ଲେଖା ହବ ହେଲା। The party shall appear on the said date. The Hon'Ble Court take WPC 12150 ঠিক আছে, ফাইল ঠিক আছে। On the said date, the Hon'Ble Court shall proceed as the prayer of the petitioner regarding examination of the father of the petitioner hearing respondent to examine her father as DW2 has been allowed. Stop. With the aforesaid observations, the writ petition is disposed of. Yes.
My lord, item number 38.
38.
Interim order to continue. My lord, 38 item number, interim order to continue.
Can I have to get the files?
My lord.
The file, just that. Yes. Who interim order date, sir?
Interim order is my lord,
38 is not reached, Mr. Sethi.
my lord, it has not reached, but in the next date.
Obviously, the order is the next date. Next date, it will continue.
After vacation, any date at the convenience of man.
और 38 डेट कर दियो, पोस्टिंग कर दियो।
We commencing 27.
We commencing 27.
Oblige man.
49 पर रहला 50 रु 50 and 51. Yes.
50 ସେଟା ତ କହିଥିଲି ଯୋଉ ସୁପ୍ରିମ କୋର୍ଟ
अच्छा 50 ଟା କହିବେ ଯେ ମିଷ୍ଟର ଶଶାଙ୍କ ଶେଖର ପାତ୍ର ଫର ଦ ପିଟିଶନର 50 ଆପଣଙ୍କର।
Yes, yes.
Mr. Ansuman Sethi, additional standing counsel for the opposite party. The matter is listed listed under the heading for admission and could not reach during the day's proceeding. It is mentioned by the learned counsel for the petitioner that the content application arises out of the judgment dated dash passed in WPC number
16/4/24
तो से कर देबे पूछ जल्दी करिया पई dash passed in WPC number so and so हैला
WPC
it is further submitted that
SLP
the SLP
होची 16/4/24
पडी लिखि दे दियो सेटा देले से भूल भाल SLP नंबर हेगा कोंतु
WPC एटिका
SLP ना
SLP होची
the state had challenged the order passed by this court by filing SLP dash. The said SLP has been dismissed by order of the Honorable Supreme Court. Hello.
On 16
dash. The learned additional standing counsel shall obtain instruction in the matter. The matter shall be listed in the for orders in the week commencing
27.
27-26. Yes. Yes.
My lord, item 26. Court below has been adjourned on 22nd.
Non appearance का है नहीं किसी 26 अपन 24 कॉल करते ले
26
कॉल है नहीं
ତା ଡକା ଅଛି
ଆଜ୍ଞା
ହେଲେ ଆମେ ଡାକିକିନି ଯାଇ ଯାଇଛୁ କିଛି ରିଚ୍ କରିବୁ
ରିଚ୍ କରି 26 ସାର୍ କଣ ଚାହୁଛନ୍ତି
if it is after vacation but in
petitioner pay
my lord but proceedings should be stay it has been adjourned up to 22nd
stay କରୁନ
then 22nd my list is
26 ରେ କଣ order interim order କଣ ଥିଲା
obtain the instruction from the court below and they have uploaded status
लिखନ୍ତୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ପାଇଁ ରହିଛି।
My lord,
ଆପଣ 95 ଦିନ ଆପିୟର କରିଛନ୍ତି ହେଇପାରିବ
26 my lord.
ହଁ 26 ତ
ହଁ
ଆପଣ ଦେଖୁନାହାନ୍ତି ସେଇଠି ଦେଖନ୍ତୁ ଆପଣ ଯାଇକି ଦେଖାନ୍ତୁ ସବୁ
ମୁଁ 26 ଟା କହିକି ଯାଇଥିଲି 22nd ବୋଲି କହିଲେ ପୁଣି ଡାଉଟ ହେଲା ଆସିଲା ଆଉ
26 ମାନେ କାଲି ଆଣିବା ପାଇଁ କହୁଛନ୍ତି
ପରଦିନ
ପରଦିନ କଣ
it has been adjourned up to 22nd in court below.
ଶୁଣ ଆପଣଙ୍କର ଏଇଟା ଷ୍ଟେ ହବନି ଏଇଟା ଆପଣ ଲାଷ୍ଟ ଅର୍ଡରଟା ଦେଖନ୍ତୁ
Then list it in 22nd my lord. Order.
ଆପଣ 95 ଥର ଆପିୟର କଲା ପରେ ଚାହୁଁଛନ୍ତି ଟ୍ରାନ୍ସଫର କରିବା ପାଇଁ ବୁଝିପାରୁନାହାନ୍ତି ଓଡିଆ ବୁଝିପାରୁନାହାନ୍ତି
My lord.
ଦେଖୁନାହାନ୍ତି ଅର୍ଡରଟା 14/5 ଅର୍ଡରଟା ଦେଖନ୍ତୁ ଲର୍ଡେଡ ଜଜ୍ ଫାର୍ଷ୍ଟ ଆଡିଶନାଲ ସିନିୟର ସିଭିଲ ଜଜ୍ ବ୍ରହ୍ମପୁର ଦେଖନ୍ତୁ
Hmm. 22nd up to 22nd it will be adjourned.
So why to keep it pending? It can be disposed of.
My lord, the expeditious disposal means each and every day they will fix it up and
expeditious କରିହବନି
there is written it required the expeditious disposal but it will be hardship to us. Hardship to the petition because each
କଣ ହେଲେ hardship ହବ expeditious ହେଲେ hardship ହବ ନା slow ହେଲେ hardship ହବ
expeditious ହେଲେ
କେମିତି ମୁଁ କହିବି ଆଜ୍ଞା
ଜଲ୍ଦି
ଗୋଟେ expeditious disposal of litigation I will observe that it had
My lord,
hardship
I am the defendant in the court.
ଆପଣ 95 ଥର appear କରିଛନ୍ତି ପରା
My lord, court below I am the
ଆପଣ
defendant.
95 ଥର appear କଲା ପରେ କେବେ ଟ୍ରାନ୍ସଫର କରିବେ
Transfer my lord, she is facing this kidney patient and orthopedic.
ସେଟା ହବନି ଆପଣଙ୍କର କିଡନୀ ଯୋଉ କହିଥିଲେ ଆପଣଙ୍କର ବର୍ତ୍ତମାନ କହିଲେଣି ଆଣ୍ଠୁ ଗଣ୍ଠି ବାତ ହଉଛି ତେଣୁ ସେଇଟା ଆପଣଙ୍କର 95 ଥର ପରେ ଯଦି ଏଟା ହେଲା କୋର୍ଟ ସେଟା କିଛି କରିପାରିବେନି the trial will be frustrated you must understand ଆମର ମୋଟୋ ହଉଛି to dispose of matters
My lord,
expeditious
my lord.
ଆପଣ କହୁଛନ୍ତି expeditious ହେଲେ ଆମକୁ ଅସୁବିଧା ହଉଛି
Each and every day
ଜଲ୍ଦି
ଜଲ୍ଦି ଡେଟ୍ ପକେଇବେ ଯିବାଟା ଅସୁବିଧା ହବ
ଯୋଉ ଦିନ ସାକ୍ଷୀ ଦେବେ ସେଦିନ ଯିବେ ଅନ୍ୟ ଦିନ ଯିବେନି
My lord, ସେଟା
ଆପଣ ପଢିଲେ ଫ୍ଲାଗ ବି ରେ ପଢିଲେ ଏଟା ଟୁମୋରୋ ଫ୍ରେଶ ଆଡମିଶନ କରିଦିଅନ୍ତୁ ହେଲା କାଲି 26 ଟାକୁ କାଲି ଫ୍ରେଶ ଆଡମିଶନ ନେଇ ଆସୁ ବସ୍ ସେଟା କିଛି ଅର୍ଡର ଲେଖନ୍ତୁ ଦେଖିଲେ ଅସୁବିଧା ହବ ଫେରେ ପୋଷ୍ଟିଂ ହେଇପାରିବ ଆପଣ 22 ମାନେ ପରଦିନ ଚାହୁଁଛନ୍ତି
ହଁ